Well, we're a small group, but that's good because there'll be plenty of chance for question and answer, and I think we can be able to go into a lot of detail. We've got a really good day planned for you. Maybe, I don't know how many of you have seen this, but maybe over lunchtime we can put on this streaming video of a Washington State Supreme Court case. It was just March the 15th for oral argument. And there's a couple of really good attorneys representing the borrowers, and there's one good attorney who's very uninformed representing MERS and some of the other parties. So has anybody seen this video yet? Okay, then what we'll do is when we have a lunch break, we'll start it then, and or maybe we'll see if you want to go out and grab some food. I think we have an hour and a half for lunch, so if you want to grab some food and come back, we'll figure out the best way to do it. Maybe we can play it twice, something like that. And so, can I borrow these? Okay, I just want to, rather than turn my neck every 2 seconds, it's probably going to be better for me to really work off of these notes that we have here. And you heard a couple of songs. I always believe in being able to enjoy what we're doing. And one of the things that we want to discuss is who will benefit from this course, because there are a lot of people that, different groups, probably at least as many as, there's at least 7 groups who will benefit from this course on mortgage litigation and bankruptcy. And so, any attorneys that are practicing bankruptcy? Do we have any attorneys that are practicing bankruptcy? 1, 2. Do we have any paralegals working with at least one more? Okay, well, I think you'll definitely benefit from this course. And then also, any attorneys that are practicing bankruptcy, but maybe you're not really challenging mortgage. You're just doing the traditional 7, 13, maybe the occasional 11. Well, this can be a whole new field that you can come into. And by the same token, any attorneys that are, say, not doing bankruptcy, but they're in mortgage, they're just doing general litigation, there's a real opportunity through the evidentiary hearing and also the adversarial proceeding for litigating attorneys to partner up with bankruptcy attorneys, and it makes a very powerful package to help the homeowner. And in addition to that, and it kind of works both ways. The bankruptcy attorneys can partner with the litigating attorneys can partner up with the bankruptcy attorneys. Then obviously, any homeowners, whether it's personal homeowners or whether it may be investors, you're going to gain a lot of knowledge here that will help you. Do we have any realtors here this morning? 1, 2, 3, 4, 5. Okay, 5 or 6 realtors. That's great, because this is going to really help you. It's going to give you the cutting edge on how to advise your clients. They say knowledge is power. I guess if it's, and hopefully good knowledge used well is good power, not bad power, because we have enough bad power as it is. And then there may be people that are just simply friends of homeowners and members of the general public who want to, anybody that's here, maybe just as a homeowner, not an attorney, not a realtor, not a mortgage person, whatever. We have 1, 2, maybe some others here. So this course is going to be good for you, and then of course it'll be good for paralegals, secretaries, legal assistants who work with any of the attorneys above. And then, how many mortgage auditors do we have here today? 1, 2, I know we got a couple in the back there, I think. So this course will help you see how your work is really the linchpin in many cases for these homeowners to actually be able to prevail in this case, in this kind of work. Now, typically in business and in law practice, sometimes there's a lot of competition, and people talk about market share, and people want to be very secretive of their clients, and all attorneys cringe when they write a great brief and they have to file it, because then it becomes public record. All your expertise and knowledge gets shared by the world. And so but really in this particular field of law, the rules are changed. This is not about competition and market share. This is about cooperation and collaboration. And the reason I say that is because the market is so huge. And it's not just the people in foreclosure, which is maybe a couple of million a year. There's anywhere from 11 to 17 million people that are significantly upside down. You know, they may be current on their mortgage, but nonetheless, you know, they may have a $500,000 mortgage on a home that's now worth $200,000. So are they really going to continue to, you know, I mean, those values are never going to come back. You know, in the beginning, when this all started happening 4 or 5 years ago, people thought, oh, in 5 years, 10 years, 20 years. Now people are saying never. The only way these values would come back is if the U.S. dollar becomes so deflated that butter is $40 a pound, kind of like it was in Germany before the Second World War. Then you're going to see houses at $500,000 and $1 million again. But in today's market, that's just not going to happen. So this really is about collaboration and cooperation. So I encourage all of you to network, exchange business cards, get to know people. You may have a client that shows up in your path who needs an attorney or needs a broker or a mortgage person in some other area that you could meet here. So again, it's about cooperation and collaboration so everybody can win, clients and attorneys alike. I'm originally from Tennessee. I was actually an All-American in track and field in college. And since I'm no longer able to run that fast, I like to talk about it now, because instead of doing the running. And I was a graduate of the University of Texas Law School. I'm a member of the Texas Bar, and I have an extensive background in commercial real estate, finance, as well as residential real estate. And I've been involved in this mortgage crisis for about 4 years. And you know, just a little bit about my personal story. I kind of came into this like everybody else. I moved, actually I came to Vegas on a business trip. I was working with some people in Vegas. So I came out for 2 weeks in '04. And I liked the weather, and I liked the national parks, and I liked the neon on the strip and everything else. And I was living in Michigan, and so my 2-week visit has turned into 8 years. And by the time I bought my second house, I said, you know, I think I've moved. And I still had a house in Michigan, which fortunately I was able to sell. But like so many people, in 2004, I bought a house for about $600,000. And I thought it was really a bargain, given where prices were. And sure enough, about 2 years later, from '04 to '06, the house was worth between $750,000 and $800,000. And today it would be very difficult to sell that house for $300,000. And so that's, you know, I was probably 1 day away from signing a lease on a rental property, and I was just going to do a strategic default. And, you know, I said, I'll never pay this mortgage off. It doesn't make any sense. The values are, you know, if I paid it off, I'm paying, you know, 2 or 3 times what it's worth. And for some reason, it just occurred to me that I really should just stay in the house. And so this is back in '07, '08, and I just started educating myself about this. You know, everybody was saying, where's the note? That's kind of how this all started. And little by little, and you know, I just started helping people. And since my law license is in Texas, I always work with licensed attorneys in Las Vegas or wherever. And I've actually been in coaching relationships with attorneys in about 12 states. And then I put my experience on paper late last year, and I wrote a book called Solve My Mortgage Mess Now. And that's a copy of the book. And you know, we're not really furnishing a book for this course. It's mainly going to be lecture and PowerPoint, but if you wanted a textbook for the course, I would say this book is it. Almost everything we talk about here is going to be contained in this book. And the nice thing about the book is that it's written not just for attorneys and not just for consumers. It's written really to cover both. It has a lot of good strategy in it, but it's not so technical that the consumer cannot understand it. And you know, if you're an attorney, it's a great marketing piece and a great education piece. And that's the whole point, is that because we've never had an event like this to occur in our economy or our society, it's never been taught in college. So, 4 years ago, there weren't any lawyers doing foreclosure defense. I mean, nobody had ever studied it or anything. And so, if you have, and that's the problem today, only about 2% of foreclosures ever get challenged. Because the homeowner just doesn't know. He figures, well, I borrowed the money, I can't make the payment, I guess I have to give up my house. He doesn't understand that there's a very good chance that even though he may not have made a payment in 2 years, it's very likely that the investors that put up the money have never missed receiving a monthly payment. You say, well, how can that be? Well, all these loans were insured, they were the mortgage-backed securities trust were over-collateralized, and so it's possible that he's not in default. And so there's a great need for education for people to find out what their options are. It's not always a matter of just giving up your home and starting over. And so we're going to, as Tiare mentioned, we're going to have a drawing, I think a couple of books right before the lunch break, and then a couple of books at the end of the session. So make sure that your business card or some piece of paper is out there in that little fishbowl that we have, and we'll, hopefully you'll be the one to win. How many people bought a lottery ticket? The 640 million. Well, one person did. Okay, one person did, and I guess there were 3 winners last night. I don't really play the lottery myself. But I have some dogs, and where I go to the dog park, one guy said, I'm going to go to California and buy some tickets. I gave him $2. And so I did not check it last night. I wasn't that excited. I checked it this morning, and sure enough, but I was happy that my $2 helped to make at least 3 other people happy. So, that's okay, I guess. Now, along with me is Aaron Gupta. Aaron is a very trusted colleague. I've set up here now Aaron is originally from India, and he has a bachelor's degree in electrical engineering, so he can fix anything that you need, or he knows somebody that will. And in addition to that, he has a master's in computer science from the State University of New York in Binghamton. And not only that, he has a law degree from UNLV, and he's a member of the Nevada State Bar, and he operates a law practice here in Las Vegas. He not only does the 7 and 13, but he also does 11, so he does the full gamut. I'll have to correct that slide. And Aaron has represented a number of clients in bankruptcy where we challenge the mortgage. I work with a local Nevada attorney here, and then we together, who's primarily a general practitioner litigator, and then Aaron is the expert in bankruptcy. So that's a good example of this kind of partnership arrangement. Bankruptcy attorneys are really good at bankruptcy, litigators are really good at litigators. Sometimes they can do both, but there's a great opportunity for partnership to join together. And so Aaron will be speaking later on this morning about some of the ins and outs of bankruptcy. And the other person that's going to join us after lunch is Charles Powell. And Charles is originally from Minnesota. His law degree is from the University of North Dakota. He's a member of the Minnesota Bar. He has about 25 years litigation experience. He really is a great litigator. And I think he recites the rules of evidence at night in his sleep. We don't have any tape recordings to verify that, but Charles is just really good, and you'll find as we go through that the rules of evidence are kind of a heart and soul of this business, because who can prove what? That's the key to this. And so Charles has worked in both civil court and bankruptcy court, and he's one of the most knowledgeable attorneys that you'll find anywhere in this particular field of practice. Now, I want to shift gears here a little bit and just talk about the current state of the mortgage crisis. And I guess I'm just going to turn my chair around a little bit. It's going to flow a little better, I think, if I do that. And foreclosures actually climbed in January. These numbers were taken from CNN Money, February the 16th, 2012. And in the month of January, 1 out of every 624 homes in America got hit with some kind of a foreclosure filing. That was a total of 211,000 homes just in the month of January alone. So if you multiply that by 12 months, then we're looking at, if that continues at that rate, we're looking at maybe 2.5 million foreclosures. I don't know if it may be closer to 2 million, but it's definitely on the rise. And so there are more foreclosures that are set to come. What that means for you as an attorney or a paralegal, it's a great opportunity if you're willing to serve people. And this is a new game. Like I said earlier, this has never been taught in law school. So you're very wise to come here and get yourself educated. Because like I said, only 2% of foreclosures get challenged, but probably 98% could be overturned if the homeowner or the investor had someone to work with who understood this and could represent them well. So let's look at some of the numbers. Foreclosures actually declined a little bit in 2011 from 2010, and the reason, one of the biggest reasons, was because that's when the robo-signing fiasco hit. And so that just threw the brakes on the big lenders. That they couldn't, they were subject to fines and penalties and sanctions, and Linda Green was big news. I'm sure you've heard of Linda Green. She was vice president of about 60 different lenders at the same time, and had about a dozen varieties of her signature. And you probably saw the 60 Minutes piece where the young man was working at DocX making $10 an hour, and he was signing Linda Green's name 1,000 times a day, 500 before lunch and 500 after lunch. And so, that's the kind of due diligence they were putting on these documents. The other thing that is going to speed up foreclosures is the fact that you probably are aware that all 50 attorney generals were suing the lenders, and it's my opinion that unfortunately they caved. But, we live in a situation where it's not just justice only, it's also politics. And even though we may not be able to prove influence and corruption in every case, we'd be naive to say that it doesn't happen. And so, the bank settlement, the lenders are past that now because it's been settled. There's not going to be a trial. Nobody's going to be going to jail. And so that's going to tend to speed things up. Florida is already up 14% this year, 2012, compared to 2011. And Nevada is still #1 for the last 61 months consecutive. That's over 5 years that Nevada has been #1. And Nevada, for the month of January, was 1 house out of every 198 houses. In California, we had 52,000 notices of default filed in January. And so the numbers for California were 1 out of every 265 homes. Arizona was in 3rd place. Sounds like a horse race. 1 out of 325 homes. And Georgia was in 4th place, barely being edged out by Arizona. Georgia was 1 out of every 328 homes. Now let's look at some of the metropolitan areas. And I guess before I go any further, I need to really give you a little layout of the course, how we're going to do this, just so you can kind of anticipate. We're going to talk about the current state of the mortgage crisis today, and then we're going to next talk a little bit about how civil litigation and some reasons why civil litigation hasn't always worked. And then Aaron is going to join me, and we're going to talk about why bankruptcy is the forum of choice. And we're going to talk about all the different aspects of bankruptcy, and that'll kind of bring us up to lunch. And then after lunch, we're going to talk about the evidentiary hearing and the adversarial proceeding and evidence and finding what we need to win. That's going to happen after lunch. And then kind of the 4th segment is going to talk a little bit about the Uniform Commercial Code, Article 3 and Article 9, and some of the other aspects. So we've kind of got history and current events, #1. #2, some of the practicalities of bankruptcy. #3, the evidence and adversarial proceedings within bankruptcy, and then number 4, kind of closing out with UCC and where do we go from here. So California had 9 out of the top 10 hardest hit metropolitan areas for foreclosure activity and filings. Only Las Vegas was the only other city in the top 10. Las Vegas was number 5. There's massive opportunities really all over the nation. And you know, you may be busy where you are, but you also may want to think about expanding your horizons and be, you know, pro hoc vice or co-counsel, or you may have friends, you know, maybe you grew up in Cleveland, then you moved to California 10 years ago, so you may have friends all over the country, so there's opportunity to help people everywhere. Now let's talk a little bit about this $26 billion settlement by the 50 attorney generals. The way we score that is 1 for the banks and 0 for the public, unfortunately. And we've had the largest consumer fraud settlement ever, and it accomplishes very little. It's all sizzle with no steak. 5 banks with a market capitalization of over $500 billion, and they're only putting $5 billion into this settlement of their own money. That's less than 1%. The other $21 billion is they allocated $3 billion for refinancing and $18 billion for principal reductions, maybe. You know, they're talking principal reductions, but none of us have. How many people have seen a principal reduction that actually happened? 1, 2, 3, 4. Okay, good.
I've seen arrearages lopped off the top on a lot of them.
Exactly, yeah.
It's a kind of principle.
Exactly. It's sort of like having hors d'oeuvre, but no dinner, you know. So now, there's over 11 million or more homes that are underwater. So if we take this 26 billion and divide it by 11 million, that means the average benefit for the homeowner is kind of like 1 month's mortgage payment, $23.63. Thank you very much. And but we know, especially in California, Nevada, Arizona, maybe Florida, that people are, you know, they're underwater by hundreds of thousands. I mean, in Clark County here, we've seen 50 to 60% decline in values of houses that were anywhere from $500,000 to $1 million. Lots of people have a $500,000 mortgage on a house that's now worth $200,000. And the opportunity here in Vegas, see, there's 800,000 houses here, just in Clark County. 80% of them are underwater. That's about 640,000 houses that are underwater. And they're underwater by probably half. So, and the people, many of them are still current, still making payments, but, you know, a lot of law firms are saying, hey, let us short sell your property and you can start over. Well, that's one approach, but, you know, what about the truth? What about justice? What about the $100,000 down that you put on that home? What about the 4 and 5 years of monthly payments you've made? So it may be an option, but I don't see it as really the best option. We've lost over $700 billion in equity nationally, and that's interesting. That's just about the amount of the bailout money. If the bailout money would have went to the homeowners, you know, we'd have been a little bit better off. And this settlement does not really address, you know, what we call the shadow inventory. The lenders that are foreclosed on many more homes that are actually on the market. If they put them all on the market now, there would be no market. So there's a total of $394 million of fines on these group of lenders that have over $500 billion with a B in assets. And so nobody's going to jail. So there's no reason to think that anything is really going to change. You know, this is like leaving a small tip at lunch for these lenders, the group of them, to put up $394 million. It's like nothing. So the lessons that we learned from this settlement is that corruption exists at all levels, whether it's an executive like Frederick Raines taking a $100 million bonus after running Freddie Mac into the ground, or whether it's a robo-signer making $10 an hour. The corruption goes all the way to the top, all the way down to the bottom. And so the rule of law in our justice system is the last remaining frontier to keep this corruption from taking over our nation, our finances, our monetary system. So we really need an army of lawyers who are not just doing their job, but they really feel a passion and a call. And you may not be a lawyer, but there's ways that you can be involved. And you can find a lawyer. If you understand this, find a lawyer who's open to it, and go work with them as a paralegal if need be. Just there's lots of ways you can be involved, or just tell people about it. Now here's a Shakespearean quote. This is from Sarah Bloom Raskin. She's a Federal Reserve Board Governor, and this was in her keynote address on mortgage servicing that was given to the American Association of Law School in their annual meeting this past January. And this is a quote from Shakespeare where she says, "We must not make a scarecrow of the law, setting it up to scare birds of prey, and letting it keep such a familiar shape that it becomes their perch and not their terror." And that's kind of what's been happening with, a lot of judges say, you're living in the house, you're not making your payment, you're out of here. They're not really looking at what's really going on with the rule of law and with the rule of real estate and documentation and chain of title and everything else. So what was meant to be a scarecrow, the law, to scare away birds of prey, can become their perch, and for the lenders. And we look at this Attorney General settlement. Nobody's going to jail. $394 million when you've got $500 billion? Oh, yeah, chump change. Let's just keep doing this. Now, she goes on to say that this wave of foreclosures is hindering our economy because actually 65% of Americans own their own houses. And see, housing drives everything. When there's new construction, there's about 22 trades, the plumber, the heating, the insulation, the painting, the drywall, the landscape, the framing, the roofer, on and on and on. There's about 22 different trades, 22 different businesses that get employed in every house that gets built. And when the homeowner buys a new house, the average homeowner will spend at least somewhere between $10,000 and $20,000 on new furniture, new drapes, decorating, a pool, landscaping, or whatever. It's all that secondary and tertiary expenses related to housing that drives our market. But when you've got 2/3 of our houses and underwater, we've lost over $7 trillion of equity in the last 5 years. And so people are just skittish about, they're not going to go out and buy new furniture. They're not going to put in the pool, typically, in those kind of situations. So any kind of recovery is going to be a long time coming. Now, in Chicago, foreclosures were down about 16%, but Cook County was up 14%, and home prices are predicted to drop another 3.5% by June. Prices are still 35% below the 2006 prices. And Northwestern and University of Chicago did a study, and they said 34% of the foreclosures are strategic foreclosures by underwater homeowners. The REO inventories are increasing, and sales at the auctions are increasing as well. In the New York area, they're just getting ready to introduce a new program to give more ability to judges to modify loans for homeowners. The 4 major banks have agreed to cooperate by sending persons with authority to alter loans to the court settlement conferences. Those are B of A, Wells Fargo, Chase, and Citi. But we all know that those are really the servicers. They're alleging to have authority, but if they don't own the debt, this is just one more cloud in the title. So this program is going to start in Queens, and then it's going to spread like a virus to the rest of the metropolitan area. And out of the $26 billion, New York is supposed to get $136 million. It's like the number's not nearly big enough. So let's look at Florida. Because of the economy, the Florida legislature has cut the court clerk's budget by 7%. So cases are going to move much slower in Florida. Palm Beach is set to lose 55 jobs in their, Palm Beach County to lose 55 jobs by a $2.5 million cut. Now, the one good news, how many of you are familiar with Lynn Sismoniak? You need to really Google her because she is a lawyer. I don't know that she was practicing at the time, but then she got a notice of default. This is probably 3 years ago. She's written some things, some letters, but she just recently won $18 million in a settlement with Deutsche Bank. And it all turned over the fact that the signatures on the documents that she was given with in the foreclosure case did not match the signatures of record.
She was the 60-minute thing, that lady that...
Yeah, she's been on 60 Minutes. I mean, her name has been around, and she had this ongoing lawsuit, and I just read this recently, that I guess Deutsche Bank did not want to litigate because then it becomes a precedent. So there was a settlement, but she got $18 million.
Was that a class action?
No, it was not. And so pardon?
Single client?
Yes. Well, that's my understanding. There was no mention of it being a class action, and I know she had a personal suit, so I'm pretty sure it was. But, so if any of your homeowners need hope, Lynn Sismoniak. Now granted, she's an attorney. She was kind of on top of this. But anyway, there's, she got, I don't know who got the most, her or the lottery people. But anyway, Lynn did real well from the time she put in over the last 3 years.
And I heard she's in hiding.
Yeah, I don't know. She probably is in hiding, and she can afford to be. She can afford to hire good security now. So you all heard about the David Stern law firm that got shut down in Florida, and some of his and he had to fire everybody like overnight. So a group of his attorneys, a group of his employees, filed a class action suit against him, and as it turned out, they each got $469, not much time, because they weren't given their 2 weeks notice that, the Justice Department came in and just shut his business down overnight. Now, how many people are from Nevada? Show of hands. 1, 2, 3. Okay. We have the foreclosure mediation program, which can help. The lender's documents are many times not in order because they're missing assignments and things. And then also Assembly Bill 284 has made the rules of foreclosure, it's requiring them to be much more strictly followed by the foreclosing entity. Now, in the mediation program, there's about 16 steps to make that work. First, you have to receive a notice of default. Well, actually, I guess you have to default. You have to miss a couple of 2 or 3 months of payments. Then you'll receive a notice of default. And along with the notice of default, you'll get an application for mediation. And a lot of people in the beginning were just blowing this off because not much was happening. But I think it's actually very valuable. It may not be the final solution, but it's certainly a good temporary solution to keep people in their homes. They fill out this application. They send in. You have 30 days from the time of the notice of default. So it is time urgent. You have to respond to that pretty quickly. So within that first 30 days, you've got to get your paperwork filled out and a check for $200, and you send it into the foreclosure mediation program. And then the trustee is noticed. The lender also pays $200, and I guess that $400 goes to the program and to the mediator. So the trustee then notices the lender, a mediator is appointed, and the mediator contacts everybody. He schedules a mediation hearing. Everybody exchanges their documents. And then the actual mediation is held, and then a statement by this mediator is sent to the foreclosure mediation program. And if the lender's documents are in order, then they can proceed with a foreclosure. If they're not in order, they cannot proceed. And often it's the case that they're not in order. I went through a mediation myself, and Bank of America was missing an assignment, no foreclosure certificate. So. And then after that, you have 15 days for judicial review, so there is an appeal process. And in the judicial review, you can challenge maybe bad faith, and you can also ask for sanctions. So that's just a little summary of the mediation program. And then Nevada Assembly Bill 284, this was passed May 20th under current Governor Sandoval. So 90 days after a deficiency, you get a notice of default. But now there has to be a notarized affidavit of authority to foreclose. And so if you sign a notarized affidavit and you're not telling the truth, that can be forgery and that can be fraud. So you must give the full and name and address of all the current and former beneficiaries. The lender has to do that. They have to state the amount of all deficiencies and penalties and cost of foreclosure. They have to prove that the foreclosing parties have the right to foreclose. And in the first 3 weeks of September, there were 1,985, this is right before this law went into effect, there were 1,985 notices of default issued. Right after the bill went into effect, there were only 56 notices of default. So this really put the brakes on the lenders, requiring them to have their documentation in order. And some realtors claim that this will slow up the recovery of real estate, which is probably true from their perspective. Their perspective is get the people out of the houses, get the house sold, and let's move on. But that's a lot of damage to a lot of human beings if that's the case. So what this is going to do is allow the homeowners to stay in their homes longer and to save up money to wage the fight against their alleged lender. Every assignment of a deed of trust, every substitution of trustee must be recorded. And if these documents are not in order, there's a felony violation which of either $5,000 or 3 times actual damage as a fine, with jail time of 3 to 20 years plus attorney fees. And the sale is enjoined if the documents are not in order. So there's some real teeth in this Assembly Bill 284 for everyone in Nevada. Now, I don't know if I'll take the time to do this. I have about a 9-minute video from a realtor who's basically saying the same thing. But in his case, he just says that this is going to, slow up the recovery. The houses can't get cleared, so maybe we won't take the time to look at that. You should be aware of there's always, anytime there's an economic opportunity, like there's a great opportunity for us to help people. So anytime there's a great opportunity, you always kind of have the birds of prey around also. And so there have been some scams around, and it's not to say that the idea was wrong, but it's the way the idea was carried out. I mean, you can say the same thing about mortgage securitization. Mortgage securitization, if it's done properly, is a wonderful thing. It allows the pooling of money. It allows so that more money is available for mortgages. It diversifies risk. So there are a lot of good attributes about mortgage securitization which are good. But the point of it is that when the rules of securitization are not followed, when it's abused, when it's carried out poorly, then it becomes a problem and a threat to people. And it's the same thing. There was a group out of Georgia called Bella Homes, and what they were doing was they were contacting homeowners, and they would have the homeowner deed over the home to them, and then they said that they were going to go buy the note from the lender, and then they would lease the home back to the homeowner. Homeowner would pay rent for 3 years, and then he could repurchase his own house at current market value at that time, and they were going to get a credit for 60% of the rent they paid. So in theory, that it's not the total solution, but most homeowners don't necessarily want a free and clear house. They're happy just to get a market resolution, something they can live with. And so that's what Bella was kind of offering people, was a market resolution. So I think they collected a few $1 million, and they were working in, I don't know, maybe 40 states. And turns out that they collected all this money. The homeowners were paying first month's rent, last month's rent, security deposit, maybe like $5,000. And then they were making monthly rent payments. Bella Homes never bought one note. They never recorded one deed. They just, educated their program and collected the money. So maybe it was a good idea. I don't know. I don't have an opinion on the idea one way or the other. But the point of it is they carried it out wrong. They were just grabbing the money.
It's a good idea if you have cash to buy the house.
Yeah, that supposedly they were with some hedge fund and they had big investors and all this kind of stuff. They were going to buy the notes, but they didn't carry through on it. And then the same thing I think can be said with in California what was called the mass joiner cases. Philip Kramer had the highest AV rating for proficiency and ethics both, but he kind of lost control of the marketing, and so he had non-lawyers sending out letters and answering the phone law office, etc. And I think his complaint was a very good complaint against the 6 major lenders. But there's a lot of influence from Bank of America and Wells Fargo in the state of California. They probably put pressure on the Attorney General to shut him down. So he got shut down, and then other people were copycatting, and I guess this person, I don't know much about this person, Samir Lakhani of the Precision Law Center. He had several companies, Fidelity Legal, Titanium Realty, Credit Shop. They were shut down and I guess what he was doing was taking money from the consumers for the lawsuit. He filed the lawsuits, but then he never followed through on the lawsuit. Didn't do any motion, didn't do any discovery, same kind of thing. Probably a decent idea, but just executed poorly. So you can be aware of those 2 situations. Now, at this point, let's hear from you. We've got a microphone that we can pass around here, and what I'd like to do is just tell us where you're from and what your profession is. And if you have any interesting news that will benefit the group, or if you have any success stories or abuses by the court, and then maybe how would you characterize the mood of the court in your area? Sophia will help us out with that. So, and I mean, if nobody has anything to say, that's okay, but I just wanted to offer the opportunity because you may know of something in your area that would be of benefit to everyone else. So if you have something to share with us, just raise your hand, give us your name and where you're from, and what, are you an attorney, or are you an investor, or you're a realtor? Tell us what your work is. And okay, right over here. Go ahead, Sophia. Oh, I'm sorry, you're going to talk. Yeah.
Hello?
Push it up, it should go.
Hello?
Let me turn it up. Use this one for a little bit in the meantime.
Hi, my name is Sophia Monteroso. I have been self-employed for over 13 years, graphic designer, illustrator, technical editor, working for the government as a contractor. And I am a homeowner, and I went through a divorce, and I got hit by a car. And so I looked into a modification, and I was told by Wells Fargo that I'd be given the modification, and they gave me the, spiel for months and months, and I sent all my paperwork in, and never got the modification. And I have gone through a few lawyers trying to claim bankruptcy, and I have now claimed 4 times without being able to get anywhere with my lawyers. So my last motion, I just filed on my own. And I am looking for an attorney who will be able to litigate for me and I am finding in California, it's very difficult because there's no precedence, but I'm also finding that the judge and the trustee, they are wanting to work with me and see me go forward. So that's where I'm at.
Great. See if that microphone works now.
Where
Where
are
are
you
you
from?
located?
Where's your property?
San Diego. San Diego, California, Ocean Beach.
Check.
Mic check, mic check. Low, mic check, okay. Anybody else want to?
Yeah.
I'm a San Diego attorney.
Oh, well, good. That's what Sophia needs. Great.
You want me to just sit here?
You can just, yeah, just you can use that microphone
Yeah.
and just tell us your name, where you're from, what you do, and then whatever you want to share with us.
Yeah, my name's Diane Beal, and I am licensed to practice in New York, where I started off, and then went out to California about 35 years ago, and I'm also licensed in Washington. Those are not licensed, but bar cards. Yeah, those are where my bar cards are, is New York, California, and Washington State. So about 4 years ago, this doesn't sound, is this okay? About 4 years ago. Okay.
Yeah, just hold it close.
Okay, about 4 years ago, my daughter was selling prepaid legal, and she called me the day after Christmas and said, "Mom, I'm with some people. They called me. They want prepaid legal, but they have a hearing the day after New Year's, and they're being evicted from their home. And it's a mom and a dad and 2 children, and the parents that have spent every bit of their savings to buy, to get a permit to build a grandparents' home in the back. Do you think you could help them, Mom? I'm buying them dinner right now because they don't have any money." I mean, would I do that for anybody but my daughter? And it's like Christmas and New Year's. And so anyway, I went over there, and that was my first case. And I went into their unlawful detainer court, and I didn't know anything about, it was like, well, show me the note. I mean, how can you be evicting these people if you don't know, if you don't have the note? And fortunately, the judge sent us out to negotiate, myself, and it turned out to be a special appearance attorney who was assigned to the case, who knew less than I do, praise God. And he gave me 3.5 months for this couple, which is now unheard of. But anyway, that was my beginning, and since then I went to a lot of seminars. Michael Pines, he was doing like lots of training classes, and there was another lady from Florida.
Closer to your mouth.
I'm sorry, April Charney, and different attorneys that were training. So I've been trying to be trained in the last 4 years to do this. I also have a house up in Lake Elsinore, although I live in San Diego, a house in Lake Elsinore that I was renting out, and they started foreclosing, so I thought I'd do a test case on that. And 2 years later, I still have it. Actually, it's almost 3 years, but what I did is I tried the civil litigation and found it very difficult to get the temporary restraining order. We can get the temporary restraining order, but then the preliminary injunction, you get problems because you have to pay a bond, and then they also want tender. So those are the 2 issues you have to overcome with civil litigation. So then I turned to bankruptcy. And so I was doing Chapter 13s for other people and myself, and then they want you to do not only you have to work out something where you pay your arrearages over a 3 to 5 year period, but also to make post-petition payments. So I did a motion to stay post-petition payments pending my adversary proceeding litigation on grounds that I didn't want to pay somebody who's not entitled to payment. So when I did this motion to stay the post-petition payments, they got me dismissed for my refusal to do an accounting and hand over the rents that I was collecting to the court or to the trustee in bankruptcy, because I thought, well, Yes, anyway, that's about it. So the judge who did Salazar, which was a wonderful decision, is now rethinking that she's not getting the support. So I just think that the judges are all difficult to deal with, but I'm really excited about securitization audits, the Bloomberg audits, that we have the evidence to go in, and I'm here because I have hope and I want to do this, and I've got a passion for it.
Great, thank you so much.
Okay. Anybody else? Yes, sir.
Just quickly, I'll do it from back here. My name is David Otto, OTTO. I'm an attorney here in Las Vegas, Nevada. I've been doing real estate of one kind or another for 25 years in one way or another. I'm a litigator. in 2008, just to give you an example, I was in a funny little probate idea of a case where two brothers were fighting over mom's house. Just before the market tanked here, brother in Illinois said, I don't think $180,000 is enough for that house, so we refused the sale. Overnight, essentially, the house fell to about $80,000. So they were fighting over that issue. And when I went into court, I said to the judge in 2008, well, you know, the real estate market has fallen. And the judge said to me, yeah, but it's coming back up. So the courts have always seen it that way. Oh, this will recover. It always does. And consequently, they're finding any excuse they can to hang their hat on to support the lender. Add to that, the federal judiciary is, Nevada is a perfect example. It is almost uniformly Republican appointed. Consequently, they support the financial industry in almost any way they possibly can. It's just how they're trained from infancy. And the thing is, they either decide to kick everybody who's underwater in their house and doesn't want to pay anymore and can't pay anymore out of their house eventually, or they allow these securitization-type lawsuits to go forward. The bar, meaning the lawyers, I don't know how many of you are, the bar has been struggling to find a chink in the armor of the Republican bench and the financial industry fraudsters. Don't expect help from the state government. Don't expect help from the federal government. What it's going to take is the judges to change their minds.
Right.
It's that simple. Now, I want to litigate these things. I haven't filed one yet because I haven't found one I like, but I think I have one drafted up now. The plaintiff, my client, is going to have to ride on the risk with me and any other lawyer who does this.
Right.
There's no guarantee.
Okay, great. Thank you very much. Well, I think you're going to find that chink today. And I'm going to just try moving over here. Sophia, you can angle that as you need to. And the reason I want to do this because we've got a lot to cover, and some of this you're going to be familiar with, but it's important. So I want to move through it pretty quickly. And the reason I want to talk about how all of this came about, even though you may be familiar with it, but how this came about is also very important with how we solve it. In other words, if you don't know how the problem occurred, then you won't be able to solve the problem. You won't see how the solution fits in. So that's what we're going to do. So there's been 5 million, just one. Yeah. Okay. The basic causes in macro are greed, lack of regulation, and inappropriate money incentives were the culprits. And so we've had about 5 million foreclosures since 2007. We'll probably see 2 million more this year, at least 11 million homes underwater. The economy is in a problem, record job losses, corruption. Who's really in charge? Where's the social and moral fabric of decades past? This is all institutional wrongdoing, but it's personal suffering. It's the couple that's getting a divorce because of the financial pressure. It's the kids that are being yanked out of their school because mommy and daddy couldn't keep their house. It's the pets that are being left in the garage as the family moves to an apartment that doesn't take pets, and those pets starve for lack of water and lack of food. So it's the collateral social damage is huge. It's not just about the money. Is there a solution to the problems? For a long time, we've had as many as 600 houses being sold every day down at Nevada Legal News. If you just take that out, that's about 3,000 a week, 50 weeks, that's 150,000 houses a year. You figure 2.5 people per house. You're looking at something like 375,000 people a year being dispossessed. That's like the entire population of San Francisco, Tampa, St. Louis, Miami, Cincinnati, or Pittsburgh. It's similar in Stockton, California, and Phoenix, and elsewhere. So a lot of suffering, a lot of collateral damage, individuals, families, and even pets. Now, the borrower is slave to the lender, adjustable rate mortgages, option arms, inflated appraisals, crashing housing market. Was it just that we bought more house than we could afford, or was there something else going on? Let's take a closer look at what really happened. it wasn't just the homeowner, it was rather Wall Street made a concerted effort to push money at anyone who was willing to sign the necessary papers without regard to whether they were qualified or not, because when these notes get sold, they make so much money, sometimes over twice as much as the note itself, but they have to have that signature on the note. So this is basically predatory lending. Think about it. Did you ever hear of stated income, no documentation loans? And, you know, people said, well, okay, my initial mortgage payment's $2,000, and 2 years it goes to $4,000. How will I pay that? Don't worry, just refinance. That was always the stock answer. And so there was a well-coordinated effort in that came from Wall Street. So from 2001 to 2007, collateralized mortgage obligations, real estate mortgage investment conduits. These were packaged in mortgage-backed securities with, you know, billions of dollars sometimes in each trust, certainly hundreds of millions, if not billions. And so Wall Street collected all this money. Then they had to hire the national, you know, countrywide, Bank of America, IndyMac, Wells Fargo, Chase. They had to hire the lenders to go out and originate these loans, and then beyond the lenders, the mortgage brokers. And so the mortgage note was sold many times over, and the profits were so great, it was not unusual to have a $700,000 profit on a $300,000 loan, because it was fractionalized and it was sold, and then you had all the derivatives that were also sold against that collateral, and there's not really any, just like in a stock exchange, you have the price earnings ratio, and you can know what's being, the derivatives is all being done private for the most part. And so Wall Street really acted as if it was above the law. The business manager was close the deal, more volume, don't worry about the details, don't worry about laws being broken. So the hedge funds and other domestic and foreign investors, they had the money, and then they swapped that money for these certificates or bonds. And they weren't really buying mortgage notes, they were just buying a right to the stream of cash flow from those notes. So they took their cash and they gave it to the Wall Street firms that were selling the collateralized mortgage obligations, mortgage-backed securities, and they just took in more and more money. And as they collected all this money, and a lot of times in their prospectus they would say, we reserve the right to substitute collateral, so they wouldn't even have the houses in the pool yet, but they would, as they brought them in, then they would substitute them in. So they pushed the money out to the national lenders and loan servicers, who then pushed the money to the unwary borrower, and then he signed the note, but the note and the deed of trust were split. Typically the deed of trust stayed with MERS, and the note either went to a warehouse in Simi Valley, California, or it may have gotten delivered to New York. And so you had the loan poolers, the sponsors, the depositors. Catherine Porter, who's a law professor at Harvard, did a study. 40% of the mortgage notes were shredded and destroyed. So they aren't even around anymore. And so these mortgage-backed securities, by law, the trust cannot own the note. That's how they get the tax advantage of the real estate mortgage investment conduit. In other words, they're not taxed because of the RMIC status. And then the investors, the certificate holders, don't really own the note. They just have a right to the cash flow. Now, if a mortgage-backed trust violates its RMIC status, the tax is 100% and the penalty is 100%. So if you've got $1 billion in mortgages and you do something fraudulently and you lose your RMIC status, you're on the hook for $2 billion then. So that is one of our biggest leverages that we have in this whole fight. So there's no note and no legal standing by these national lenders who are doing all the foreclosing, but they don't really have standing because they don't own the note. Only the owner of the note has the right to foreclose. A lot of violations of federal and state laws, and the bottom line is don't let them steal your house. This is another diagram. Is most everybody pretty familiar with this background information? But well, if you're not, we're going to have a Q&A, so you ask questions, but I just want to make sure we get to the meat. I mean, everything we're doing now is kind of laying the foundation for the solutions that we're going to talk about later. But here you see the borrower. He was maybe working with a mortgage broker who was working with a lender, but the lender was not loaning their own money. That's why they didn't care if you were going to default. There's only two parties in every loan. You have the investor and you have the borrower. Everybody else is just a middleman taking a fee for a service. And so it's important to realize that. So the issuer here, you know, you have the trustee, you have the underwriter, you have the rating agency, and interesting, the Wall Street firms were writing the software for the rating agencies, go figure that. And then the credit enhancement was brought in, and then the investors were putting in the money to the issuer, and you had all these different parties over here. This diagram is actually from the Federal Reserve System. I think it's FDIC actually. And so the borrower obtains the loan, the lender sells the loan, but in most cases the loan was actually table funded. If the lender, it says lender, but it's really the originator, because lender is a deceptive word. When you say lender, you think they're putting their money in it. Many times it was just money that was table funded from New York, and if they ever did use their own money, they immediately sold that note and got their money back very quickly. And so the issuer sells securities to the investors, the servicer collects the monthly payments here. Now what we have, in many of these cases, it's the servicer that's foreclosing on the borrower. But the servicer doesn't have the servicer doesn't own that debt. Servicer never did own the debt. Servicer wasn't using his own money. He's just servicing it. So some of the primary issue for litigation is standing. Is the party trying to foreclose a party in interest? Who is the holder in due course? Were the transfers done correctly? And the answer is absolutely not in 98% of the cases, and we'll talk about that. Where is the unbroken chain of title? Are the endorsements and the allonges in proper order? A note has to be endorsed.
So you're saying I can ask this cat any question?
The cat is connected to the computer. You just type in the question, it will read his mind. There the answer comes.
You're the man! I've been looking for this for weeks.
Whereas a deed of trust is the note, of course, is the obligation. The deed of trust is the security. So the note has to be endorsed. The deed of trust, which is the security, has to be assigned. Are the assignments in proper order? And they have to be recorded also in the county where the property is located. Was there any fraud perpetrated? Now, as I mentioned, this whole area of law, since it's never happened, it was never taught in law school, so the judges don't understand it. In fact, we've had conversations about offering a course like this to the Federal College for Federal Judges up in Reno, and we're going to follow up on that. So in the beginning, since people couldn't find any attorneys to help them, you had lots of pro se litigants. Now in many cases, the pro se litigants who were filing their own lawsuits, they were right, but number one, they didn't know how to prove it. Number two, they didn't understand court procedure. So they kind of got the bench a little bit ticked off at them. And I think there were some education events held maybe by some of the big law firms that represent the lenders. And so the pro se litigants, you have to admire their courage, but in some ways they kind of bias the court against everybody. And that's one of the things we fear. We don't want a pro se litigant to take a case to the Supreme Court and get a bad decision and kind of wreck the party for everybody else. So that's what's important. So in the beginning, we knew we were right about all of this, but it was going to be difficult to prove it. And I have a 57-item request for discovery documents, for example, with 40 interrogatories, and those are things that I'll be happy to share with you. And but a lot of times we get stonewalled. And the interesting thing is the big law firms representing the lenders, in 9 times out of 10, they don't understand their own client's business. Those guys are litigators, and they don't understand mortgage securitization and all the moving pieces, and they kind of work off templates. There's a few big law firms that have kind of written some white papers that basically everybody's using kind of the same arguments, and we can talk more about that later. But there was kind of limited success in state court, and what happened was that I think we experienced the negative effect in the federal courts first. The federal courts, probably Republican orientation, like Mr. Otto was talking here, and they just took the approach that, well, you signed a contract, and if you didn't fulfill your contract, breach of contract, deed of trust, you're out of here. And they didn't really look to see if that deed of trust, if that contract was valid or not. And in most cases, it's not. So people started going to the state court, and we were working in civil court, in the state court, and having some pretty decent success, getting temporary restraining orders, getting preliminary injunctions. And then it was about October of 2010, we just saw a definite shift. And again, I can't prove this, but I would venture to say that there was some kind of a policy decision among the judiciary that they said basically, we're not going to decide any cases in favor of the borrowers. We're going to dismiss their cases, but we're going to tell them you've got a great case for appeal to the Supreme Court. And so basically the lower court, the district court in Nevada, was just passing the buck. Now why would they do that? Well, number one, in Clark County, if you have, as some people might say, influence on the court. We can't prove it, but we'd be naive to say that doesn't happen because the state court judges are elected and they all have campaign funds. But beyond that, if you have 600,000 houses underwater just in Clark County, and if they start deciding in favor of the borrower, you're gonna have such a floodgate open of litigation, and whichever judge does it, the other 35 judges are gonna not look at him very happily. Now, granted, they should be fulfilling their oath of office that they take, but they're human beings, and so what they said is, it's my opinion that what they said was, let's just not decide this here. Let's dismiss these cases. Let's send it to the Supreme Court. Let's let them decide, and then we'll just quote the precedent afterwards. Because we had judges where we had gotten TROs, we had gotten preliminary injunctions, and then the next thing we know, our case is being dismissed, and in every case they said, but you've got a great case for appeal. It's like they were baiting us. Please go take this up and get a decision, so we then have our marching orders what to do now. And I...
MERS's nominee, though. Didn't MERS's nominee have a lot to do with those decisions?
Every case is different. I mean, the nomineeship of MERS is a big item, but that's not necessarily the case altogether. I mean, it could have been, and that may have been the hook. They hung it on that hook, but I still think those other dynamics are in play at some level. That's 2010. So really now, we shifted, after we just saw we were getting stonewalled in the civil courts, we shifted over to the bankruptcy court, and a lot of that was probably looking and understanding the work of Max Gardner. Max Gardner is an attorney out of North Carolina. He's been doing boot camps for probably 6 years. And his information is very valuable. I've been to a couple of his events, and he has a whole team of people that he's very close with. He usually has about 12 speakers when he does an event, a major event. And people like Adam Levitin, if you know his name, or Tanya Twombly, some of the best minds academically in this field that are sensitive to consumers are tied in with Max. And so Max's work, so that's why we basically started looking at bankruptcy. Now, there are a lot of advantages to bankruptcy. Number one, you don't have to get a TRO and a preliminary injunction to stop the sale of the house. The stay is automatic. That's a big one right there. We've had some judges in the civil court where they wanted all of the arrearage posted as a bond, $17,000 to $20,000. And you're not going to find many bonding companies, so basically you got to put up the cash. So with bankruptcy court, though, there's no need for TRO, there's no need for a bond. And that's a big, and the stay is immediate. I mean, as soon as you file your papers, the stay is immediate. They cannot sell your house. The other thing that's very important is the bankruptcy judges understand debt. You know, debt is a kind of a complex field. There are a lot of moving parts. You've got the deed, you've got the promise, the obligation, you've got the security, you've got the documents, you've got the paperwork. And frankly, a lot of your civil court judges, they've never specialized in debt. And you start talking about a securitized mortgage, you're about 30,000 feet over their brainwaves. You know, they just look at you with a blank stare and kind of mumble something and then say dismiss. But the bankruptcy judges, they're intelligent and they're smart and they understand debt. And so that's why it's important. Now, the bankruptcy courts only raison d'etre. The only reason they exist is to help debtors. So there's a nice bias, if you will, from that standpoint. You know, whereas the civil court judges, you know, you're in the house, you're not making payments, out of here. That's their bias. The bankruptcy judges are, oh, you have a debt. Well, in bankruptcy, every debt has to be proven. Whether it's a credit card or a school loan or anything, the burden of proof is on the creditor. See, that's a huge advantage in the start, right there. And the bankruptcy judges don't have any problem, you know, stripping liens and writing. They do it all day long. Now, another advantage is that on a bankruptcy, if it's a personal bankruptcy, let's say you own, you know, 2 or 3 houses, well, you can put all of those properties into one bankruptcy case. You don't have to file 3 or 4 separate lawsuits. That gets real expensive for a homeowner or an investor. If an investor's got 5 properties, he has to file 5 lawsuits. That gets very expensive. So in a bankruptcy, you can put them all in one case. So it's more economical for the borrower. And the other thing that's critical, we have literally tons of good precedent in bankruptcy in favor of the borrower. We don't have that most of the time in our civil courts, but in bankruptcy we do, and because bankruptcy is federal, you can quote court case precedents from all over the country, California, Massachusetts, Alabama, wherever you want. So there's a wealth of precedent that's very helpful in the bankruptcy courts. Now, I'm going to kind of turn things over a little bit to my colleague Aaron Gupta. And Aaron, you want to stand up maybe over here? Is that going to be so you can see the screen? And you can use this microphone. And I'll let Aaron, and we'll kind of work together. And so let's welcome Aaron. He's a great guy.
Hi, my name is Arun Gupta. I solely practice bankruptcy and I do Chapter 7, 13 and out to Chapter 11 for businesses. And some of the people will not qualify for Chapter 13 because of the debt limits, so they can use Chapter 11 if they have multiple rental properties. And as Charles mentioned, bankruptcy is a forum of choice for several reasons. First of all, you don't have to go to the state court to try to get a restraining order or injunction. It's automatic as soon as you file the paperwork. So it saves all the hassle and all the cost associated with getting a restraining order. Second, as you said, the banks have to prove the debt. It's on the onus is on them. Instead of you trying to prove it's not valid, they have to prove it's valid. So it's a huge, huge advantage if you use the bankruptcy forum.
Sorry. That's the advantage.
And the way the bank can proceed with the foreclosure is they have to go to the court, file a motion to lift automatic stay. And that, again, is on your benefit, on the benefit of the debtor side. And as I mentioned, there are 3 possibilities, Chapter 7, Chapter 13, and Chapter 11. Chapter 7 probably would not be a good forum for these kind of cases because it's either give it all or take it all. So if you're behind a mortgage, you have to come current or you have to surrender the home. So Chapter 7 is basically a liquidation type of bankruptcy, will not be a good forum or good avenue for these kind of mortgage cases. So our choices are between Chapter 13 and Chapter 11. Chapter 13 has a debt limit which can be easily met if people have maybe 2 properties when they bought it at the high of the market. So if they have more than 2 properties or a huge debt, it's about $1 million sum for secured debt. So if you have that, then you can go to Chapter 11.
Aaron, one question. Even though there's a debt limit, if we list those mortgages as disputed debt, can't we remain under the debt limit?
You can, but I think it's better for the debtor to use Chapter 11.
Right, okay.
And as I mentioned, Chapter 7 is not a good forum, so we choose between 13 and 11 depending on the debt they have and what they're trying to litigate. Very quickly, we'll go over Chapter 7. It is simplest, easiest, cheapest, but the least flexible of all the choices. It's good for debtors who have very low income and they just want to get rid of it all. They can't afford any more debt, they just wipe it off. They don't have to repay the creditors back. And any non-exempt assets are liquidated to pay the debt that can be paid from there. What I mean by non-exempt is, by statute, every state has different exemptions. For example, in Nevada, we have a homestead exemption. We have certain exemptions for household goods, clothing, tools. So any assets which can be exempted are protected. Anything over and above is used to pay the creditors. Normally, as I mentioned, if you want to keep a property, if you are behind on a mortgage, you have to come up current. Otherwise, it will be surrendered in bankruptcy. There won't be any liability for any deficiency, but the secured creditor can take the property back. Chapter 13 is the next higher level up for debtors who have income left over after paying reasonable living expenses, which is called disposable income, and they can pay back some or all of it depending on how much is left over. Chapter 13 is like a payment plan where they take all your non-exempt disposable income and they can spread it over 3 to 5 years. The maximum period is 5 years. Secured loans can be paid or surrendered. In the case of mortgage debt, we list it as disputed until that issue is decided. If the court goes our way, then that debt is wiped off and that is not part of or not added to your debt. So you can pay the remaining amounts through the Chapter 13 plans. In this cases, we mention the secured mortgage loan as disputed.
Just one thing to mention on there, it's very critical that your mortgage be listed as a disputed debt, assuming you want to fight it, because if you list it as a secured debt, you just ratify the debt.
That is correct.
And that's an official document. So if you're going to challenge a mortgage, do not list it as a secured debt. List it as a disputed, either unsecured or disputed, and preferably disputed. We can take a couple questions, I guess.
So if you list it as on the secured debt and then put disputed?
Yes, that's right.
Okay, and then can you also list it on the unsecured?
Normally courts and trustees object to that. They said it's not unsecured until it's proven. So we always list it as disputed.
Okay.
If you can prove that they, in other words, if you did an audit, a securitization audit, and you can prove that it is indeed not theirs, doesn't that make it an unsecured?
That is correct.
Can you then?
Well, our goal is to make it go away altogether, not make it unsecured, because you have to pay part of the unsecured debt as part of your plan. So our goal is to make it go away altogether, if we can prove it.
If you list it as unsecured in a Chapter 7, you just say, I'm sorry, you list it as secured, but it's disputed, and then you get all your unsecured debt, and because 11 is over so fast, they don't bring a motion to stay, they don't do proof of claim. What's the status when it goes through the 7 as a disputed secured?
Chapter 7 is not flexible enough to allow it as a disputed debt. They will say either pay it off or just surrender it. So we can really take advantage of disputed debt in Chapter 7.
Except what about an adversary proceeding?
They won't allow that. It's simple liquidation kind of bankruptcy. They won't allow these kind of proceedings in Chapter 7.
You can't do an adversary?
No.
Because I know people who've opened it up and...
It's very hard to fight on those issues because once you file Chapter 7, it becomes involuntary petition and the trustee can take over whatever non-exempt assets are there.
So if somebody's gone through a 7, they can then go back and do a 13, and that's how.
Yes, you can either convert to a 13 if you think you qualify for a 13. If you have filed a 7 and you have got the discharge, there's a waiting period before you can refile a 13. But you can always convert if the case is not closed and the debt has not been discharged. If you qualify, you can convert to a 13 during the pendency of the Chapter 7.
But if it has been closed and discharged,
Then you have a waiting period to refile. Like a waiting period to refile. And I'll go over the waiting periods in the next slide.
So if you dispute the security of the note, then the court may, and you're probably does in some cases, separates the note from the debt, from the security, and then the note or the value of the note itself goes into the Chapter 13 claim, correct?
If the lender cannot prove that they own the note, they don't have standing, the debt is, they don't own the debt, it's wiped off.
So the claim is wiped.
Right.
So in that case, there is no debt?
Right, that's correct.
Yeah, the court just makes an order that this creditor cannot collect against this borrower on this debt. So you may want to get ultimately a quiet title to get the lien removed, but I mean, practically speaking, if that creditor doesn't collect, no other creditor is going to show up on that debt.
That is correct.
So you have the bankruptcy court discharge the debt, so to speak, in the 13 or 11.
Effectively.
And then in the state court file a quiet title using the judgment of the bankruptcy court.
That is correct.
I gotta complete the chapter 13 to get the discharge, right?
Repeat the question again?
Gotta complete the chapter 13 to get the discharge.
Yes.
Aaron, just for the sake of the tape, if they ask you a question, if you could repeat the question before you answer it, then it'll...
Go ahead one more time, please.
Yeah, the question is that in order to do the quiet title, you have to wait until the case chapter 13 get the discharge.
That is correct. The question is,
25 years.
the question is whether you have to wait until the discharge is complete to file a quiet title action. That is correct. And in most cases, if you wipe out the mortgage debt, there won't be any, you won't have to complete 5 years. If you are making a 100% plan, you can finish it up early.
I will say, I guess it's our experience, it's taken about a year and a half
Because if it goes to discovery,
to litigate, to get to the evidentiary hearing, to get to the adversarial hearing, to get the debt wiped out. We've had about 5 mortgages recently wiped out back in January or so of this year in the bankruptcy court. Those cases took at least a year, if not longer, to get to that point. And Aaron's point is, once you wipe out the mortgages, if you got 20 or 30,000 credit card or whatever else, you can pay that off pretty quickly. Or if your home is free and clear, go refinance your home, and then you pay everything off immediately.
So what happens in the case that after that the real owner of the note show up in court?
if the realtor of the lender is
The real owner of the note, because there is a note, there is an owner of the note. What happens if the real guy show up in court?
oh, well, they have to go to the pen. We have not had that situation yet, but if they do, they have to go to the bankruptcy court and try to prove it.
They have to do a proof of claim.
Right.
Or a motion for relief of stay.
Sure, and they have to get all the documentation in order, all the chain of assignments, all the chain of title with full signatures.
Can I just, people have asked, is there a textbook? And really this this book that I'm holding in my hand here, as my cell phone is ringing, is this is the closest thing to a textbook that you'll find, and you would do wise to have a copy of this, and we will be doing a drawing for some free copies of this, but that would be, so really it's just lecture and PowerPoint, and then you have this book as an option, and we talk about pretty much everything that we're discussing here in the class in that book. And now Aaron's going to pick up, I was going to mention that I think possibly somebody, we don't know if it was somebody in this room or not, actually picked up a copy of the book off the table out front. And so they aren't just like complimentary. You need to see Pierre about that if you to make arrangements for the book. But anyway, we don't. It could have been one of the employees of the hotel. We don't know. But just so we'll turn it back over to Aaron and we'll continue on with some of the practicalities of bankruptcy.
All right. So we'll continue our discussion on the next level of bankruptcy chapters. The next level is Chapter 11. Chapter 13, everyone may not qualify for Chapter 13. There are debt limits of 360,000 of unsecured debt and 1,081,000 for secured debt. These limits are changed every few years to account for inflation. A disputed debt is not included in the limit, but some judges, this could be a challenging issue. So we, as we discussed earlier, we try to go for the right chapters to start with. These limits may seem high, especially the secured debt limit, but if you had bought your home, or maybe two homes in the peak of the market, these can be easily exceeded. And Chapter 11 is the granddaddy of all types of bankruptcies. It's the most flexible. You have a lot of leeway, a lot of leverages, a lot of flexibility in trying to reorganize your debt. Businesses can go into Chapter 11 or Chapter 7 if they're just liquidating. Chapter 7 and 13 are for individuals and couples, and as I said, Chapter 7 can also be used by businesses. There are some practicalities of filing a bankruptcy. If you have done previous bankruptcies, there are some time limits you have to follow.
Can you mention those briefly?
Let me, there's another slide I have that for that. So I'll go over those limits in the next slide when I put that up. There's a means test. In Chapter 7, you have to have income under a certain level where you can qualify for Chapter 7. But if you have income, the household income above certain limits, you have to move into the next level, which is Chapter 13, where you pay a portion of your disposable income as part of your repayment plan to the creditors. So it's sort of like you have some ability to pay back. And I'll go over those numbers in another slide, a subsequent slide. What debts can be included and not included? Mostly all unsecured debt can be discharged in bankruptcy. There are certain exceptions. Alimony, child support payments, student loans, IRS payments, any tickets, traffic tickets, those cannot be discharged. Apart from that, we can discharge almost all unsecured debt. Even with other debt like IRS debt, other things, there are some other provisions which we may not want to go in detail here, but there are some exceptions to those also, where we can include those either in the plan or can discharge at least a portion of those. Before you file bankruptcy, especially for individuals, we have to take a class. It's called a credit management class. You can do it in person, over the phone, or online. A lot of people are opting for the online option. You have to do one class before you file the case and another class after you file the case. It is like a defensive driving class when you get a traffic ticket. So before you file bankruptcy, you have to have that class. After you file bankruptcy, there's a meeting with the trustee. It's called meeting of the creditors, where all of your creditors who you included on your petition are invited to dispute, contest, bring their point of view and meet. It's called meeting of creditors, and it typically happens in Nevada, typically 4 weeks after you file in a Chapter 7 case, and about 6 weeks in Chapter 13, and about the same time in Chapter 11. And it all depends on the court docket load at the time. But it has been averaging about 4 weeks in Chapter 7 and about 6 weeks in Chapter 13 cases.
Is this during the time, is this when you present your case and ask if it's if you say it's going to be an unsecured debt?
As soon as you file your case, the court automatically assigns you a date for a meeting of creditors. So depending on whoever you included in your schedules, Schedule D is for secured creditors and Schedule F is for unsecured creditors. So based on you include, whether or not you include one or thousands, the meeting is set by the court automatically.
So the disputed debts then show up here?
That is correct, yeah. All the creditors are invited to this meeting. They may or may not show up, but disputed debt is included in this. As the name suggests, it's meeting with the creditors or meeting of the creditors. And the trustee is there, and I as an attorney or your debtor's attorney is present at the meeting. Once we meet with the trustee and the creditors, then the court gives us some time. In fact, at the time of filing, we can propose a payment plan, and during as the case proceeds, the plan has to be modified or changed depending on some of the objections from the trustee or the creditors. So the plan may be modified a few times before it becomes permanent. And after you file, you don't have to do anything. Attorney is supposed to do everything for you. I for myself, do everything on behalf of my client. All you have to do is come with me to the meeting, and after that, you just give me the documents, and I do it for you. As you mentioned before, in these type of cases, we can list the mortgage debt as disputed debt, and based on the outcome of those cases, which typically can last up to a year, and most of the time is taken in discovery and other issues. I'll take some more questions now, if you have any questions on the slide we just discussed.
We were talking about the time limits of when bankruptcy is dismissed. Could you share with us?
Yeah, I have another slide on that, so I'll go over that when the slide comes up.
What kind of evidence do you need during this time? Do you need the securitization audit? Do you need proof that there's no assignment of mortgages? Is that what you're looking for?
Yeah, after lunch, we have a full session from Charles.
Yeah, we're going to focus on all the evidence and the proofs and all that after lunch. I mean, I don't want to refuse questions, but I don't want to jump ahead. We're going to have another attorney joining us and go into more detail on that.
If the debtor has the limit in a chapter 13, can he decide instead of going 13, going to 11?
Yeah, he can do that, or the trustee can file an opposition and force you to convert to 11. Or dismiss.
He's under the limit.
Oh, okay. Yeah, sure.
But he decides
Yes.
instead of going
Yes.
13,
Yes.
he decides going
Definitely. Yeah.
11.
A bankruptcy case in California where the person filed bankruptcy and she disputed the debt, and then the creditor filed a motion to lift the stay, and the judge granted it and said that she lifted the stay because she filed bankruptcy after the sale of the property, that she couldn't protect her bankruptcy law because it was filed after.
If the property is already sold, it's very difficult because there's no stay to put on anything left over. So if the property has already been sold, it becomes very difficult to put a stay on that property. In that situation, that was the scenario.
Even if you're disputing the debt?
Even if you're disputing the debt, but the property has already been sold. So the court doesn't have the property in the estate to fight over.
Aaron, if I could step in on that. If a property has already been foreclosed, but say the homeowner is still in possession, or maybe a tenant is still in possession if it's an investment property, in a case like that, you can actually go file a civil complaint for wrongful foreclosure. And in Nevada, I think the statute says you have to file that complaint within 90 days of the sale. And you can allege wrongful foreclosure, and then based upon that case that you have filed in, say, the district court, you can then go to the justice court, which handles unlawful detainer and evictions, and you can ask for a stay of the eviction because this case is not, on wrongful foreclosure, has not yet been decided. And then we would basically use the same evidence and the same arguments that we do in the bankruptcy court. It's just that experience says the civil courts aren't as open, that they seem to have this policy, just dismiss it and you appeal to the Supreme Court. But, you know, if your client is willing to appeal, then that's fine. You know, as long as you know you've done the securitization audits, you've got the evidence, if you know you have a good case, then go for it. And then typically, maybe not all the time, but a lot of the times the Justice Court will give a stay on that eviction until this case that you have filed in wrongful foreclosure has been decided.
Thank you, gentlemen.
There's also, in that same vein in California, an unlawful detainer in the, what you call the Justice Court here in Nevada. When we do those lawsuits in the Superior Court, we point out to the unlawful detainer court that it's a summary proceeding, and they're not dealing with complex issues of title that will affect all the parties, and therefore they must issue a stay, so they can't get over in possession and go forward until the state court action is finalized, and we ask for a restraining order and injunctive relief until the lawsuit is pending. It's been finalized until they can go and apply it to the unlawful detainer.
I've always felt that California was a little more progressive than Nevada.
Can I just respond to that? Yeah, my experience is that the UD cases, they will allow you to do a motion to consolidate, but they're not going to give you a TRO. You've got to go to the state court,
right.
get your case filed, get your TRO, and do a motion to consolidate. And only then, when you show the judge that you've gotten your TRO, will they stop the UD. Otherwise, they will go right through the UD.
That's what I maybe not didn't articulate it, but that's what I was trying to get to. You go to the state court, get the TRO, and show that to the unlawful detainer court.
If you do a motion to consolidate.
We tried to consolidate, they wouldn't do it because they were saying one was a summary proceeding, didn't deal with the title, so they wouldn't do it, but they kept it bifurcated. And the only way to stop the unlawful detainer was the restraining order from the Superior Court.
Okay.
We tried the consolidation, but it didn't work. At least in that.
I've been told by the UD courts that you have to have the motion to consolidate in order for the TRO to apply to the UD case.
Well, we tried that, but the Superior Court, there's a case law, and I give you the site if you want it.
Okay.
But it talks about when one court issues an order, all courts are bound by that order as long as the same nexus of operative facts, same parties, and same property at issue.
Okay, so then you don't have to do the motion to consolidate.
Right, well, they would do it in our case. They said because one court's ruling applies to the other court, all courts have to follow the orders of each other.
Great.
All right. And I would like to mention one thing in Chapter 11. If you have, I think there are some realtors in the group. If you have multiple rental properties, the let limit can be easily exceeded in Chapter 13. And Chapter 11 is a forum of choice there. And in Chapter 11, you have a lot of flexibility to deal with the rental properties. We can wipe out the second mortgages if there is no equity in the home. And we can also do something with the principal. So if you have multiple properties, Chapter 11 gives you a lot of flexibility.
If you don't have equity.
You can't do that with 13?
You can do the 13 if you are the limit, sure. If you have, for example, if you have a second mortgage on your primary home also, we can strip that. Or if you have a rental land at home, we can strip that out. If there's no equity.
One question, like what if you do have equity?
You do have equity, then only the portion which is unsecured can possibly be stripped or severed. But you have to look at the numbers and we may have to order an appraisal. There's one book if you want to, some people asked a question about having a book for bankruptcy. This is one available book in public domain that you can do. Again, this is just as a general guideline. Again, there are a lot of deadlines to meet, a lot of procedures to follow. So this may be a general overview for yourself, but I would always recommend that don't do it yourself if you don't feel comfortable. Always seek an attorney or somebody you trust who can help you with the case.
Have you looked at have you reviewed the book to see if it's...
No, I do not recommend the book. I have not looked at the book myself.
Yeah, I have this book here, and this book does not talk about any of the arguments or the evidence or anything that we're doing. Those things are covered in this book. What this book does, it just gives a general overview of Chapter 13. It has copies of the forms in it. I think it's $40, $45. It's something that if you have a client that just wants to study up or wants to, or has a lot of questions, you can recommend this book to them. But I'm like Aaron, this is definitely not you know, just because you have a knife in your hand doesn't make you a neurosurgeon for your child. And
Well, I mean, the information is pretty accurate in that book.
I would not comment on that. I would assume, but
only in a, it's a very general approach. I mean, it's not if you really want, the National Center for Consumer Law in Massachusetts, they have excellent, and I think maybe $150, and they do, I think at least quarterly supplements, and they're very up to date on the cases, and they're the, aside from maybe Max Gardner, I think they're the brain trust that really takes the position to advocate for the consumer, and they have excellent briefs and strategies and everything, up to date on their cases and everything.
What book was that?
It's the well, they have many publications. It's outside of Boston. I forget exactly where in Massachusetts. It's called let me get the National Consumer Law Center, NCLC. I think that's what it is, NCLC. And I'm sure they have a website, and you can go there, and their publications are more geared for practicing attorneys. I mean, you're buying kind of like legal help books. This book is really just kind of for the consumer, and but I mean, this is, you know, this is a third of the price of probably the other books that you'll find from NCLC. So, and again, we're not recommending this, we're endorsing it, we're just saying this is one example. If you're not a bankruptcy attorney and you just want to get a quick general overview of bankruptcy, this kind of book can be helpful. If you're going to partner up with a practicing bankruptcy attorney who's going to do this kind of work, and then you're going to come in and do the litigation part, well, you may want to just familiarize yourself with that. So this kind of has the structure, and this kind of has the content, I guess would be the way to describe it.
And is there software that's used to do the bankruptcy forms? If we're going to do them ourselves? Is there
yeah, there are different companies that sell software for bankruptcy filings. You can Google them, and you can subscribe for some of them.
Just a question. Are you going to talk about the tools for auditing or securitization, like Bloomberg levels, something?
Yes, in the afternoon session we'll have a good discussion on that. Okay. One thing about the book, these are written, and I don't know how often they're updated. So they may have older limits, they may have older forms, and things are dynamic based on the economy and the caseload, and so they may not be updated. Again, it's good for a general overview, not for specifics.
So we can draw for the free books now. We were going to sort of save it for the lunch break, but maybe we'll say, why don't you switch over to your other group? Aaron has another group of. Slides. Give us just a minute to make a switch on the computer here, and we have some more information on bankruptcy in general. Since Aaron has a master's in computer science, I don't have to say anything to him about how to work my computer. In fact, he hits keys and gets things to happen I didn't even know existed. Has this been helpful for you so far? Good. Okay, the real, I guess the main course is kind of like after lunch. I mean, that's where we get into evidence and some of the arguments and strategies. But for that part to make sense, we have to have the morning part as well, which, I mean, this is valuable too, but it gets a little more exciting after lunch.
This is the slide I briefly touched upon before. What debts are discharged in bankruptcy? Most of the unsecured debts are discharged. The following may not be discharged: child support payments and alimony. And the reason for that is public policy. If somebody had these obligations and he files bankruptcy, this bankruptcy is not a way out for these things. So as a public policy, they do not allow these debts to be discharged. Debts for personal injury or death caused by drunk driving. You cannot be driving around and kill somebody and then discharge that penalty in bankruptcy, no. Student loans, again, some private student loans may be discharged. But normally any government loans cannot be discharged. And IRS debt, there are some provisions in the code where if the debt is older than a certain time period, we can try to discharge that also. But more recent, up to 3 years, cannot be discharged in bankruptcy.
If they're over 4 years old?
Yeah, you can do that. But there are some limitations on that the tax has to be filed on time every year. So there are some other provisions that have to be met. This was a question a lot of people asked about prior bankruptcies. If you have done a Chapter 7, you cannot do another Chapter 7 for 8 years. If you have done a Chapter 7, you can do a Chapter 13 if that Chapter 7 was done 4 years ago. And if you had Chapter 13 2 years ago and discharged, you can do another Chapter 13 after that time period. So if you can reopen a case if you forgot something to include something or add additional things, but filing a new case has to follow some of these time guidelines.
On a Chapter 13, if you just got dismissed, how long a time frame do you have to refile?
You can, if it's dismissed, depending on the reason for dismissal, you can refile in short order. However, you have to be careful, the automatic stay is not automatic after a month. You have to file a motion to extend the automatic stay. So you can refile depending on the reason for dismissal. If it's bad faith or some other reason, the court may not allow it. And the dismissal order from the previous bankruptcy will tell you why it was dismissed, and they may also put some additional limitations on filing again. So it's not like you can just refile again for every dismissal. The court or the judge may have put in the order that you cannot file for 6 months or 1 year, depending on the reason why it was dismissed.
Any limitations on the 11?
11, I didn't put them on this chart because I can look it up in the break and let you know.
What about the chapter, what they call 20, where you combine the 7 and the 13?
I don't do chapter 20s, and a lot of people that I know have not done 20s in Nevada, so I do not comment on chapter 20s. Now we talk about the means test. They take an average of debtor's income, household income of the last 6 months, and then they compare to the median income for the state where you're filing. Every state has different limitations based on their cost of living index. And if it's below the median, then they can qualify for Chapter 7. And if it's above that limit, there are certain other few criteria that we need to test, and that's called the means test. In Nevada, these are the income levels. If you have one earner, a single person filing, annual income below 42,346, 2 people, 56,000, and so on. And these are standard guidelines, and again, if your income is above these levels, they may still qualify for 7, but we still have to do some additional tests to make sure they can qualify.
How would you have the 3 and 4 people filing? Is that where you...
No, household size.
Household.
So if they have 2 kids, if one single father, 3 children, those kind of things. The household size. So that's why if you look, the first one says one earner, and after that is people.
Right.
And it's immediate family, it's not friends, kids or neighbors' kids, it's the immediate family.
Aaron, there's a list that people need to bring to file bankruptcy, like last 6 months, bank statements, 3 months. You want to go through that list briefly for people? Just so if you have a client who's thinking to file bankruptcy, this is the, not only does he have to make sure he hasn't had a prior bankruptcy, not only does he have to make the means test, this is the documentation. Well, he's going to have the online course for the certificate, but then Aaron will just give you the list of the documentation he needs, and then we'll take a question, I guess, afterwards.
Oh, the question I have pertains to the income level.
Oh, go right ahead then.
These change based on the locality you're in, like in Los Angeles.
Correct.
That's correct. Yeah. These are based in Nevada, and they also change based on the inflation index, so every few years.
What location is that for?
Nevada. Mm-hmm. And for the documentation part, normally we need 3 to 4 years of tax returns, 6 months of bank statements for all accounts, and 6 months of pay stubs and any other source of income. So
what if it's self-employment income?
Then we need profit and loss statements showing where your money is coming and where it's going.
Is that for 12 months to P&L?
6 months should suffice. If the trustee has questions, they can always ask for more.
Right.
So I'll hand back over to Charles now, and he.
Thank you, Aaron. I'm going to see, we've had some questions about MERS, and we're going to talk more about MERS later on this afternoon, but I'm going to see if I can get this. See, Aaron has a master's in computer technology, so I don't know if I can get back where he was or not, but no, that's okay. Let me try. I think I can do it. Well, it's already up in it down here. Maybe. Okay, good. Let's see, I'm going to have to go up here just 1 second. I think you'll find this pretty interesting. Oh, does anyone know if we have Wi-Fi in the building? I mean, I'm sure they do. Is anybody plugged in? I can use my phone. I just realized I'm going to need a computer connection for this. Let's see. Is anybody hooked up to the internet with a hotspot right now? I can usually do it with my phone. It may take a minute here to.
Yeah, there is one.
There is? Okay, well I think my phone will pick it up if I just need to. I don't usually hold a microphone when I'm trying to do something with the computer.
Should I hold the microphone?
No, that's okay. I don't know why that's, let's see.
Connection to the internet normally is on the right side of the computer. Normally it has.
Well, that's true, not at the bottom. Let's look down there and see what we have. Thank you.
So it should be checked there, yeah, it should be in there somewhere. Yeah, I guess. The offline, hit the offline.
Let me try another way that I'm more familiar with.
There you go. Connected.
Okay, good. That makes me so happy when it works. Okay, good.
Oh, this is the law?
Okay, hopefully it'll load up.
Open that back up. Oh, that video, okay.
It's a streaming video.
Oh, okay.
I believe in God, so I'd like to just kind of give thanks at this moment in the program.
It depends on how far the internet is reaching.
I mentioned this earlier, I don't know if everyone was here, but there was a Washington State Supreme Court case. They had heard oral arguments just March the 15th, just 2 weeks ago. And this is Bain versus Mers and they consolidated a couple of cases, Selkowitz against Litton Loan Servicing. Let's see, I'm going to need to plug in the audio here, though.
Do you have citations for those cases?
Pardon?
Do you have citations for those cases?
I think we'll get it if we don't have it here. But I'm sure if you Googled Bain versus Mers, Washington State Supreme Court, if you Google that, you'd get it in a minute.
Supreme Court of the State of Washington is now session.
This morning is Kristen Bain versus Mortgage Electronic Registration Systems et al. And Kevin Selkowitz versus Litton Loan Servicing. The opening is going to be shared, as I understand, between Ms. Hulsman and Mr. Jones. Ms. Hulsman, you at this point have 8 minutes and for your opening and 4 minutes for your rebuttal. Mr. Jones will have 8 minutes, for opening. And then Mr. Pratt, I understand you'll be the only one arguing for your side, and that's 20 minutes. Ms. Hulsman, if you'd like to approach.
Do
Melissa Hulsman, and I'm here with my co-counsel representing my client, Ms. Bain. We're here today to deal with a certified question from the federal district court. And obviously Judge Camaro asked 3 questions of the court, but I understand the court has kind of rephrased the question. But ultimately, really the question before this court is essentially whether the rule of law matters in Washington. The holders whose loans are secured by real property in Washington were provided with an expedited, less expensive process to collect on a debt by the Washington legislature in the form of the Deed of Trust Act. In return for that benefit, the note holders were required to waive any right to collect a deficiency and to strictly adhere to the statutory requirements, something that this court and all the courts of appeal have made abundantly clear in every decision interpreting the Deed of Trust Act. Utilization of the Deed of Trust Act is a choice made by note holders. If they do not want to comply with its requirements, they can seek to foreclose judicially, and in the proceeding, they also get to seek a deficiency. But here, MERS seeks to assert, on behalf of itself and its shareholders and creators, which are basically the largest banks, that it may utilize the provisions of the DTA without adhering to its requirements. Now, they try to disguise this by saying that they actually do adhere to its requirements, that they're a beneficiary, but the plain language of the statute makes it clear that they are not, in fact, a beneficiary as defined by the Washington legislature. We laid out in our opening brief the history of the Deed of Trust Act, and certainly the legislative history is not as clear as we know I like it in hindsight, but I do think it does make clear that what the drafters were looking to do was create this expedited, more efficient process. But there was no indication in the legislative history or at any time since the Deed of Trust Act became law that they intended to essentially ignore essentially the standing requirement that one would normally have in a judicial foreclosure setting. So in other words, that the real party in interest or the note holder be the party enforcing the contract through the non-judicial foreclosure process.
What's the policy that they were trying to affect with this exemption? Why is there this statute? What policy is being affected by the failure that you argue occurred here?
So first, I believe that the statute was put into place in order to give a more efficient process to perhaps take it out of the judicial system, relieving the burden on the courts of providing, as the history indicates, a more inexpensive process. But certainly there was also the decision when they did that the strict requirement that the statute should be amended because there's no judicial oversight. So what we have now, turning to the present case, is that we have parties that are seeking to ignore the requirements of the statute, and the public policies are outlined well in the Attorney General's brief. But those public policies are, first and foremost, transparency of land records. So we have a long history in America deriving from our the English laws of transparency in the public records, so that at all times the parties, the residents of any state or even outside the state know at all times who owns land, who has liens on land. That protects the owners of the land as well as any creditors who know what outstanding liens are on pieces of property. Then we have the requirement, the policy favoring homeowners having the ability to know who owns their loan. And there's been numerous revisions to the Deed of Trust Act since it became law, and really the significant changes started coming about in 1998 when we first had the definition section added, as well as a multitude of other sections added. And every change that's happened since then has done nothing but actually more strictly tighten up the requirements of the Deed of Trust Act and have it more specific as to the necessity. And in fact, numerous of the amendments which have occurred in the last few years have actually made it even more clear that it's important to know who the note holder is. So this is for the benefit of the homeowner, so that the homeowner, and I guess in any property owner, but in particular homeowners, would know who they can communicate with in order to see about that loan transaction, to make sure that they are making payments to the right party, to make sure that they can work out any arrangements regarding the sale of the property or foreclosure of the property or preventing the foreclosure of the property. And so all of the
I've had this problem.
Big problem.
I really needed
A good lawyer.
And I kept searching and searching.
There are so many choices.
It's really hard to find one that has all the things on my list.
But I finally did it.
Yes. Thank you.
If you are looking for one as well, look no further.
Here's a really good one.
Just use mine. Use mine.
I'm very satisfied.
Definitely recommend.
Problem gone
thank you.
These reasons have been continued to be all of these provisions have been added to the Deed of Trust Act have simply made it even more clear that the homeowner needs this information in order to protect his or her rights.
So, counsel, have you finished your answer? I don't want to interrupt your answer to the question, but
I believe so. I wanted to make sure I answered the Justice's question. Yes. Okay, thank you.
my question is this: are there provisions of the Deed of Trust Act that can be waived by the parties, say by the grantor or by the beneficiary or by anyone else?
Actually, Your Honor, I don't know of any provisions that may be waived under the deed. I don't know of any case law or language in the Deed of Trust Act that indicates that the parties may waive any of the requirements of the Deed of Trust Act.
So there's nothing in the Act that you think can be waived?
I can't think of any. I know it pretty well, but I can't think of any because as the Attorney General's brief, I think, also on the public policy issue, did a good job of pointing out that this is a plenary statute. It indicates the public policy of the Washington legislature regarding how foreclosures are going to be handled. And when you talk about changing something that is representative of a public policy, then I think it's important to look specifically at something in the statute that indicates that it's appropriate to do so, and in the absence of such language, it's inappropriate to do so because it represents the intent of the Washington legislature. Certainly, again, it's important to remember this is a voluntary statute. Lenders are not required to use the statute. So if they don't like the requirements of it, if they don't want to adhere to it, don't use it. It is really actually that simple. But in fact, they derive a significant benefit from using it. It is cheaper and more expensive, and it's faster to take somebody's home. And it's important to remember that the Deed of Trust Act allows them to take someone's home. This is not a car repossession. Lenders do not have title to people's homes. People own their homes, and lenders have security rights and lien interests on that property. They do not own a home or the real property unless and until the foreclosure is complete. So it's not analogous to a car repossession, and it's in fact inappropriate to use language like repossession because they never possessed the home to begin with.
So what is the consequence of your argument? Is it that there can be no foreclosure?
Absolutely not, Your Honor. And in fact, MERS, if they actually complied with the requirements of the statute and were in fact a note holder, or a party who properly derived rights from the note holder according to the requirements of the UCC, then the foreclosure could occur in their name. But that's the problem. They do not do that. They do not perform any of, they don't meet the definition of a note holder. So if they want to choose to become a note holder, if they want to have notes endorsed in blank and delivered to their offices, and then they want to provide the instruction to the foreclosing trustee to complete the foreclosure, then they would meet that requirement and that definition. They don't do so.
Can I ask you, as a follow-up to that, do you think that what you just argued goes to the second certified question, or do you think that the Attorney General's amicus brief argues that it's just not possible to answer the second question in general? But are you saying the legal effect is they can't enforce, they can't foreclose because they're not a holder?
No, and in some respects that's the difference between Ms. Main's position and Mr. Salkowitz's position, because I do not maintain, and I don't mean to speak for Salkowitz, but we don't maintain that in fact it voids or vitiates deeds of trust and that suddenly now people have free houses or that they're left with equitable mortgages. The deed of trust that MERS creates is certainly muddied. There's imprecise language where it calls itself the nominee for the beneficiary, but then it tries to assert that it's really the beneficiary, but then it's saying it can act for successors and assigns, and so in essence it wants to be a principal, the agent, and a nominee. So it certainly raises that question, but I think the Deed of Trust Act actually gives us the correct guidance, which is the note holder is the one that can enforce the note and use the security instrument to do so. So I actually think that even though we have these MERS
deeds of trust with this imprecise language. The note holder is clearly permitted to non-judicially foreclose under our statute, and therefore, so long as the party, whoever that may be, is in fact the note holder, then they may foreclose non-judicially. And so this simply precludes, I'm sorry, that answers my question. I just don't want to eat up too much of your whole time. Thank you very much. Okay. Councilman, your time has expired. You're not sorry. Thank you. I just want to step down. I did have a question. I wanted you to answer this succinctly anyway. Could you just refresh my memory as to why using the MERS acts and practices violate the Consumer Protection Act? Well, because it engaged in a deception and unfair deceptive act, and that is misrepresenting who the beneficiary is for purposes of initiating a non-judicial foreclosure. I think it's especially appropriate to look at it in the context of Ms. Bainey's case, and although this court is obviously not ultimately deciding the issues in her case, and that will be left to Judge Kuhnhauer, it certainly is appropriate to consider that after 3.5 years of litigation, we still do not know who the note holder is. We know who the trustee of some unidentified securitized trust is, but we still do not have that information. So even in a judicial setting, and especially when in federal court, where even if you don't engage in discovery, you're required to provide initial disclosures, we still do not have information regarding the note holder, and even the vague information that we did get regarding the servicer and the trustee of the trust only came about a couple years into the litigation, and after attorneys for the various defendants have affirmatively inserted other parties as the supposed real parties of interest that turned out to be incorrect. And I think that that's very telling.
Thank you, Counsel.
Thank you.
Jones, you have 6 minutes.
Thank you very much, Your Honor. May it please the court, I'm Mr. Roland Johnson. I am here representing Mr. Kevin Silkowitz. With the limited time I have, I would like to simply make the point that as the court looks at the 3 questions that have been certified, that we return to the principles of Cox v. Helenas for some sort of determination of how we should evaluate those questions in view of the facts that are before the court. Now, I will concede that counsel representing Ms. Bain has a much more complete record. My case for Mr. Silkowitz has not even begun discovery. So the facts of my case are fairly straightforward, and I won't bore the court with those. But it seems to me that if this court is going to make a fair ruling with regard to the efficacy of the MERS regime and its implications for the Deed of Trust Act and the way it's conducted in the state of Washington at this point in time, that we need to return to the principles of Cox v. Helenas. The question for the court would be, does MERS make the non-judicial foreclosure process more efficient or more inexpensive? No. It actually makes it more difficult and more expensive because the borrower does not have any idea as to who its real lender is, the real party in interest, if you will, the individual or entity that has, as it were, the skin in the game. Why is this important? Because the Deed of Trust Act, it specifically defines the beneficiary as the holder of the obligation. It doesn't, after all of the iterations that have been done by the Washington legislature, it has never amended that definition to include agents or nominees. I find the issue of nominees somewhat troublesome, and I'd ask the court to reflect on the utilization of that term. A nominee is not really in the form of an agent with a principle and with authority. A nominee is a placeholder in general parlance. So there is no accountability. MERS has no accountability as a nominee. Although, as counsel pointed out, there seems to be some language in the Deed of Trust that seems to go back and forth. At one hand, it wants to be a nominee. Other times, it wants to be collecting monies. It's a grab bag depending upon the particular Deed of Trust that's employed in a given transaction. So, yes, Your Honor.
I guess I'm looking at the first question that we've asked, and it says, is MERS a lawful beneficiary within the terms of the Deed of Trust Act if it never comes upon a note secured by the deed of trust. We don't have any idea really who or, as a factual matter, if MERS ever held the promissory note secured by the deed of trust.
No, we don't. And isn't that important?
Well, it seems like it would be.
It is.
We can answer.
Well, no, but I think
we do in terms of answering that first question.
I think, as the court did in Cox v. Hellenius, I think the court can set out for those of us that are practicing in this area some guidelines as to what is appropriate. What does that term mean? What does it mean to be a beneficiary? And when the legislature asks the question or asserts that it is the note holder, the one that holds the obligation, I think my esteemed colleagues on behalf of MERS would agree that definition should be construed in terms of the UCC. The UCC and the Deed of Trust Act having been essentially promulgated within a couple of years of each other. The same legislatures were involved, and the utilization of the language was probably consistent. One can presume that the UCC is to be employed. But the most important part is that there's no language in that definition, RCW 6124.005 subsection 2, that refers to an agent or a nominee. It is a holder. Why is that important? I would submit that to fulfill the principles of Cox, if you don't have the note holder enforcing the note, you have individuals who have no respect for the borrower. Now, why would that be important? It's my reading of Cox that this court struck a balance with its thumb slightly in favor of the borrower, because it is the borrower who is in the most difficult position, has the least power of any of the participants in a transaction. It was set that way to give preference to the borrower. That's what is missing here. When the borrower does not know who the holder of the note is, has no idea who to negotiate with when troubles arise.
Was at the starting point, the borrower knows who the note was with. And they went to a bank, they financed a home, and the note was signed to that bank. So why? I understand the assignment issue through the Uniform Commercial Code and holders in due course and all that. The original note owner, I mean, that's where you're somewhere exactly.
That is the problem, Your Honor.
Under the statute, and I'm a real simple guy here, I did follow the statute recently enacted by the legislature to protect homeowners from foreclosure. You got to know who to negotiate with, that they set or arbitrate with. But again, wouldn't you start with the person with whom, or the bank with whom you had originally instituted the loan, and maybe send the notice to them and tell them, if you've assigned it, pass it along to the assignee?
Can't be done.
You can't find the bank, or?
No. In my client's case, First American was that New Century Mortgage Corporation was the original lender. That was in 2006 and 2007. New Century filed for bankruptcy, all its affiliates.
I did read that.
Then in 2010, MERS, on what authority, appoints a successor trustee. The authority issue is really what's at issue. Can you find New Century? No.
I see the problem. I'm sure glad this is a federal court problem.
Well, you can. These cases are in competent hands of Justice Howard. Absolutely, Your Honor. Absolutely. So, if a bank has a department like MERS within it, that's part of the bank, that's okay. As soon as they make it an outside consultant or agent, then they no longer can pursue foreclosure under the statute. The note and the deed of trust, Your Honor, have been effectively severed. In most of these MERS transactions, MERS does not appear in the note. And I've been waiting to hear the argument that, in fact, the note should follow the security instrument. The longest date is that it's the other way around. The security instrument should follow the note. Why is that significant? Because MERS is only found as the nominee for the lender in the deed of trust, not the note. So the note goes where it goes. It gets securitized. It gets pushed into the cosmos. It's made a security sold to Wall Street. It's one of the toxic assets. That's the dilemma. That's why we needed to revisit Cox and try to establish principles that would allow us to find out who the note holder really is.
It turns out security they've disappeared, and with whom do you know? Well, Your Honor, this is a little bit beyond the scope, but I would submit in most instances these securities have forms of insurance, which the court may be now aware of, debt default swaps. In many instances, the court probably suspects. Well, yes. I'm not trying to eat your time. I'm here to serve you, Your Honor. I'm here to serve you.
Your time is expired.
Thank you very much, Your Honor.
Mr. Pratt?
Good morning, Your Honor. Mayor, please come to the court. I'm Bob Pratt from Jaworski. Here with me today is my colleague Russell Wheeler of the Daily Piper firm in Seattle. I appreciate the court's courtesy in allowing me to appear before our feature today. I'm here representing all the defendants in this matter on certified questions. We've talked about the three questions. You've heard about the three questions. Clearly, the penultimate question here is, can MERS be a beneficiary under the Deed of Trust Act in Washington? And given the time constraints, that's what I'm going to focus my argument on today. Naturally, if the court wants to hear about my thoughts on the other questions, I'm more happy to respond. I submit that a thorough analysis of long-standing Washington law will confirm that, in fact, MERS can be a beneficiary under the Deed of Trust Act. I think that there are three approaches to answering this basic question. There are consonant, long-standing Washington law and public policy, and each approach leads us forthrightly to the same answer. I think first, MERS can do so because Washington allows entities to do anything through an agent that they can lawfully do themselves. And the lenders in these cases have expressly selected MERS as their fiduciary agent to serve as beneficiary for the lender, its successors, and sons. Secondly, MERS can do so because under long-standing Washington contract law, parties are afforded broad latitude to insert into mortgages basically any provision they want to have. And furthermore, this court has a very strong policy of enforcing contracts.
So counsel, the MERS is an agent for the holder. And who is the holder?
The holder of the holder of the promissory note would be at the inception of the loan, as the question was.
Is the holder in each of the two cases before us? Who is it?
It would depend on when in time, when you ask the question. At origination, the holder of the promissory note.
Now, if the borrower wants to know who holds this note, who is it?
At this juncture, I can't identify with any certainty who the specific holders are of each of the notes. There's very little actual record in this case for these certified questions. But I think to get to the essence of your question, and judging with some of the comments made by opposing counsel, is who does the borrower need to know about in connection with the loan? It's a complete illusion that the borrower doesn't know who to deal with in connection with his loan. The party that has dealt with the borrowers in residential mortgage lending for my entire career, which is going on 35 years, has been one party. That is the loan servicer. The loan servicer is the party that is specifically designated by, I would say 99.9% of every loan originator in the United States to deal with that consumer. That's the person they make payments to, that's the person they put escrows with, that's the person they do loan modifications with, that's the person they do forbearances with.
I don't mean to argue with you, but the assertion is that my client is an agent, but I can't tell you whose agent my client is.
Well, you asked me for a specific point in time. I don't have the record on these two loans. If, for example, the loan had been sold to Fannie Mae would be the holder of it. The actual loan itself, the promissory note, would be an asset in a trust, in a bankruptcy-proof trust that would stand as collateral for mortgage-backed security. Okay, Fannie Mae, I think this court will recognize, Fannie Mae and Freddie Mac have been the largest purchasers of residential mortgage loans in the United States for the last 50 years. Okay, at no point in history have any borrowers dealt with Fannie Mae. That's, it's, the borrowers, the people that own these promissory notes, they don't have employees, they don't have internet connections, they don't have websites, they don't have customer service staff. It's a fallacy to think that the borrowers need to know who the note holder is. Because
through my mind as, say, a borrower. And let's take this from the opposite perspective. I want to pay off my loan. And I want to get a document from someone who has authority to recognize payment in full. How am I comforted in this situation to know that the person who has signed that document has ownership of that debt?
I think that question, I think, can be answered very directly. And that's actually the reason the MERS was created in the first instance. Okay, when the savings and loan industry collapsed in the mid-1980s, prime was at 21%. A lot of us had mortgages at 14 and 16%. Prime dropped down to 18%. We all wanted to down to 8 to 10%. We all wanted to refinance, but we couldn't do it because the titles to our mortgage loans were wrapped up in a cascade of failed S&Ls, much like today. You couldn't get a release on your mortgage when you wanted to refinance it. That's why MERS was created in the first instance. That's why MERS serves as the beneficiary. To your question, the way you find that out, the Real Estate Settlement Procedures Act, a federal statute which governs all mortgage loans, requires that the borrower be told who the servicer of their loan is. That's the person they deal with. And that's where the release comes from. And that's why MERS is the beneficiary of record in the land title records, to avoid the problem of not having someone who can release the record. If MERS is the beneficiary of record in the deed of trust, that is exactly what happens. A deed of trust is issued and of record, your lien is released and you own your property free and clear. In point of fact, I checked with my client before the hearing today. Since MERS was created in 1997, MERS has released or reconveyed over 1 million properties in the state of Washington, over 28 million nationally. That's what it does. Today, when a bank fails and the FDIC comes in and takes over, they actually use the MERS system to convey the assets, the mortgage loans, the deeds from the failing bank to the new bank.
And so I ask you about the transparency, I guess the disclosure that the Deed of Trust Act anticipates. And so when you're saying, obviously borrowers deal with the servicer more than the holder of the note, but what distinguishes the system under MERS from, in a simpler time, the double selling schemes where the borrower was paying to the person they thought was the holder, but in fact was since sold, and so you end up with double obligations and no one...
Exactly. Well, ironically, that's what the super scheme. One of the great advantages of MERS is that when a loan is originated, it is assigned a NIN number, a mortgage identification number. That mortgage identification number is assigned at origination. That's one of the tools that's used to combat that exact fraud. Because when the loans are registered on the MERS system, one loan can't have two NIN numbers. And actually, the FBI uses that in their fraud investigations. They consult with MERS on that very issue. So that's one of the tools against double selling. That's fraud. Now,
can I just interrupt and ask, though, been addressed? We hear all the time in the news about mortgages, nobody knows who owns them. How does that happen then?
It is a press. I think that...
It's making it up.
No, it's, the problem is they think that the person that owns the mortgage loan, okay, loans are securitized. Loans are all, vast majority of loans in this country are securitized, and that brings more capital, into the state. We're long past the days of the Bailey Savings Loan from It's a Wonderful Life. The loans are actually owned in a bankruptcy-proof numbered trust that stands as collateral, and they sell off pieces of that loan to investors, and that's perfectly allowed. The problem promissory note says it can be sold. It doesn't alter the obligations of the borrower. What the borrower needs to know is, who does he make his payments to? What does he have to do if there's a default he wants to negotiate with somebody? That's the servicer. The owner of the loan doesn't have the stamp, doesn't have the employees to do that. If you call the trustee of a mortgage-backed securities trust in New York, which is different than a trustee of the deed of trust now, two different trusts, they're going to direct you to the servicer. If you look at the plethora of federal programs in the economic crisis, who are they all directed at? The servicer. Who did the Washington Attorney General just enter into a giant settlement with?
Counsel, are you finished with your answer to Justice Stevens' question? Because I have a question as well.
Absolutely.
All right. And my question is simply this. You're arguing kind of, this is a good system, this is a system that solves a lot of problems. But our legislature has said the beneficiary is the holder of the obligation and security. It hasn't said it's the nominee or it's an agent or anything like that. It's the holder. Now, how is it that, by contrast, the parties can change that definition? It's a statutory definition embedded in the Deed of Trust Act.
Your Honor, I don't think that we're changing the definition. I think that when you analyze the statute was enacted within the context of what the law is in the state of Washington. And two aspects of the law of the state of Washington are that anything you can do lawfully yourself, you can do through an agent. And secondly, that the Deed of Trust Act also provides that parties can freely put into a mortgage any clause they want, and that's made specifically applicable.
Well, let me press you on that, because it seems that your argument leads to the conclusion that anything in the Deed of Trust Act can be contractually altered. For example, we have a provision that you cannot non-judicially foreclose agricultural property, even if there's a deed of trust. So can the parties just write into their deed of trust, well, gee, we can foreclose agricultural property?
I think the difference is you're talking about a prescriptive clause in there, not a definitional clause. What's the purpose of the definitional clause? The purpose of the definitional clause, to my way of thinking, is to identify who can be a beneficiary within a deed of trust. And they didn't use the term promissory note. And one thing we know, this legislation knows how to use the term because, as the Vice Counsel pointed out, when they amended the statute, the Deed of Trust Act, for other purposes, they specifically used the term promissory note. They didn't change the definition. They used the broader terms, holders and instruments. Instruments and documents, I'm sorry. That evidence the obligations of the borrowers. I think the legislature recognizes that there are multiple obligations and multiple documents in a residential loan transaction. And what they're trying to identify is the entirety of the obligation of the borrower. And I think to your point, when you're looking at the definition here, they're using the term to identify the universal parties who could be. Clearly, absolutely, the lender could be the beneficiary, right? We all agree with that. The Plaintiffs' Counsel agree with that. There are other parties who could be. The legislature was smart enough to recognize that this is the universal parties that can be the beneficiary, but it's incumbent on the parties to the transaction to decide who's going to be the beneficiary of Bob Pratt's mortgage. And in this case, the lenders specifically chose to make MERS that beneficiary in their capacity as their agent from the lender the successor decides. I don't think that violates the public policy. As was pointed out, this particular part of the Deed of Trust Act was designed to provide a more efficient remedy for lenders to execute against collateral. And I think to look at a simple slide, I'm still troubled by one point that I asked your opposing counsel, which is recent events and focused by the legislation that allows negotiation or arbitration to reduce the amount of the principal. Seems to me, from what you said, MERS has limited agency. They can collect it. They can, as I understand it, they can satisfy the underlying obligation. But do they have authority to negotiate a reduction? What if one of the plaintiffs, or I understand the plaintiffs here haven't paid their debts, but what if somebody is current and they want to discount because of mortgages underwater. Sure. And MERS do that. MERS would not do that. Only one party would do that. And who is that? That would be the mortgage servicer. And that's exactly the party that's designated to do that. And I think that's recognized in the deed of trust amendment. That's what this big settlement does. The big settlement that all the AGs just signed, including the Washington Attorney General, just in a meeting on that last week. They're directed at the servicer, and they tell the servicer, work on these loan modifications. That doesn't really affect, I think, the answer to the question of what MERS is or isn't. And I think this is important because what we're talking about here, maybe limits a beneficiary there because you say they're a beneficiary of the terms, some kind of holding the note, but they can negotiate changes in the terms. If the lender wanted them to, they certainly could. That just is not a role that they do. The MERS was created to address a very specific type of problem. A very specific kind of problem, which was the problem of not being able to get releases and reconveyances. That's how they came up with this notion of having MERS be the beneficiary of record. Because what is the purpose of the Recording Act? Why do we record a mortgage in the first instance? To put the outside world on notice that somebody, inquiry notice, that somebody has a lien on there. So if, for example, the state of Washington wants to condemn part of 10 houses in a row taking a right of way, or they've got a tax lien, which they can serve it on MERS, and MERS is obliged to get it out there. Municipalities, when houses are foreclosed, I've worked with several cities with MERS to help them identify, who the servicers are on the loan because the house needs repair. And I think that's one of the things that when you look at that objective, that's what's done to the transparency question. I think there's also an illusion about what is and is not in the land records. Okay? The whole of the promissory note has never been in the land records in America, to the best of my knowledge. I know a lot of looking. Actually, statutorily in this state, we have a torrent system. Nobody uses it, but there is a torrent system. We have a torrent system in Minnesota, Your Honor, because I and actually that's one of the things that's interesting because with the use of with the development of MERS, one of the questions we had in Minnesota, because the torrents, I'm probably dragging you way up here. I'm sorry. We can have that discussion another time.
So I want to ask you a question on behalf of Justice Chambers. You may know he's recovering from surgery and he can't speak, so
I'm sorry to hear that.
he sends me his question, and it follows up on Justice Wiggins' question where you distinguish between definitional sections and prescriptive sections. And his question is, could the parties change the definition of agricultural land to accomplish what Justice Wiggins was asking about?
I would say absolutely not. Because that is a prescriptive term. It's a definition that is intended to provide a specific remedy for it, as opposed to just the identity of the parties. And I think when you look at the operative provisions of the Deed of Trust Act, I'm a consumer too. My kids are consumers, and I want them to be fairly treated. And when you look at the remedies in the Deed of Trust Act, what are the consumer protective things? There's things like making sure you get notice, making sure that you don't have another action being brought against you in another forum on that same debt. That if you elect to use this remedy, you not intend deficiency judgment. And I want to make one other point too before I see my points like coming on here. A very important consequence of the issue we have here today goes way beyond foreclosures. We're all focused on foreclosures because it's a big problem. And there's a lot of problems with foreclosures. I don't think MERS is the problem. And when you think about this, we're talking about, can we be designated the beneficiary when the loan is originated? Can we serve that function? And I think one of the things you got to keep in mind is that the arguments that the plaintiffs are making would require that somebody who is looking in the land title records in Washington at a recorded document would not be able to ascertain from the four corners of that document what the rights of that party are. A title examiner, and I don't know if they're a lawyer, a title examiner needs to be able to look at a recorded document and say, here's the beneficiary. They're indexed in the grantor and grantee things. They can do what beneficiaries can do. There's no such thing as a limited purpose beneficiary for the Recording Act. Title examiner's not going to have a clue what's going on with that promissory note. And if you draw the analogy to commercial lending in Oregon, for example, Commercial loans have used lead banks as the holders of the secured party for decades. It's never reflected all of, the 40 participating banks in the note. It's the same thing here. You cannot require a title examiner to look beyond the recorded documents. And the owner of the note has never been in there. I submit that if you search the land title records in Washington going back to 1960, up to 1997 when Morris was created, you're not going to find Fannie Mae or Freddie Mac in the land title records.
Suggesting is you've answered the question of Justice Chambers and Wiggins, but what some of your argument here seems to be directed to the wrong party, i.e. across the street we have a legislature that can change the definitions and saying we got to update this because we got to do, there's a new system, there's a little old lady in Topeka whose retirement is based on the payment coming from these mortgages. That's a good argument, but again, not a discussion you and I will ever have because I'm not going to join the legislature.
Why, hopefully. But I think that, you look at the definition, and again, you look at the context of the statute. The context of the statute is, you've got a long-standing agency law here. You've got a specific part of the deed of trust which says you can insert any clause in a mortgage to protect the mortgage. The legendary professional Staubach, I think is how I pronounce his name, it said, there's no end to the number of clauses that can be in there. And I think that's true. I think the clauses can't conflict. You could not, for example, shorten the notice period on foreclosure. But again, I think you can appoint a beneficiary. I think the statute needs to be read in the context of you're allowed to do things with an agent in this state. And I think that's actually, I think the agency argument is both compellingly simple and the most direct way to get to the question. I think freedom of contract is there. This is a contract where the parties have agreed to the appointment. There's nothing hidden here. They know that MERS has been the beneficiary. If they want to find the owner right away, they can go on the MERS website and find out who the owner is. They can put an inquiry and they'll tell them. If they want to find out who the servicer is, they can tell them. That stuff you could never find before MERS. There was no inventory of it. Thank you, Your Honor. It's been a pleasure to be here today.
Ms. Hillsman, you have only 2 minutes.
Okay. Mr. Johnson wanted to say something, but I guess between the two of us, we only have 2 minutes. So I'm just going to hit the bullet points, if you don't mind. So first of all, counsel's representations regarding MERS and what its function is demonstrated, is contradicted by the record. I ask the court to pay attention to that. Most importantly, the Washington legislature has actually continued to make it abundantly clear that they care who the beneficiary is. And most recently with the passage of the foreclosure mediation statute. And also the requirement in 2009 that in order for a foreclosing trustee to foreclose, they are required to get a declaration under penalty of perjury from the party indicating that they are in fact the beneficiary or have power from the note holder to initiate the foreclosure. That does not contemplate something like MERS. And so the legislature has continued to make clear its purpose and the importance that it's placing on being a note holder. Justice Gonzalez mentioned what if MERS was part of the company or something, and whether or not it could then take the practice essentially as a servicer or as the note holder. Again, it's important to remember MERS is attempting to replace our recording statutes. It is not attempting to actually act as a servicer. It doesn't collect payments. Its own policies and procedures, its own agreements, which are in the briefs, make it clear that it does not collect payments. And in fact, it specifically describes itself in its own MERS agreement language with the various parties. It is solely the nominee, that it doesn't collect payments, and in fact, it now has a policy in place specifically instructing servicers or entities engaged in foreclosure, identifying them as the foreclosing entity. So they continue to change. They're constantly making different representations regarding who they are. The real reason for the creation of MERS was not because of some problems with the land title system, because certainly they could have gone to legislatures to clear that up. The real reason the MERS was created was the savings for lenders and servicers. They obtained an analysis by Ernst & Young in 1994 and estimated that they would save $77.9 million in recording fees around the country, and that is in 1994 money. So the real purpose was to avoid the recording statutes of the states. And that's important because obviously we have significant budget concerns right now, and counties could use that money, and these banks and servicers have attempted to avoid it. They've also contended, also your time is expired. Thanks very much. We'll be in recess for 10 minutes.
Pretty interesting.
Supreme Court is recess.
Okay. I want to tie a few things together for you. One of the things that was talked about a lot was the Deed of Trust Act in Washington. And most states have some version of that. And it's important to look at the legislative history of that. And you have to kind of go back 150 years, maybe something like that. You know, in the early years of this country, when more land was acquired in the West, and a lot of agreements were made with the railroads, and that sort of like every other section, the railroad got ownership of every other section, so you had kind of a checkerboard effect. And then there was a lot of absentee ownership of property. You might have somebody in Chicago or New York who, you know, bought half of a county in Idaho or somewhere like that, and maybe they had a mortgage on it, but they were really an absentee owner of that property. And if they failed in their payments, it was going to be very difficult and expensive and time-consuming before the days of the internet, before the days of airplane travel, to have a judicial foreclosure, which had always been the model. The model had always been judicial foreclosure. You know, the lender would take his evidence and go to a court of law and file a complaint against the borrower saying this borrower has not honored his contract, so Mr. Judge, please issue me an order to go and foreclose on this property. And so, but if you think about it, if people were all over the United States, a lot of money and a lot of ownership was, say, in the eastern part of the country, owning a lot of land in the western part of the country, it would be very difficult, expensive, and time-consuming to have to go and have a lawsuit, you know, especially if you're traveling by stagecoach or something like that, or maybe by train at some point. But it would be just very difficult to have all these court cases. So what developed then was non-judicial foreclosure. And non-judicial foreclosure was done as an accommodation to lenders. And it was not to waive or obviate any of the rights of the borrower. In other words, due process still had to occur, even though there was a non-judicial format or system in place to bring about foreclosure, mainly as a way of convenience, to save time, to save money, and just, I mean, if the person's not really going to fight this case judicially, let's just have a non-judicial foreclosure. So non-judicial foreclosure was set up, but it's always clear, if you go back and read any of the legislative intent in any of the states, that all of the aspects of due process are supposed to be adhered to and honored. And so what they're saying here, in this case, was that non-judicial foreclosure has not been convenient, it's not been less expensive, and the rights of due process have not been adhered to and honored because they're not following the paper trail, and it's a moving target. We're changing the definitions as we go. And it was interesting that, Mr. Pratt, who was counsel for MERS, actually, did not know who owned, this case had been going for at least 2.5 years, and he did not know who the owner of the debt was. And then in his further comments, he kind of went on to say, but that doesn't matter. We don't need to know. Well, let's roll the tape back just a little bit. Mr. Pratt, if you're in a home with a mortgage and you had a catastrophic accident, you fell down the steps or who knows what, and you can no longer work and you'd like to try to negotiate something with the holder of your note, wouldn't you like Mr. Pratt to be able to know who your note holder is and be able to communicate with them perhaps or something like that? And so on the one hand, you have the traditional laws and rights and duties of the parties that we've had in real estate for hundreds of years, and on the other side of the spectrum we have over here this accommodating quick system. And as the counsel for Ms. Bain indicated, it was really not done so much to accommodate the lenders, it was done to save the filing fees for recording all of these assignments. In other words, if you name MERS as the assignee or as the beneficiary, then you can swap that note as many times as you want to without having to record it and pay the recording fees every time because it's always MERS. But the point of doing that, MERS would never exist. I mean, if MERS was literally named the beneficiary, then Haltman, who's no longer with MERS, but those people would have cashed in those notes and gone to South America a long time ago. So MERS in its own contract with these originators and quote-unquote lenders, it says they will not take any interest in a note. And I think they have to have that in their own documentation, in their own contract. Otherwise, these originators wouldn't name them. They're like giving away the value of that note. And so MERS cannot take an interest in a note. So if MERS does not have an interest, and they're not an agent, they really are just a nominee, that they have no authority, they have no skin in the game, they have nothing at stake. And MERS it has less than 20 employees, I think. And then it has, thousands of vice presidents in all the originating lenders' offices. And by the way, those vice presidents were named by Haltman, who did that without a board resolution. So most of those vice president appointments can be challenged also. And so it's just interesting that here you kind of see some of the best representation that MERS can bring up, and it gets all the way to the Supreme Court, and the guy admits he doesn't know who owned the note, but he in the same breath he kind of says, but that doesn't matter. Well, I beg your pardon. So far we're still under the rule of law in this country, and it does matter. And so these are the kind of points, and we're going to get very much more so into legal strategy and evidence and the other aspects of the cases, but we're going to have the drawing now, I think, for a couple of the books. Quentin, can you help us? Who has the names in the bowl?
Yes. My experience here started in June of 2010, and we started bringing a whole raft of lawsuits in state court trying to allege wrongful foreclosure and a lot of claims like that. What we experienced in the state court and knew was going on just rampantly in the federal court was that the courts, state court and the federal court, were just very hostile to these claims. And I think the basic reason is that Nevada is a non-judicial state, and we were basically asking the judges to look at all these mortgages and basically turn it into a judicial state, and they didn't want to do that. So we have had more success in the bankruptcy courts. We found because we find that the bankruptcy court judges and law clerks, they know debt better. That's all they deal with. And you're dealing with subjects that lawyers never take as a mandatory class in law school, namely UCC Article 3, and it's only just given for a little section, even on the Nevada bar. I didn't even have any of it on the Minnesota bar. So you're dealing with topics that a lot of people, including a lot of judges, don't understand. But in the bankruptcy situation, as Charles indicated, you will file a bankruptcy and you will pretty soon get hit with a motion to lift the stay. Now, they'll set it in Nevada for 30 days out. They can't serve that motion without a notice of a hearing on it. And you have 14 days before that hearing to file an opposition. Okay? That opposition should highlight, in my opinion, the following. First of all, it's very clear under the bankruptcy case law, and this is nationwide. If you find a bankruptcy case in Michigan, use it. The best cases to use are the BAP cases, the Bankruptcy Appellate Panel cases. That's the Bankruptcy Court of Appeals that a particular region of the country will go to. The Ninth Circuit out west here has its own BAP, Bankruptcy Appellate Panel. So it's very clear under the law that in the context of a motion to lift stay, the banks, the creditors, have the burden of proving that they own not just one but two things. That they own the deed of trust and the promissory note. That is, that they have the right to enforce them. Otherwise, they don't have any standing to bring a claim. What we've been seeing a lot of is on the issue of standing, and where you do have a securitization audit and you find that this note has previously been sold to a securitized trust, hasn't been very frequently that the movant, the person bringing the motion to lift stay, is the trustee of that securitized trust. Okay? Sometimes it happens. We're dealing with a couple here where it has happened. But if the movant, in that case, is not the trustee of the securitized trust, there's a lot of law that they have no standing at all to bring that claim, and it should be denied. The other thing is that you get into court, and this is where, and it's always nice to have them bring a motion to lift stay, in a sense, in the sense that the burden of proof as set forth by the bankruptcy reported issued cases that are precedential, it's very clear that they have the burden of proof. They will also file, sometimes, most of the time, not all the time though, a proof of claim document. Now they're supposed to attach to that all their supporting documentation. That would be the note, that would be the deed of trust, and that would be any endorsements or allonges to that note. You all know what an endorsement is. An allonge is a separate piece of paper that has a signature blank that's supposed to be affixed to a note that's supposed to be attached to it for purposes of endorsing it or transferring its negotiability. Who can cash it? I have not seen one proof of claim yet come across my desk in a year where they ever attached a properly endorsed note. Now, when they don't do that, the bankruptcy rules and law is very clear. They do not get the benefit of what would otherwise be a prima facie showing of proof. If they do attach a properly endorsed note to a proof of claim, then that is prima facie evidence of the validity and the amount of that claim, and you better come in with some evidence to show it's not, because now the burden's been shifted to you. But again, like I say, I've never seen it. You get these people that are, I don't know if they're $10 an hour or whatever, but they're just told to go to the copy machine. A real endorsement might be on the back side of a piece of paper. I just saw that last week on what they claim is the original. Yet when somebody sent it through the copy machine, they didn't double-side copy it. Other people claim that these allonges actually were with the note at the time, but somebody just forgot to do it or something. You know, real convenient claims like that. But anyway, so it's nice to combine and when they do file a proof of claim, then you as the borrower or representing the borrower should be filing an objection to that proof of claim. Well, it's nice to combine the hearing on both those for one date. So it's nice to get it set up in that way, because then it's very clear that they have the burden going forward. Now, I should mention this, and this is going on in the cases that we're seeing. By law, and I believe it's Bankruptcy Rule 7001, if a borrower challenges the validity or amount of a proof of claim, they cannot do it without starting, that is commencing, an adversary proceeding. What is an adversary proceeding? It's a lawsuit within a lawsuit, sort of. Bankruptcy case is not a lawsuit, but an adversary proceeding is. An adversary proceeding would involve the drafting of a complaint, the naming of defendants, people that might claim an interest in this note, suing them, getting service on them, or admission of service, a lot of money paid for that, filing that in court, getting it in court, going to a Rule 16 hearing or whatever to have a scheduling order set up by the dates by which certain events have to transpire, a whole period of discovery, a lengthy period of this, that, and the other, and finally a trial day way out into the sunrise somewhere. Now, what I just articulated is a very lengthy, expensive, and complicated process. We have been successful, however, at responding to those arguments, which they are just really, I know, making for appeal purposes. Because the rule does say that. The rule does say if you challenge the validity of a debt, you have to start an adversary proceeding. We have been getting the judges, however, to accept this argument. Let's look at Rule 1 of the Rules of Civil Procedure. They say that every rule should be guided by the principle of effectuating a just, speedy, and efficient result. So the judges are saying you can get all the due process that you're claiming you need, everything that you need in terms of what the adversary proceeding will provide you, if we just set out a date for an evidentiary hearing in the bankruptcy. We don't have the borrower start an adversary proceeding, and we allow all you people to do discovery in the interim. And we've had 4 cases go that way. So it's cheaper to our clients, it's more efficient for us, things can happen a lot simpler.
All right, can I stop and
Sure.
to make sure I understand what you're saying? You don't file the adversary.
No.
You set out an evidentiary hearing on the motion to list stay.
We don't, sir. We go to the hearing on the motion to lift stay and or the objection to proof of claim. We request that right in our briefs, and all the time.
Evidentiary hearing rather than, in other words, just an evidentiary hearing within the bankruptcy court, not the adversary, for the purposes of proving the no.
Absolutely. Yep. And it's, again, like I say, it's a lot simpler, it's a lot quicker, and it's a lot cheaper for everybody. And you're dealing here with people often that don't have a lot of money, they wouldn't be in bankruptcy. So,
And if the lender, creditor objects to that process of the courts deciding in the debtor's favor?
they are here in Nevada. If you look at the rule under which an objection to proof of claim is expressly mentioned, it mentions that, quote, after notice and a hearing, unquote. We're using that to bolster our argument that, hey, we don't need this whole other lawsuit within a lawsuit with summonses, complaints, finding people, investigation on the Secretary of State, where are they, who's their, registered agent for service of process, getting service of process. We're talking $1,000 there just to do that. Now we get him into court. Now, well, you guys know how lawsuits go. They go on forever. These things can occur, however, within the course of a lot less time, getting into an evidentiary hearing. Then what we find is that What we have found so far is that we have had some real success at the evidentiary hearings. If you're careful to point out who has the burden of proof here and look at the specific evidence, and I'll just talk about some examples that we've run across. Okay, so you get there, and they're claiming that a note was signed and therefore turned into bearer paper, and they're the bearer, they're the holder, and they can enforce it. Well, before you introduce anything into evidence at trial, and that's what the evidence hearing is, you got to authenticate that. You have to prove that this is in fact what it purports to be. That's the rule of the authentication evidence rule 901. You have to prove that this is in fact a business card of Mr. Aaron Gupta. Unless you do that, that does not get into evidence. Okay? Having crossed the one hurdle of authentication, you then come across, this applies across the board. The witness who does that has to have personal knowledge of that fact. That's evidence rule 602. They don't have personal knowledge of it. Oh, Charles told me it was? No, doesn't get into evidence, that's hearsay. Then you must prove all the elements of the business records exception to the hearsay rule. And I'll show you how they work within the context of somebody trying to admit a note and an endorsement. I have not seen in the last 2 years, one, a allonge or endorsement that's dated. I find this hard to believe. I don't know how much legal business is created over people not dating things, but I know it's in the trillions. People should always date things. That's why our smart cameras and everything like this do it for us nowadays. Although you would have to have a subscribing witness, wouldn't you, that I correctly set the date. That's personal knowledge. But these things are undated, and the people that sign these things sign many per day. Yet in bankruptcy, it's crystal clear that that endorsement, that endorsed note whereby somebody hands me an endorsed IOU, for me to be able to enforce it, I have to prove that it was in that enforceable form at the time the proof of claim was filed. And I have case law that I've brought along here today that backs that up. So imagine somebody coming in where they sign multiple documents per day, tens, maybe hundreds, I don't know. These are executive presidents at banks. Now they might be gone, and they're going to tell us that really, in fact, on this undated allonge, they really signed it before X date. I mean, they are so subject to cross-examination. The deed of trust is dated. The deed of trust is often notarized. The assignments are dated. The assignments are often notarized. The promissory note is dated. Sometimes there's a signature name affidavit along with that. It's notarized. Get this allonge that supposedly transfers the right to enforce a note that can be worth $1 million worth of money is undated. It's incredible, but they do it. And at the cases we've seen, they don't call the right witnesses with personal knowledge who can get these things into evidence. And therefore the result has been, oh yeah, these judges want to try to bend over backwards to help these people that, you know, have lawyers, they're banks, they supposedly can help hire the best legal counsel, but we've gotten orders sustaining our objection to claim, but denying the motion to lift stay without prejudice. Meaning, we'll give you another shot. Line up the correct witnesses, buddy, and we'll let you come in here one more time and try to prove it up. So, that in a nutshell is been our experience in court. The other thing I'd like to address in connection with apparently what somebody's going to talk about more this afternoon is that what is the value of a securitization audit in connection with a bankruptcy file? If anybody's heard of the Veal case in this region, it's In Re Veal, V-E-A-L, and it's a BAP Ninth Circuit case recently by Judge Markell, who sits here in Las Vegas on regular bankruptcy files. If you look at his pedigree, he's a real scholar on this stuff. He says right in there that it shouldn't matter to the borrower if it's been securitized as long as he knows who to pay. But there are the following situations in which a securitization audit could prove to be real good ammunition in a case. We've got a bunch of failed banks in the last 5-10 years. We got Countrywide failing, becoming Bank of America. We got IndyMac failing, becoming, isn't it One West? Right. One West Bank?
Right.
And 3, at least from my knowledge, we've got Washington Mutual, that was in Henderson, Nevada, where I live, failing and becoming Chase, right? Now, if you've got a situation like that, where that note supposedly originated with either Countrywide, Washington Mutual, or IndyMac, you got this situation. I'll bet you, Vegas odds, that they took that loan, they took that note, back when they were IndyMac, back when they were Countrywide, back when they were, and they sold it to a securitized trust. Now, it's no different than this. I have a bunch of garage sales in my garage. Last week I sold a particular toaster. Now, you can't come in here today and buy that toaster, because it's gone. So, when Chase takes over Washington Mutual from the FDIC, when One West takes over IndyMac from the FDIC, when Bank of America merges with all these different companies that became Countrywide to BAC Home Loan Servicing to this, that, and the other, and merged and stuff, and all this, did all these legal finaglings, it wasn't there to buy. It wasn't an asset to purchase. It was not owned by them, and if it's not owned by them, they can't buy something that the other guy didn't own. They're very good in that respect. The other way in which those securitization audits are good is that they show who is the trustee of this securitized trust. I bet in 90% of the cases I handle, the alleged creditor, the movant, person going after filing a proof of claim against the borrower, making a motion to lift stay, is not that trustee. So that audit shows who the trustee, that securitized trust is. And you back that up with the law that no one but the trustee of that securitized trust has standing to bring this claim, and they're out. That's the way it should go down in the courts. The third way in which the securitized audits are beneficial and helpful is that they show, or should show, you should put it into the declaration or affidavit of your securitization auditor that he or she found that this trust, particular trust, had a closing date. Closing date means a date by when all assets have to have been sent into that trust. Okay? Now you'll find, here's what you'll find, routinely. Your note, your auditor will find in that trust. And the auditor will find that the note was in the trust for the closing date. But then what happens later on? Well, all these notes made during the crisis subprime market blow up of 06, 07, 08, they're going to have an alleged default by the borrower. Now is the only time at which they're going to create an assignment of the deed of trust. Then that assignment deed of trust is going to try to send it to whom? The trustee of that securitized trust. There's two things about that that you should be aware. First of all, trying to do it beyond the closing date, so therefore it's not not properly assigned. Second of all, point this out, and I'll tell you why in a minute. Point this out. Those securitized trusts don't hold deeds of trust. As a matter of course, ever. They only hold notes. So it's an improper assignment because they don't even hold those type of documents. when you get into an audit that tries maybe to rely too heavily upon the PSA, the pooling and servicing agreement of the trust, the prospectus, some of the trust documents, the lenders have tried to, and have very successfully so far in the courts, tried to paint your whole picture like, well, judge, he's alleging the violation of a whole bunch of agreements that, of which he's not a party. And he's not a third-party beneficiary of that, so he has no standing to raise those arguments. I would recommend you try to stay away from too heavy reliance on those agreements or breaches of those agreements, and just go use the audit and fashion the declaration or the affidavit accordingly, like I've set forth. But what we've really found is that when you can finally get them cornered to the evidentiary hearing, or contrariwise in an adversarial proceeding at the trial, one, they have the burden of proof, and you have to nail that down with the judge. We had a judge last Friday that was confused about that and made us proceed first. But that would be reversible error on appeal for sure, because it's a de novo issue which an appellate court would review afresh. But hammer that home, that they have the burden of proof. Write a pre-trial brief, write a trial brief, write an evidentiary hearing brief. Again, reminding the judge, you've just read your 20-page combination opposition to motion to lift stay, objection to proof of claim. Did they get that part of it? Did they really get the part about who has the burden of proof here? Who has the burden of production? Who has the burden of persuasion? It's very important. Then at that hearing, just get your rules of evidence in a book, copied off the internet, whatever, and have them there in front of you. And again, they are 602, personal knowledge, 8036, business records exception to the hearsay rule, and 901, authenticity. The other ones should be 1001 and 1002 that stand for the best evidence rule, the original documents rule. What does that mean? That means they should come in here with the original note, not a photocopy. No bank would cash a photocopy of a check. Moreover, in the UCC Article 3, whatever state you're in, I have the number in my briefs, but there is a provision that if demanded by the debtor, the claimant must exhibit the instrument. That's the language used. That language has been construed by courts to mean they must produce the original. So hold their feet to the fire, make them produce original documents. They're usually coming in with things that are signed in black ink. You notice a lot of lawyers a lot of time will walk around with a blue pen in their pocket, not a black one, and there's a reason for that. Some people use red or green for the same reason. But make them prove its original document, and with just those rules of evidence in front of you, I think you're going to find that if you just say the word objection, witness doesn't have personal knowledge, objection, hearsay, whatever, you're going to get those objections sustained. Let's look a little bit at the business record exception to the hearsay rule. What do you have to prove? First element of that, it's about 5 parts. You have to prove basically that the records were made in the ordinary course of business, that it was the regular part of the business to make such records, and they just have to appear trustworthy and that they were done just routinely, how they always do things, okay? But the first part of that says that they were made at or near the time by a witness with knowledge. Now, what does that mean? On an undated allonge, again, what does that mean? They have to prove, right, that rule says right there, they have to prove that it was made at or near the time. The time means, in the In Re Wells case, the time the proof of claim was filed. They have to prove that endorsement was made before the proof of claim was filed. Usually they can't do it. I'll tell you what, I deal with so much paper in my life. If there was an undated document, I have a very good memory for when things are created on dates. But if I signed the same type of documents day in and day out and did not date them, and years went by, these notes are dated 06, 07, 08, proofs of claim are filed a year ago, etc. I couldn't do that. And I'll tell you what, anybody else that comes in there that says, oh, I know it was made before this date, when you establish that they've signed thousands of these things in their lifetime, hundreds within a week, it's going to appear incredible. So that's where we've had our successes in the area of evidence at these hearings. And I can't emphasize enough here in Nevada anyway that the best forum in which we have seen these claims succeed, where we've kept people in their homes for a substantial period of time, is in bankruptcy court.
Chapter 11?
We do mostly 13s. 11s are, as I understand it, very expensive reorganization for a business, but all the same principles should apply. Now, I have to couch that statement by the fact that my case law, all my cases dealt with 13s. It rose out of a 13. I don't see anything conceptually different about a 13 versus an 11 that would shift burdens of proof and things like that, but there's more of a dearth of case law than there is with 13s.
Going to get more, case law on 11s, same idea, emerging shopping centers.
What's that, sir?
We're going to get more 11 law shopping centers and all that falling down.
Oh, I'm sure. Yeah. So anyway, that's my summary of what I can bring to the table here. I would, unless Charles wants to handle it differently, just open it up for questions from the audience and or Charles or whatever. So
that's what I was going to suggest, that we take some time for question and answer, and then at the end of the question and answer period, Tierra and Quentin are going to demonstrate. How many people here have seen a securitization audit? How many people have not seen a securitization audit? Okay, especially for those of you who have not seen one. And then even if you have seen one, you know, like I've seen an integrated circuit board. So what? I don't have a clue what goes on inside that integrated circuit board. But so Tierra and Quentin, and maybe with some input from us up here as well. I'm actually certified as a securitization auditor myself, and have gone through the training with CFLA. And so anyway, we'll take some Q&A right now. And just before we do that, then we'll talk about the securitization audit. But I'm gonna just back up here. Most of these slides parallel a lot of the things that Charles was talking about. Let me see if there's one more. So you may just want to go, Charles, I'll just have you, if you'll advance the slides.
Sure.
Right there, and see if there's anything else that you wanted to bring out.
This way it's already all the way to the back.
No. Just click it one slide at a time.
Proceed to comment.
Forward?
Yeah.
Yeah, that was forward, right there. Yeah.
One thing I see here on this screen that is important, that Aaron is aware of, the reason for, is that the way, so you understand how we practice. At the firm I work at, we only challenge the real estate debts in the context of bankruptcy court. Like I said, mostly Chapter 13s. Lawyers like Aaron do the general bankruptcy work, all the other stuff, preparing the schedules, preparing the petition, getting all the other filings ready, appearing at the hearing, confirmation hearing, appearing at the 341 meetings, et cetera, et cetera, et cetera. But lawyers like Aaron do prepare these schedules. Now, you can imagine these banks are going to want to latch onto anything they can get, and if they can see some admission or something in your schedule or something, they're going to try to grab onto that. It's important that you've listed the mortgages as disputed debts. It's important. You can amend later. I've even seen case law on the topic, and I kept it for future use, just in case need be. It seems to be a split among the courts, but I think most of the courts hold that those are not admissions. But you just want to avoid areas like that, because it's like trying to, it's the old story about throw a skunk in the jury box and, you know, I mean, you can never get it out. So, anyway, I'm not so sure I was real focused on anything that, whoops, I should have pressed that one, that's true. Now it's little. Otherwise, I was just gonna.
Whoops, oh, that wasn't the right, okay, let me catch us back up here just 1 second. That was my mistake, Charles.
Anyway, while he's doing that, I saw a couple hands. Yes, sir.
Yeah, when you say that you have to list the mortgage tax as dispute tax, you mean Schedule D or Schedule F?
As what?
You mean Schedule D or Schedule F?
Anywhere it's listed. I think F I saw the other day, it is listed, there's it's the one document, I think it's F, in which there are real narrow little columns for that.
D is secured debt.
Yeah, you don't want to list it as secured.
Okay.
If you do list it as secured, say the amount secured is 0.
You can list it as secured and then.
No, I'm not kidding.
But wouldn't you say disputed in Schedule D?
What's that?
You would say that it's disputed within Schedule D.
Absolutely. That's correct. You're not going to run into problems.
I'll just advance it, and you can see if there's anything you want.
Okay.
And you said to list it as unsecured?
Disputed.
Yes, I would.
Schedule F?
Yes, disputed.
Unsecured and disputed.
Yes.
You betcha.
I mean, it seems to me if they can't enforce the note, they have no security.
That's right.
People are getting their houses for free, Jeff.
There you go, and that's the proverbial question that everybody's trying to answer. And then it gets into, we could spend days here coming up with public policy.
I just want to know what happens.
Let me address that.
If the judge is thinking that way, you've usually got a problem, and they are thinking that way, and what we're seeing is judges that, they don't want to be the first one to go up there. Because you'll probably get a flood of litigation coming into courts, right?
Absolutely.
Nevada is just that far away from maybe going there, because in the Levia case, in footnote 7, it said, we're not addressing the split the note theory. So they got to get the right case up there before they do. But yeah, that is the end result. When you go in on an objection to proof of claim under that 11 U.S.C. statute, you are asking the court expressly to hold that. The debt is, the words in the statute are, quote, unenforceable against the debtor and the property of the debtor. I hope y'all heard that. We're talking $1 million loan here, and you're going for the home run.
Let me just make a comment on that. For some of you, you may have a little trigger in your moral conscience that's saying, gee, a free house here? Now, well, hang on, because it can play in court. See, and that's, the counsel for the lenders have been taught to go into court repeating a mantra, even to the level of screaming, Your Honor, you can't let them have a free house. Your Honor, you can't let them have a free house. That's one of their biggest moral pressures on the judge. Now, here's what you got to think about. That counsel is representing a lender, pretender lender, who did not loan a nickel. So who's really getting the free house?
They are.
Exactly, it's a reverse. Now, here's the other thing you've got to think about. Most people put, a lot of people 100% financed, but a lot of people refinanced, and so in other words, a lot of people actually had some equity in their houses, either a down payment, or maybe they made mortgage payments for 4 or 5 years, they paid taxes, they paid HOA, they did improvements, etc. And a lot of our complaints, when we were in civil court, we would actually add up 3 or 4 years worth of mortgage payments that had been paid, the down payment, the improvements, and all those things. And a lot of times, let's say it was a $500,000 house, something like that. A lot of times, the borrower had actually paid $150,000 to $200,000. If you've made, 4 years of mortgage payments at $3,000 a month, and you put in a pool that you paid cash for, or you paid taxes and HOA, and now that house is no longer worth $500. That house is worth about $200, and the borrower has actually put $200,000 of his cash into it. The pretender lender hasn't put in a nickel. Who's getting the free house? So just let that give your moral conscience a little bit of resting room. That's what we're going on. Back to Charles.
No, that's going to come up.
I just want to know what the plan looks like when you come out the other side of the motion to lift stay.
See, no.
Big smiles.
I would rephrase that a little bit. If the judge, you got to read Veal.
Okay.
And you'll read this. You'll read that a denial of a motion to lift stay is not res judicata, but a sustaining of an objection to proof of claim is res judicata. Now, for all the non-lawyers in the room, here's what that means. Okay. Veal held that the denial of a motion to lift stay is not res judicata, Judicata. However, the sustaining of an objection to proof of claim is res judicata.
Can I define that? Res judicata means already decided.
What res judicata? It went too fast.
What it means is that
No. The second thing you said is res judicata.
The sustaining. You hear about objections in court, are either overruled or they're sustained. If an objection to proof of claim is sustained,
I know somebody in...
it is res judicata. Meaning that, let's say that, here's an example. It used to happen back in Minnesota when I practiced tort law back there all the time. Somebody would get in a car accident, they'd be personally injured, and their car got banged up at the same time. Well, they thought, I'll just go into small claims court and sue for the property damage. Well, they didn't hire a lawyer, not allowed in small claims court in Minnesota. And they screwed up their case, and they didn't put in evidence the right way and all this stuff. Things just went bad for them, and they lost. Now they go and they sue the guy again for the personal injuries, right? Res judicata, a thing decided. It has three elements: the same parties, same issue, and a final judgment. You only get one bite of the apple in court. That's why I can't emphasize enough here today that if you people are doing things, or know lawyers that are doing things that, well, let's start this thing in state court, and then if it goes bad, we'll try to get in bankruptcy here or something. Problematic. Big time. Because if that thing goes south on you in that non-bankruptcy court, and you want to extract yourself from it, you know what you got to have? Some real nice guys there who are counsel for the banks who will sign a stipulation of dismissal without prejudice. Without prejudice means you can bring the same claims again. With prejudice is, only idiots agree to it, usually issued by a court in an order that says, you are done, this is over. You can never bring this back again. Without prejudice means you can bring it again if you bring it within the statute of limitations. So you should really pick your court very carefully. I'm not pretending to be up here saying that it's bad to go into a state court or a federal court in any other state other than Nevada, because I don't know that it is. I've seen some bad rulings out there. I've seen some good rulings out there, like the Ibanez case from Massachusetts, etc. But that is very important to know. So I know you had your hand up. You had a question a while ago.
Charles, can you repeat the question after they say it? Repeat it on the mic.
Yeah, okay. I see what you're doing. You're taping it. But there was another slide up there before I was going to talk about. Okay. The second bullet point there, like we're talking about, you're going to get hit with this motion to lift stay. Well, when you only have, it's Nevada here, they're going to set it for about 30 days out. You have to file that opposition 14 days before that hearing. Now, with your other busy practice and all the stuff going on, it's got to be filed. And it's got to be filed in the right way, and it's got to make the right arguments in the right way. You have to have, like, a lot. I mean, hours. I mean, weeks. I mean, what people go through to find the right law and marshal it in the right manner to draft a proper response or opposition takes a lot. And you should not be doing these things or challenging these real estate debts in court unless you're ready to hit them with a very, very well-polished opposition. It's going to come at you 14 days after you open the mail, or you get it on your computer through the electronic court filing system.
If I can just add to that, so when we take a client, when we're talking to a client that's going to come into the practice and file a BK and everything, we don't wait until that motion to lift stay comes. We go immediately and order the Bloomberg audit and the securitization audit and start getting, you know, we're doing all this in anticipation, because what Charles is saying is if you have a busy practice, 14 days is not enough. So you have to start as soon as that client comes in. Some of the first monies that the client pays is for the securitization audit, and we want to then look and see if we have a good case or not. And that has to be determined, and then you put the time into it.
And it includes weekends.
Yeah.
Okay, yes.
Have you ever had a securitization audit and the affidavit challenged by the other side?
Oh, yeah. Yeah, big time.
So what happened?
Well, we have only had one hearing where the auditor we were using was going to testify, and then the judge just delayed everything. We had flown them all the way in here and everything, but they, what happened on that hearing is the banks are famous for doing this last minute stuff that they want to delay the thing on if they feel they're not completely ready. And they succeeded in doing that in that case because they took the deposition of our client. The evidentiary hearing was set back in November. They were allowed to do discovery in the interim. Waited 2 days before the evidentiary hearing to take our client's deposition and claim, surprise, 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 she's claiming all this stuff. We thought she'd admit her signatures on the note. We thought it was a done deal, you know, wow, you know, we can't do this. And they also filed a motion in limine, they called it, to exclude the testimony of the securitization auditor. It would more realistically be called a motion to suppress. Well, the judge just took one look at that, they filed, just said denied, move on, you know, filed too late. But to address your question, they're never going to exclude that testimony absent late disclosure. The judge is going to allow it if that person has the experience to do it. That usually requires testifying before. That's the most important criteria on there with an expert is, has this expert's testimony been admitted in court before? And you can get into, like, if you're aware of the cases like the Daubert issues, like, has the expert's analysis and research been peer reviewed? Is it reliable? Can he bring a laptop to court and show everybody the process by which he made these findings? That's another very good point that raises that you want to try to couch a lot of what your securitization auditor is coming up with in terms of a factual finding, not an expert opinion. A factual finding will get into evidence a lot quicker than an expert opinion, okay? So a lot of the things from these searches are just factual finding. Fact, I found the note in this trust on this day. It's a fact, it's not an opinion. It's just that it requires specially licensed software to discover that. That's the part of the expertise about it. Yes?
How do you get around, how do you collect your money for all of this before the bankruptcy is filed? And how do you, is it the trustee gonna claim that you've charged too much, or if they are gonna pay you later that it's a debt that's gonna be discharged, or is there something like that, some problem like that with the money?
Extremely good question. It's more of a general bankruptcy question. I might defer to Aaron a little bit on that about.
Yeah, basically it goes both ways. You can have an upfront retainer for a certain amount for initial work, And after that, you have to make an application to the court to be employed, and then the trustee and the judge approve your payments. So you can take whatever retainer you can afford, the plan can pay you upfront, and then remaining can go through the court.
What about the cost for the securitization report and all that?
Those will be included in your application for a reimbursement with the court. So that will be paid through the plan, Chapter 13 plan or Chapter 11 plan.
Yeah, but he said you'd have it before you file bankruptcy.
Well, a lot of times before the person is filed, we would have them do the research. So, and there may be some vulnerability that the court would want to call that back. We've never had that happen. The person is usually paid for the audit, 2 or 3 weeks before they file for bankruptcy, probably, and it takes a couple of weeks to get the audits turned around, I guess, normally, unless it's really something hard to find. But typically, it's just an expense that occurs before the filing, and so far we haven't had any problems with it. I wondered at this point, do we want to bring up Quentin and Terry to talk about the audits a little bit? They want to,
sure.
This might be a good place to insert that. So kind of keep your train of thought. We're going to go back into this area. The question over here, sir?
Just a brief one. I think Charles mentioned he had some citations. I was wondering if we could get those before he finishes.
Oh, sure. I brought a couple of briefs I've written lately, and I think I just want to hit some of the highlights. If I talk about a concept or a name that somebody doesn't recognize, just let me know.
Charles, some of those may be in the PowerPoint later.
Oh, okay.
If we can hold that, because I think we're going to cover it later, but let's go ahead and get TRA and Quentin, get their input, and then we'll go back with Charles after that and talk more on this. But I think we need to get their input to kind of round out the picture a little bit. Go ahead.
For this time, I'm going to present our Level 3 Bloomberg audit. Again, I'm Quentin Murray, Certified Principal Loan Auditors. In the essence of bankruptcy, I guess what I'll do at this time is just go through the securitization audit as evidence as it be presented in court. So I'll go through all the components of the actual Bloomberg audit itself as it is compiled due to the research of our auditors that we have on staff. Yes, sir.
Quentin, just briefly describe what a Bloomberg audit is for those who may not know.
Sure. The Bloomberg audit is an audit of the deed and trust separation thereof, the bifurcation of the deed and the note, using Bloomberg research. So the Bloomberg terminal, most mortgage-backed securities, as well as any publicly traded security shows or reports to Bloomberg. So we use the research and evidence that we found in Bloomberg to substantiate our reports. So, and you'll see in this report as I go through it exactly how that correlates and what that looks like as an actual report. Okay? So I'll go ahead and get it started. In our Bloomberg audit, a lot of our clients do private label, but those who are representing their clients more closely, they will use our branding. So in this particular example, we have Certified Forensic Loan Auditors on the cover page as the outside third-party independent researcher. We will, in many instances, when the clicker is properly functioning as such, we will have it drafted on behalf of the client, which actually was prepared for the audit recipient. That will be the actual attorney that is requesting the audit. So if you prepare for them on behalf of the homeowner, Mr. and Mrs. John and Jane Doe, it'll outline the subject property address, as well as have the disclaimer that we are a third-party research entity and we prepare the actual report on behalf of the lawyer. On the first page, we show all the transaction details. So we show the borrower and the co-borrower, their current address, if not the subject property address that the loan is being done for. We also show the transaction participants are everyone who was involved on the day of the closing of the loan. So we'll have the mortgage broker, when appropriate or when applicable, or when we know, the actual servicing company, in this case is Select Portfolio Servicing, MERS, they have been nominated as a beneficiary, the original lender and or service company here is First Franklin, the mortgage trustee, which is Old Republic Title Company, and the actual title company itself. In the next portion, we show everyone who's involved in the securitization process. So this is a process when, again, I believe Mr. Christmas spoke about earlier, securitization is perfectly legal when done in proper courts. When there's a true transfer deed note A to B, B to C, C to D transfer, that's perfectly fine. What we find in most cases, or many cases in loans between 2001 and 2007, that A to B to C to D transfer was not followed properly. So in this page, we identify everyone who was involved in the securitization process. So the first, you'll see First Franklin, they're the A, they'll be the actual originator and our lender. The sponsors, Lehman Brothers, they are the people who actually set up the trust, or the actual investment house who established the actual trust. C is the Structured Asset Securities Corporation, they're the depositor, and they're actually responsible for creating the actual certificates. The issuing entity, I'm between pages there. The issuing entity in this case is First Franklin. That's the actual remit or the actual trust that the loan or the note will end up in. U.S. Bank Association, they're the trustee. They basically handle all the paperwork on behalf of the trust. And the servicing company, of course, the Royal Loan Servicing, collects all of the payments. You see we have the cutoff date identified here, September 1st, 2006. That's the date that the loans or the actual notes can start coming into the trust. And the closing date is September 25th. That's when no more notes can come inside the trust. What we found in the past. A lot of notes have gone inside of the trust after the cutoff date. They do have a 60 to 90 day, period to cure, but sometimes we found them years later. Trust that was created in 2006, and then the note finally been placed in 2010, just for an example. We also.
Why did you say there was a 60-day lag time that's admissible?
It's a notice of right. Basically, they get a right to cure, so they can still not necessarily put any more notes in, but make sure all the proper paperwork has been transferred in properly within 60 to 90 days of that final cutoff date. Okay. We include the prospectus, and the prospectus essentially outlines that the deed and the note must travel together. You can actually see that here in this line. They must be delivered to the custodian on behalf of the trustee according to the agreement, just showing that the note and the deed must travel together. So we'll have the entire prospectus in there. If we go down to page 5, we'll see we also cite the 4245B, which is the actual prospectus, and leave a link there in the event that the judge or the opposing counsel would like to go in and actually view the prospectus as it reads in its entirety. We also include the pooling and servicing agreement. We heard people call the pooling and service agreement, of course, the Bible of the securitization process. If things are not obeyed inside the pooling and service agreement, it can ruin their REMIC status, and then they have to pay tax for it. Mr. Christian spoke about that earlier in his presentation today. So we include sections 2.10 and section 2.02 of the pooling and service agreement, which pretty much outlines how that actual trust should have operated and how things should come in and out of the actual trust and how they interact with the service company, so forth and so on. Next, we have quite a few pages there. Next is the actual, in this instance, this is the Bloomberg screenshot. This is when we go inside of Bloomberg and pull out the information about the loan. In this particular instance, it's kind of in between pages. So we'll find the name of the trust, the group or original balance, and the loan year and zip code. In this particular instance, this is an exact Bloomberg match. This is the exact loan number of the particular note that we're speaking of inside the Bloomberg terminal, currently reporting to date. It's still inside that trust, reporting and trading actively. So in the time of the foreclosure proceeding, this loan is still trading inside of the trust. So it's identified, we identify the actual trust, which groups that particular loan has been fractionalized into or placed into, the original loan balance, and the zip code of the actual property address. So that's all the loan level data. And so essentially we positively identified this particular note inside of this trust. So there's no gray area, it's in there, we know it.
What is FXML? Is that a New York Stock Exchange, what it's traded under, or what does that mean?
That's the actual name of the trust. That's the initials of the actual trust that is there.
Oh, is that mortgage, whatever? Is that a New York Stock Exchange, the symbol that it's traded under in New York Stock?
No, actually, that's just the actual abbreviation for the actual trust that it's in. We'll go on a couple other pages. We'll show the CUSIP numbers. We'll be able to see where they're actually traded on the New York Stock Exchange. That'll come in a couple of pages here. Here again, the loan level data. This is again us positively identifying the actual loan inside of the trust. Again, that's the loan number. That's the current balance of the mortgage. This was the original balance and the groups that it's trading in. It actually shows what type of documentation that was used when the loan was originated. This was a limited doc. You see some of them full doc. It shows the geographical region, which is Nevada. It shows the occupancy, which is owner occupied. Again, the actual zip code, and it's in Las Vegas, Paradise, Nevada. So the actual physical location of this particular property. Yes, sir.
What is the difference between a limited and a full doc?
A limited and a full doc, and it's probably all about how the loans originated at that time. You know, there were a lot of stated loans going on in 2001 and 2007, so limited documentation will just show that possibly identifying that was possibly a stated loan. And in this case, you see it's a limited documentation. That might actually help the case that they didn't have full documentation when they actually originated this loan.
Okay, thank you.
Yes, sir. Now here's the important part. This is where we show that the actual, now the note itself was fractionalized and placed into several tranches. And this one, I believe this loan is in 19 out of 20 asset classes. So they took the $340,000 loan and they divided it across several asset classes. And they kind of do that to blend the credit ratings and to make the security more marketable. So instead of saying, you know, you may have a limited doc loan where that person may have a 690 credit score, as opposed, and that may be, you know, B or C paper, as opposed to someone who has a 790 credit score, and that's an A paper loan. So they fractionalize so they can pretty much enhance the credit classes of the actual asset classes, or tranches, should I say. And that can pretty much be defrauding an investor. We're not really here to argue that, we're talking about bankruptcy, but just an added point. And on this page, you'll see the different asset classes. This number here, let me scroll down. This is in millions, so that's $129 million in this one asset class, in this one pool. And this particular loan, the same loan that was identified before, has been fractionalized, and it's in each and every one of these classes. You can actually probably research this CUSIP number. I had a Series 7 at one point in my life, so when I first started working for the company, I went and started researching these CUSIP numbers. You'll be interested to find that most of these CUSIP numbers, if you research them, they're owned by banks that are no longer in existence. So not only do the note holders, the person who actually owned the notes, they're no longer in existence. So the service company doesn't have the standing to foreclose, and the person who owns this fraction of the actual loan is no longer in existence. They can't come forward. Just an interesting note, sidebar that mean
This screen doesn't show you whether they're in existence anymore.
Yeah, you have to go, you can Google this CUSIP number, and it'll show you which all these CUSIP numbers may be owned by different entities. So this one may be owned by XYZ Bank, the other one ABC Bank. You can actually look at it and see who owns it and what their current status is. That'd be very tedious work to do. It's just interesting information. I thought it was fun. So the loans again spread across all these asset classes. This is the security description. So they actually show a description of the security itself. This is again, I think this leads back to your question. I can't remember your name, you want a book. With this definition, this is the actual trust, the FML 2006 FF14A1.
Mortgage.
Thank you so much, First Franklin Mortgage. That makes so much sense.
Which is the issuer.
Which is
the issuing entity.
Which is the issuing entity. And it just describes it. It shows the rating of the actual asset class now has a triple C rating on Standard & Poor's, Moody's CAA3, and Fitch overall rating is a C. So this actual trust has a C rating. What else to show? Show the different coupon payments, the payment dates of the coupons to the actual investors, and a lot of various information there. Okay, this is again the group description, more information about the actual description of the actual trust in and of itself. The collateral characteristics, again, We spoke about this earlier about the full and limited doc. This is another more detailed description of the collateral characteristics. So you'll see the type 2 pools of conventional, first lien, adjustable, and fixed rate, fully amortizing, and balloon residential mortgage loans. It shows what's actually in there. In this Class A, it shows the subordination, spread account, cross-collateralization, overall collateralization of the actual trust in and of itself. Again, the prospectus. This kind of rules out the possibility of hearsay. This is the actual prospectus that we provided. They actually uploaded the prospectus inside of Bloomberg as well. Now here is the actual chain of title, so to speak, where we show the actual securitization process. When done properly, it would have gone from First Franklin, Party A, to Lehman Brothers, Party B, to the depositor, which is Structured Asset Securities Corporation, Party C, over to Party D, which is First Franklin Mortgage Loan Trust, 2006 FF14. What we found in our research that it did not fall that, it sidestepped that process and went directly from Party A to Party D. This is again the chain of title showing where the deed and the note actually separated from each other or bifurcated from one another. That's on page, we're showing on the same page, page 19. You'll see that on August 1st, 2006, the deed was filed in Clark County, Nevada. And on July 28, 2006, the note holder took First Franklin took the note, and then it was deposited to the trust on September 1st, 2006. We also...
What's the significance?
That's where we actually show the break in the chain of title. Where the note and the deed was separated, where the bifurcation of the deed and the note. That's what we show they actually separated.
You show that in there somewhere?
We do. Let's see. Recorded chain of deed possession. This is where we show the deed was recorded in Clark County, Nevada. The original deed of trust. And then it shows the date that the note went with First Franklin. So that's when they separated.
Quentin, can I just make a comment?
Absolutely.
Just so you keep this in perspective, see, 3 years ago, we knew we were right. We knew we were right. But we didn't have the evidence to prove it. So we'd file a lawsuit, then we'd go to discovery, we'd use my 57-item request for production of documents, my 40 interrogatories, asking questions about everything that Quentin is saying. And we get stonewalled, and and then you got a judge who doesn't believe in your case anyway, and all that kind of stuff. So it was really tough sledding uphill. Now, since we have the ability to use the Bloomberg terminals and the securitization audits, and I knew 4 years ago when I started, and I said, I need to find somebody who used to work on Wall Street, who knows how to manipulate these databases to find that, everybody says, where's the note? Well, somebody knows where the note is. And then, just about a couple of years ago, maybe even less than that, maybe a year and a half ago, the Bloomberg audit, you can use Bloomberg, you can use ABS.net, you can use Reuters. There's many different financial services. The Bloomberg seems to be the most used and perhaps is in some ways the better one, but we can really get all this information on the front end. And it's like, as I said to somebody earlier today, in the old days, we took a gun to court and we had to use discovery to get the bullets from our opponent to shoot him. Today, we take a gun to court and it's loaded because we have all of this done first. So we know what kind of case we've got, we know what the issues are, then we're going to go back and use the crosshairs of the rules of evidence, so to speak. And sort of pull it all together. But I just want to, everything that Quentin is saying, I just want you to get that in context and a little bit of perspective of how much better it is to have all this information available to us now on the front end. Back to you, Quentin.
Absolutely. Yes, sir.
In terms of the splitting of the note, I was here in Nevada at bankruptcy court and actually didn't get to, I had a very simple motion and the judge started asking ungermane questions and which annoyed me. I got dismissed. All I was asking for was a continuance to get more time. But walking out with opposing counsel, he mentioned that Nevada had become very unfriendly to the whole argument that a note was split between the mortgage and MERS having the being the trust of the nominee. Thank you. He said the whole splitting of the note was just being dismissed as trivial in Nevada. So I'm curious if you're talking about splitting the note in the same way, and if so, how can I make that significant before a judge?
Our statute laws.
Pardon me?
Bird just flew in.
Hello?
Yeah.
That's probably, can you just
Briefly phrase that question. I think it's a question for Charles Powell, but
Yeah, I was in...
I mean, without all the history, just sort of summarize the question.
An opposing counsel told me in the elevator going down that the Nevada bankruptcy judges had become very unimpressed with a lot of the arguments that homeowners are using, and one of them was the splitting of the note to behalf of MERS. He said that had just become a loser argument. The guy was sanctioned for it a couple of years ago.
Well, what I would comment to that is the gun is in the wrong hand. See, if you heard what Charles Powell said and what we're going to finish up saying, I mean, you can take the argument, the note and the deed of trust have been split. If you don't know how to use it, it's kind of like just shooting blindfolded. But if you know how to use it, because Charles can take you to case law and to the UCC where you have to have ownership of the note and the deed of trust both, not just one or the other. And we know they were split. So there's a difference between shoot west and when you shoot west, hit the bullseye. That's the difference. So your guy was, especially if it's pro se litigants who, again, they were kind of on the right trail, but it's like anything. Having a knife doesn't make you a neurosurgeon. It takes a lot of training and expertise.
That's a very good question, and I'll address it later after Quentin finishes. It's a very good question.
Okay, coming into conclusion, or close to conclusion of the actual audit in and of itself, we have a report summary essentially outlining or slightly summarizing for the actual affidavit, which is the next portion that we go through. It'll give you a cursory view of everything that's happened in the actual process that we talked about earlier. So that's what the actual report summary is. Pages, here's what we were able to show that MERS is the actual nominee and beneficiary of this particular notice. It identifies the U.S. Bank as the trustee or the investor for this actual loan, which will help us go back into the actual research. Actually, going to MERS where we start our whole research, because we can start there to find out who the actual servicer is and also who the investor is, and that's how we find out where the actual trust that the actual loan is in. That's the starting point of all of our research, is with MERS. The chain of title conclusion, that just shows where the flow of the money is, where the money went from beginning to end. It is not the most important piece, but it just shows the flow of the money. Page 23 through 27 is case law. I think Ms. Christmas noted earlier that here's what we find. Most time the case law that we have cited, people say, well, that's only for California, or that's only for a particular state, it's not specific to my jurisdiction. And that's true, but we do cite the case law. I believe it might be more useful in bankruptcy court than it is in most others. So 23 to 27 is just different case law, different cases that we found where rulings were made in behalf of, or were made in reference to foreclosure. And finally, we have the affidavit. The affidavit essentially is the auditors showing their veracity of the findings of that actual audit in and of itself. It shows they've been trained, certified, how many years essentially their curriculum vitae in short, and what gives them authority to actually put together the actual audit. It shows the actual loan number that was identified in Bloomberg, all the different parties that are involved in securitization. It shows the loan amount positively identifying this actual loan was inside of the trust. There's also the screenshot to show the different asset classes this loan was inside of and how many of them have been paid off. And this one again, there was a total of 20 classes. Out of the 20, this is a very special case, 19 of the 20 classes were paid off. So essentially, I guess you could argue the point that, okay, so they say, well, you're right. we don't own the note. This person owns the note. Then you say, well, that person don't own the note, but they've been made whole to the tune of 99% in that particular
Already
argument.
owe 5% of this 19 out of 20.
That's it. We write you a check for $17 and we'll call it that. You could argue that. And then they'll be signed. We also know now that they're signed and notarized, signed in blue ink and notarized. So all of our audits are now court admissible. And that concludes the actual Bloomberg audit report as the tool to be used in bankruptcy.
Let's take about 5 minutes for questions on the audits then.
Sure.
Okay, so you've got a CFLA that does the audits, and so this Arthur Bernardo is somebody who will come into court then?
We do offer expert witness testimony. Our auditors are available for expert witness testimony.
And it would have to be by the auditor who did this, right?
It will. In most cases, well, it doesn't always have to be by the auditor that did it. Now, we do have different people that we use for expert witness testimony as well, who will stand by, they'll double check, and if, they deem the audit, that they can offer expert witness testimony to the audit, they will. So it doesn't always have to be done by the actual auditor who did it. It just has to be done by someone who is certified as well, who will stand behind the findings of the audit.
Now, I've seen like your price list on the various different audits. Can you give us an idea of like what CFLA charges to send an auditor in to testify?
For the auditor to testify, but we can talk about that one off if you want to catch me. And the only reason we do that is because we are business-to-business wholesaler, and party A may do 40 files a week and party B may do 1, and there's a difference in pricing. So instead of saying a set price in the air in front of everyone, and I don't want to get calls to carpet saying, we told me that it's going to be $7,000. I'm sorry, it's 12. So if you just catch me after class, I'll be more than happy to discuss the price of the actual audit. Yes, sir.
What's the difference between you got different levels here? What is that?
Yeah, we do. We have a level 2 securitization audit, which is essentially everything you see here minus the Bloomberg report. So it's the exact same premise, but without the findings from Bloomberg. Not all loans are in Bloomberg. There are certain entities, your Fannie Mae's, your Freddie Mac's, they do a different type of filing. They don't file according to the regular laws of the land. So they don't report to Bloomberg at all.
Are you able to find the information from like Fannie Mae and Freddie Mac in regard to that? Or?
We are, but those audits are, particularly when you have a Fannie Mae and Freddie Mac, and what I've learned, I'm not an attorney, but after talking to attorneys and getting Fannie Mae's and Freddie Mac's back from auditors, they're better used in bankruptcy court because they'll say, well, you can't prove to me that it went to a particular trust because they don't report. Well, through discovery, through bankruptcy, now we can kind of force them to show us where it is. They have to if they're going to prove they're the actual creditor.
What about situations where you can find that it went originally, like back in 2003, to a pooling and servicing trust, but then how does Fannie Mae get it? Like in a situation like, at one point One West was saying, claiming to be the person who was entitled to collect the debt, find out that they're the servicer. So then upon doing, QWR or whatever through discovery, they do admit that no, Fannie Mae's got the note. But then you do an audit and you find out that originally, back in 2003, it was securitized into a pool. How does Fannie Mae then get the note?
It's rough because of the way they report. Fannie Mae's and Freddie Mac's are the hardest audits for us to do. And we admit it. When one comes in, it's going to take almost 2 to 3 weeks. Those are harder. They're harder nut to crack, for lack of a better term. My short answer is I'm not 100% sure.
I mean, is it possible that
It takes a certain level of security clearance to have access to the Fannie Mae and Freddie Mac documents, and so that's why not just anybody can do those kinds of audits. I mean, you've got to have somehow an end to find that information typically.
I mean, is it typical where...
Go back with Charles Powell, and this is where we're going to be able to cite a lot of cases for you from the bankruptcy courts. Charles, you want to pick up here?
Yes.
I think you had a chance to look at it, so try to make sure they don't fall apart. I didn't know.
Yes, thank you. One gentleman there was curious about some legal citations and all that, and that's really the guts of why you really go to one of these seminars, is to get some useful material that you can use in future cases. So, you want to handle the flipper?
Okay.
Go to here.
So, I've got to change PowerPoints here. I've got to take theirs down.
First of all, is the gentleman in the room that asked about the split the note issue? I think he is. I think he's plugging in. Yeah, I want to address that.
Yes. Carpenter v. Lonigan was one case I know of.
What's that?
Carpenter v. Lonigan was a Supreme Court case which was tangentially relevant.
In Nevada?
No, Supreme Court. That was like, it was like 100-year-old.
Oh, Carpenter v. Longin. Right. Carpenter v. Longin. Yeah, I'm aware of it.
But I'm not sure how relevant it is. You know,
Yeah.
how much I can get out of it.
Right. Here's the whole story on that matter in a nutshell. And you're going to see it when we go through some of the PowerPoint slides that are going to come up. But it is most relevant of an argument when Mears is involved. Is there anybody in the room who isn't familiar with what Mears is, who they are? Everybody is. Okay. Mears, are you familiar with who they are? Mears, perfect. Okay. Right. Now, okay. Because here's how the split arises in the context of MERS being named as a nominee in the trust. MERS can legally transfer a deed of trust. MERS cannot legally transfer a note. It's reversed in the materials and we're going to correct it. So, the Agard case that we're going to see.
The microphone's up.
Yeah, it's going up and off, on and on.
I don't know why. Is it on? Okay. Try to keep it close to mine. Close to my lip. It is going on and on.
It's off right now.
I can put a fresh battery in it. I don't know if that's...
Or another microphone.
Yeah, where's the other? Oh, it's over here. Sorry. Do you want to speak from the lectern?
Sure.
Okay.
In the context of a MERS case, where MERS is named as the, they call it a nominee / beneficiary in the deed of trust, you'll see that. Okay. Courts have ruled they're not a beneficiary, but they are a nominee. What is a nominee? An agent. Okay. So an agent can always act on behalf of a principal or a master. Now, MERS can assign, that is transfer, a deed of trust. MERS cannot transfer a promissory note. Because a note can, and the courts have uniformly held this, there is no dispute on that. Because a note has to be transferred by negotiation and delivery. Negotiation means proper endorsement and possession. Everything in this whole arena of UCC Article 3, the Uniform Commercial Code, Article 3, is who's got the ball, okay? Who's got the possession of a properly endorsed note? That person is called a holder. And you can't be a holder in due course. That's who can enforce the note, unless you're a holder. Okay. So, some of the significant cases I wanted to run through, I'll try to combine it with the ones that we have on the PowerPoint, but I think it's probably easiest for me to go through some of the case law, and if you want to get a cite from me later, just come up and ask, or it'll appear in the PowerPoint later, the exact cite. But I'll talk about the cases that I talk about these are some of my actual briefs. Here's a combination brief that was an objection to a proof of claim and an opposition to a motion to lift stay. And the relevant rules and statutes and cases are these. Everything in bankruptcy in the federal statutes is under 11 USC, 11 United States Code. It's all there. The first one that's very interesting is 11 USC section 502 lowercase b as in boy 1. That's where you try to hit a home run and get the court to rule that this debt is unenforceable against the debtor and the property of the debtor. So what these assignments do as relative to the split the note argument is when MERS gets in there and assigns some paper, you'll often see, if you look at a lot of these, that they purport to assign not only they'll call it the beneficial interest, right, in the deed of trust. Sometimes they'll say together with the note. That's just harmless surplusage. It's just excess baggage that doesn't mean anything. They can't transfer the note. So it's that assignment document that you argue splits the note and the deed of trust. Now, it's true what the gentleman with the laptop was saying, that there's a real issue in the state of how it's going to go. No one has addressed it yet. No one has needed to address it yet. Courts won't answer questions that they don't have to. And they're most assuredly not going to go out on a limb and give the general public what lawyers call dicta. Just an extraneous statement isn't necessary to decide in that case that might haunt them later. There's a case called Levia. I think it's L-E-Y-V-A. Levia. Okay. Whatever works for you. And that was decided by the Nevada Supreme Court in July of 2011. In footnote 7 of that case, it specifically said we're not addressing or ruling on the argument about splitting the note and the deed of trust. So it's important to understand how those two documents work in conjunction with one another. The deed of trust is the security. The note is the promise to pay. Now, if I only hold a note, what have I got?
Non-secured debt.
Depends on the wherewithal of the debtor. If I can't get blood out of a rock and that debtor's a rock, I ain't got nothing. I got an unsecured debt. Now, if I only hold the deed of trust, the debtor can never default. Because the debtor only owes money to a proper holder of the IOU, the promissory note. So it's very important that those things, that there be unity between them, that they not be split, and what securitization does, when it's articulated to the court properly and if bought by the courts, this argument, is that this whole scenario of MERS getting involved, first of all, the note getting sent into a securitized trust, next, 3 years go down the line and everything's hunky-dory because the borrower is making the mortgage payments. All of a sudden, they're not making the mortgage payments. Then what happens? They will purport to assign that deed of trust to the trustee. But they've split it because two ways. First of all, it doesn't go simultaneously with the note. And if you look at your standard form deeds of trust in Nevada, for sure, no doubt, and I think California, paragraph 20 says that this security instrument may be transferred, quote, together with, unquote, the promissory note. So you use that language to your advantage. Because they right there are establishing that there has to be unity between them.
That was paragraph 20 of what?
The standard form deed of trust. The case law that's important on what must be shown is, first of all, there's a case called Kemp. That was an adversarial proceeding. These aren't shown in here. I'll give these cites to them later, but this gets into burden of proof, and this is very important to emphasize, that it's the maker of the note may properly press, that is, force the other side to establish its holder status. In re Agard says that what the creditor must show is that it holds both the promissory note and the deed of trust. And that's just to get a motion to lift stay. They also have to show that they would have established prima facie that it is good enough to win their case, absent evidence to the contrary coming in. Evidence if they attach to their proof of claim a properly endorsed note. Like I said, they rarely do it. I've never seen one of them. If they don't do that, then it's the cases and the rules are, the bankruptcy rules, you'll find these in, is 301F. That's F as in Frank. A proof of claim that lacks the documentation required by Rule 3001 does not qualify for the evidentiary benefit of Rule 301F. It is not prima facie evidence of the validity and amount of the claim. That's a Ninth Circuit bankruptcy appellate panel case in re Heath. It's like a Heath bar. Another very important case that comes up in these matters is these are all bankruptcy cases too, so they're all important.
One of them wasn't enough. Which one was it again? In re Heath?
In re Heath is a Ninth Circuit bankruptcy appellate panel case 2005 that holds if the proof of claim does not contain the required documentation. Example, has a deed of trust, has an assignment, has a note. But there's no endorsement to that note. There's no allonge to that note. That is not the required documentation. That does not prove that you have the power to enforce that note. It must be endorsed. What that establishes in the bankruptcy proceeding is that now the creditor has the burden of proving that it owns both the note and the deed of trust. And you, in connection with filing the objection to proof of claim, can sit back and do what I've always called a chip and pick defense. You just chip and pick it the way at the other side, at their evidence that you try to put in. Raise those evidence rules that I stated earlier for the witnesses on the stand, and they won't be able to get those documents into evidence, in all probability. In re Wells, that's going to come up, that's W-E-L-L-S. It's a bankruptcy case. Doesn't matter what state it's from because these are all federal cases within the United States. It holds a couple things. First of all, it holds that the relevant time frame for someone to show that they are in fact a proper holder of a properly endorsed note is at the time that the proof of claim is filed. Kemp has the same ruling. But as In re Wells points out, it says, when a claim is not prima facie valid, why? Because they didn't send in an endorsement. All the debtor need do is only object to the claim and place the burden of proof back on the claimant. Even if the creditor responds to debtor's objection, which they often do, all of a sudden magically they come up, they appear with this endorsement. Oh, Judge, in another file, we got it now, attached it to our motion to lift stay. We attached it to our response to their objection. Even if the creditor responds to the debtor's objection, the creditor carries the burden of going forward, this is an important distinction, as well as the ultimate burden of proof to establish its claim at the hearing on the substantive objection. When we go to law school and we go to bar review, we hear about two concepts. When you're in the general public, you hear about one concept, burden of proof. When you go to law school and bar review, you hear about two concepts that break that apart. Burden of production and burden of persuasion. If somebody has the burden of production on the matter, they can, like in a proof of claim situation, attach a properly endorsed note, and they've done enough to get to the jury. They've done enough to get to the judge. They've done enough to keep their case going. The other side, of course, could come back and defeat their proof and win. But if you have the ultimate burden of persuasion on the issue, then you must prove in a civil case by a preponderance of the evidence that your claims are more likely true than not true. What does that mean? You take a teeter-totter, and if it just elevates or just declines ever so slightly on the other side, that's it. You got to prove by 51%. So these are important because they establish who has the burden of proof. Then, although different notes might not be a, quote, negotiable instrument because they have too many conditions to it, many of them are a negotiable instrument, and that's where some of the good case law in Nevada comes in, like Levia and Pasillas, that's P-A-S-I-L-L-A-S. And then what you want to do, which will be aided by a securitization audit that shows so-and-so is the trustee here, is you want to allege that this creditor who's making this motion to lift stay, this creditor against whom I'm objecting to the proof of claim, doesn't have standing to break this claim. Standing in bankruptcy court means right to payment. If you look at the language on a proof of claim form, it's a standard form. They just pull it up on their best case software and just insert the information into it. It says right there, the claimant, it says the person to whom money or property is owed. Okay? Now, if this loan was securitized, sold early on in its lifespan, it's not still owned by the creditor who's going after you in all probability. I have seen a couple cases where the trustee of the securitized trust will be the claimant, but not often. So you want to raise a standing argument on it. There's the Rosenberg case that says in loan securitizations, the real party in interest is the trustee of the securitization trust, not the servicing agent. And what you're going to see in a lot of these cases is it's a servicing agent who's bringing the claims against you.
You find a lot of times they're signed by the attorneys.
Yeah, sure. Yeah. You know, you'll often see affidavits signed by attorneys that say, oh, well, this is a true and correct copy of the note. Well, I got numerous problems with that. Not the least of which is the rules of professional conduct. Counsel shall never place himself in the position of being a witness to the case. Otherwise, guess what? Get out of here. You're disqualified. You can't be a witness and counsel at the same time. Second of all, they have no personal knowledge. They have no personal knowledge that that's a true and correct copy of the note. Not at all. These alliances, these extra pieces of paper upon which alleged endorsements are written. The way the Nevada statute reads, at least, is endorsement means a signature on an instrument. And for the purpose of determining whether a signature is made on an instrument, a paper affixed to the instrument is a part of the instrument. I'll just give you the UCC numbers on these statutes, and you can find them in your state accordingly. That would be 3-201. Interestingly, Black's Dictionary defines affixed as to fasten onto it permanently. So when you see these people taking these, you'll often see a lot of times in a case, you'll see a note, it's got a 2-hole punch to it or something, and you'll see an allonge, and there's no 2-hole punch. Now, were they together? There's a case, in re Weisband, bankruptcy case out of Arizona. It holds this. It was a situation, and this occurs so often. It holds this. Where the creditor files a proof of claim, no allonge, no endorsement. And then later on, files one, files endorsement, files allonge. Weisband held that when GMAC filed its proof of claim, the endorsement was not included, which is further indication that the allonge containing the endorsement was not affixed to the note. So if these things are together, it's not a true and correct copy. People want to call these things technicalities? Go ahead. You're dealing with somebody's home. You're going to kick people on the street, and you're not doing this paperwork right. Yes, sir?
Could you spell that case for us, please?
Yes. Weisband is W-E-I-S-B-A-N-D. Bankruptcy case out of Arizona. And again, I'll be happy to share any of these sites with anybody after the session here. Then what you want to do is you want to attack these allonges. They're often, I've never seen one dated. Again, you want to contrast them with the deeds. Always dated, aren't they? Assignments, always dated, always notarized. Notes oftentimes have a signature name affidavit page, notarized. Undated allonges, legal documents purporting to transfer the right to enforce and payment on $1 million debt. I mean, I think these people would look like clowns if they really came into court and a good cross-examiner got after them, which they should. Again, it's the In re Wells case and the Kemp case that a creditor's standing to file proof of claim for pre-petition debt must exist at the time the claim is filed. Okay? And you relate that to the business record exception to the hearsay rule, and these undated allonges of which these people are probably in this building, and that's all they do all day long is sign paper. It's very unlikely they're going to be able to credibly prove that that alleged allonge was made before they filed the proof of claim. First of all, they probably don't know when the proof of claim was filed. So you could hit them that way, then just pull it out later that, well, I want to ask you to assume. The court could take judicial notice of its own records of when that was filed. Okay, here's information about this separation of the note and deed argument that would render the debt unenforceable. Okay, here's another way. We had this happen just the other day. The first statute that I read you out of 11 U.S.C., whereby what you're going for is the grand slam on objection to proof of claim, a ruling, a holding that this debt is unenforceable against the debtor and the property of the debtor. You can skin that cat in a number of ways. First of all, if they fail to file their proof of claim within 6 months of the filing of the bankruptcy petition, they're out. It'll be disallowed as untimely.
Say that again?
If a creditor, if an alleged creditor, does not file a proof of claim within 6 months of the date that a bankruptcy petition is filed, they're out. It's untimely. You should then, in that event, take the bull by the horns. Nothing happens in the legal system falling out of the air like manna. You got to assert your rights. File an objection that any proof of claim they would even try to file at this time would be untimely and disallowed under Section 9 of that statute. But this is the real nuts and bolts of the separation of the note and deed argument. It's the in-re. Okay, it starts off a lot of times. You don't have to have mirrors in your case to do this, but having mirrors in the case really helps. Because again, they can assign a deed, they can't transfer a note. So when they assign the deed, they split them. But as the In Re Agard case holds, it says this: while it is generally true that a mortgage travels a parallel path with its corresponding debt obligation, and in saying that, it cites the Carpenter versus Logan case that this gentleman discussed earlier. The parties in this case have adopted a process which by its very terms alters this practice where mortgages are held by Mears as mortgagee of record. By Mears' own account, the note in this case was transferred among its members, while the mortgage remained in Mears' name. Mears admits, that's the admission by an agent now, Mears admits that the very foundation of its business model, as described herein, requires that the note and mortgage travel on divergent paths. You know, when you talk about evidence, like in seminars where you go to trial school or whatever, you know, you might hearken it back to, I don't know, it used to be up in the North Country anyway, this old beer commercial, like old Milwaukee, I don't know what it was. But these guys were sitting around this campfire and they're going canoeing. It was the end of a day, it was Miller time or something. They're going, you know, the scenery was great and everything. You know, it doesn't get any better than this. Let me tell you something. Evidence does not get any better than the admission of a party opponent. It does not. Why? Because that's a confession. And moreover, an admission is substantive evidence. That is, an admission can carry your burden of proof. It can establish the issues in your case. If you were to do a car accident case, for example, was the defendant negligent? Yes, the guy in the stand. Well, do you think he could have drove a lot more careful than he did that day? Yeah, I was really careless. You can use that one statement in that trial to answer yes on that jury form, he was negligent, and that gets held up on appeal. It's the strongest evidence you can get. So Mears, by being a nominee in that deed of trust, is an agent. And where they say that, it's pretty devastating. So, there's lots of good tidbits you can get off of Mears' website and stuff too regarding these matters. One page that I've used in the past, this is right out of Mears' manuals that they distribute amongst its members. And who's not a Mears member? I don't know. I think they all are. But it says this: Mears cannot transfer the beneficial rights to the debt. The debt can only be transferred by properly endorsing the promissory note to the transferee. So there's Mears right there, saying that all they deal with is the deed, not the note. They can only transfer the deed. The note is always transferred by endorsement and delivery. This is the language out of Veal. And in Veal, it is dicta. And Judge Markell put it out there. A lot of times, no judges will not write any dicta in a case. Some will, though, just to kind of like put it out there and look like a maverick in the area. They don't decide the issue. They don't rule on it. They just note that this is contained in leading treatises or authority, and then they watch the issue percolate and develop up through the other courts. But the issue is not squarely presented to them in Veal. But it says this: under the common law generally, the transfer of a mortgage, it's the deed, without the transfer of the obligation it secures, it's the note, renders the mortgage ineffective and unenforceable in the hands of the transferee. That's right out of the restatement of property. A mortgage is unenforceable if it is held by one who has no right to enforce the secured obligation. Said another way, in the terms of the paper we deal with, a deed of trust, the security, is unenforceable if it's held by one who has no right to enforce the note. When the note is split from the deed of trust, the note becomes, as a practical matter, unsecured. Again, citing the restatement. Additionally, if the deed of trust was assigned without the note, then the assignee, the one that it was allegedly transferred to, having received no interest in the underlying debt or obligation, that is the note, as a worthless piece of paper. So, it's pretty strong language. If the Nevada Supreme Court goes down that path, they could decide to do it. I think they'd be mavericks. And I was just talking with a gentleman up here, I believe you in the back, sir, that although that could create a flood of litigation in the courts, and that might be a temptation not to do it, judges might think we're not going to give people, quote, free houses, and that's a temptation not to do it. I'll tell you what, I would solve this whole economy and bring a lot of lenders to the bargaining table. Because there's so many people, there's so many loans in this country where those two have been split. In fact, it's definite preponderance, more than 50%.
What was the citation of what you just read?
In re Veal is VEAL, 450 Bankruptcy Reporter, always abbreviated BR, 897. It's a very long case. That language appears on pages 915 through 16. That's a 9th Circuit Bankruptcy Appellate Panel case, 2011. It was written by Judge Bruce Markell, who's a member of the Bankruptcy Appellate Panel, who is also a judge who sits here in Las Vegas. He is the judge before whom, in fact, we had the, so far at least, total success, where he held these people to the line on the evidence and they couldn't get their evidence in. He therefore sustained our objection to proof of claim and denied their motion to lift stay, but did it without prejudice. He's going to give one more shot. I think the reason he's doing that is this. That case, the creditor alleged, like they always do, if you have not brought an adversary proceeding, that Bankruptcy Rule 7001 provides that you must, if you're going to challenge the validity or amount of a debt, you must do so within the context of an adversary proceeding. Now, he did not require that. So, potentially vulnerable on appeal regarding that, right? But then, in law, you always look for, you look behind the rule. If the reason for the rule doesn't apply, the rule does not apply. You learn that in law school. So therefore, what is the reason for that rule? It's to afford them due process. It's to afford them notice and an opportunity to be heard. It's to afford them discovery, where they can find out about stuff. Depositions, interrogatories, requests for production documents. And the biggest thing about due process is a hearing, a point at which somebody may be heard with rights of appeal. So Markell cuts to the chase and says, look, all these rules are kind of guided by Rule 1 that says All these rules shall be interpreted so as to bring about the just, speedy, and inexpensive determination of every action. We can give them all the due process they need if we just say, hey, how long do you need? Cool in 6 months? Good. Now, in the meantime, you can conduct all the discovery you want, or you're going to appear here in 6 months, and we're going to have an evidentiary hearing. You have a chance for your hearing. You can call whatever witnesses you desire. You can cross-examine all the other side's witnesses. You give an opening statement, final argument, pre-trial briefs, post-trial briefs, the whole enchilada. And so therefore, I think that if he was ever challenged on appeal on that ruling, that the appellate court would say, well, he gave them everything they want, so the adversary proceeding wasn't necessary. Either that or they'd call it harmless error. They'd say, yeah, it was error, but it's harmless because he gave them everything they wanted. So, that Beal case is the one that really gets out there. What it does, in fact, is some of you people may have previously heard of a case right here out of Nevada bankruptcy called In re Mitchell. That was by Linda Riegel, Judge Linda Riegel. She said the same thing there that Judge Markell did in Beal, but she did it in the context of an unpublished decision. Notably, for state court cases and whatnot, Beal was cited by the Nevada Supreme Court in, somebody over there corrected me earlier. Levia? Leyva. Okay. Leyva. And that's a Nevada case, and also Pasillas. Then what, again, my briefs routinely contain is, like I said before, that these people need to produce the original notes and original lodges. You're going to find that requirement in UCC 3-501. Party against whom a negotiable instrument is being enforced is entitled to demand that the claimant, quote, exhibit the instrument it seeks to enforce. Careful on that one. Remember, it's an adversarial situation. So if the other side doesn't bring up arguments, good ones that they have, tough cookies. I walked into the gates at Harvard Law School. The big banner above the walkway into the place said, rights are for those who assert them. So, really, in all these deeds of trust, Lewis and Roca was the law firm here in town to first bring this to my attention, but in all these deeds of trust, they make the debtor waive the act of presentment. That's a term of art in the UCC. Quote, presentment, unquote. This rule that I just read you, where you have a UCC right to see the original, is under the doctrine, under the statute defining presentment. So just be aware of that. But even if they bring that up, you've still got the best evidence rule, the original documents rule, Federal Rule of Evidence 1002. To prove the contents of a writing, the original writing is required. And there's case law backing that up from bankruptcy courts in California and in New York. Now is the guts of where these people, I think, 9 times out of 10, are never going to be able to prove what they need to prove.
Before you go on, do you have the citations for the New York and California?
Yes, I do. You might have heard, because I believe you told me earlier you practice in California. In re Vargas. It's 396. Bankruptcy Reporter 511. At page 520. It's Bankruptcy Court, California, 2008. Pursuant to a commercial code provision identical to that of Nevada. Defining presentment, which the holder must exhibit the instrument. The court held that this law requires that, quote, the person making the demand show its right to enforcement by showing the original of the promissory note. In re Mims. MIMS may have came up on the screen before, I'm not sure. That's New York. That's 438, Bankruptcy Reporter 52, page 56, 2010 case. Again, held that Wells Fargo has not presented any evidence that it is in possession of the original note and was therefore denied relief from the automatic stay. But this is really where, in evidentiary hearings that we've gone to, it all plays out in this section of the brief. Promissory note cannot be admitted into evidence unless it is authenticated. Again, that's Vargas. Federal Rule of Evidence 901A provides that the requirement of authentication or identification as a condition preceding to admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims it to be. So, next, the real big one that they hardly ever comply with is personal knowledge. Federal Rule of Evidence 602 provides that a witness must have personal knowledge of the matter on which that person is going to testify. Otherwise, what's the only exception to that? An expert can give an opinion. The business records exception to the hearsay rule. The exact language of 602 is interesting before I get to that. 602, a witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. So they just can't call a custodian that, well, I have a file and it's in here, this allonge was found in here. Well, did you write the allonge? No. Do you know when it was dated? No. It's not in evidence. Unless they get their documents in evidence, they can't enforce a note against it. Business records exception hearsay rule, evidence 803-6. The first one is the most important. Number one, that the document was made at or near the time by or from information transmitted by a person with knowledge. Again, when you tie in the relevant time that that's talking about, it's talking about proving an endorsement was made by the time the proof of claim was filed. The last one is, that I use, is that we must show that the source, method, or circumstances of preparation must not indicate lack of trustworthiness. What I always try to show is I compare the allonge, or alleged allonge, alleged endorsement, versus the deed of trust, versus the assignment, all of which are precisely dated, notarized, and then this thing just is undated by a bank. Secondly, the suspicious circumstance that when they filed the proof of claim, there was no endorsement attached. Then when you call them on it and say, hey, you don't get prima facie proof, then suddenly, magically, this endorsement appears. So it's untrustworthy in that sense. That's the reason why all the exceptions to the hearsay rule exist, because those matters are deemed to be trustworthy because business records are kept in the ordinary course of business. People rely on business records to make multi-million-dollar decisions, etc. That's about it. Then some of the arguments I'll make in reply. Here are some arguments. Here are some exact quotations taken from a declaration that I helped a securitization auditor who's been in the banking business for 30 years draft. Just quoting about 3 provisions out of his declaration, but they get right to the heart of the matter. I researched the online database at the request of debtor, property located at such and such. Note was identified in Bishopsgate Residential Mortgage Trust, 2007, as required by the terms of this trust and as reported by the trust itself. Debtor's note is now and has been in the possession of this trust since 2007. The import? Well, one note can't be in two places at one time. It can't happen. My research shows that debtor's note has been securitized. Securitization is the process of aggregating a large number of notes in what is called a mortgage pool and then selling security interest in that pool of mortgages to investors. These sales that my research shows took place in this case would have fractionalized possession of the note over many different investors. Again, a very important point. Quentin brought it up earlier. What you're doing here is you're pointing out that not only would the trustee have an interest in this note, the trustee of the securitized trust, but they've taken that note and it's like a mirror and you drop it on the floor and they broke it out into little pieces. Well, you can try to glue it back together, but it'll never be the same. And even the Pasillas case recognized, that was a case brought by the trustee of the securitized trust. That lawyer for that creditor showed up at that foreclosure mediation and admitted that he could not agree to modify the terms of that loan without investor approval. Now, why would that be? Because they own it. And they're not ever going to come. You're not ever going to round up 100 investors out of a securitized trust to be in a lawsuit. They've been paid and everything to go after one little debtor out in Nevada or something. It just won't happen. And finally, this is the most important stuff right here. My research further shows that, first, creditors, move-ins, neither of them had possession of the note when the proof of claim was filed in bankruptcy court on January 31, 2011. Second, when the proof of claim was filed in bankruptcy court, neither of them was entitled to receive payment on the note. And third, when the proof of claim was filed, the note was separated from its otherwise corresponding deed of trust.
Could you repeat those, please?
Sure. The real essence of the case is, and some of these are factual findings, some are opinion, that when the proof of claim was filed on a particular date, the creditor did not have possession. That's it. That's what a holder means. Of the note at that time. At the time the proof of claim was filed, with the exact date and insert that date. January 31, 2011 in this case. Second, when the proof of claim was filed, creditor, alleged creditor, was not entitled to receive payment on the note. And third, when the proof of claim was filed, the note was separated from its otherwise corresponding deed of trust. Excuse me? Oh, I was just reading the 3 paragraphs that I and a securitization analyst came up with that he then acknowledged to me were correct in a declaration. These are facts. What lawyers do is you apply the law to the facts. The law is they have to show that they are entitled to enforce the note at the time the proof of claim is filed. This factual finding / opinion, whatever, states they didn't have possession of the note at that time. Didn't have possession of an endorsed note. Therefore, number 2, they weren't entitled to receive payment on it. It's just, it really gets down to simple, and sometimes for the judges, you really have to put it down in simple terms that everybody understands with commercial paper. If one of you writes me a check and I want to convey it over to Charles, I got to do what? I have to endorse it. And until it's endorsed, he can't enforce it. It gets that simple. These people are coming into court with these notes that are really owned by other entities, other investors, other people, and they're trying to enforce them against these debtors and trying to kick them out of their homes when they really should be doing the paperwork right. I think I covered why, in contesting, they'll always, this is my reply brief, they always say that an adversary proceeding should be required. I cite 11 U.S.C. 502, B as in boy, 1, expressly provides that in this context of adjudicating a proof of claim, an objection to a proof of claim, All that is required is, quote, notice and a hearing. It really reads, if such objection to a claim is made, the court, after notice and a hearing, shall determine the amount of such claim in lawful currency of the United States as of the date of the filing of the petition, and shall allow such claim in such amount, here we go, except to the extent that such claim is unenforceable against the debtor and property of the debtor. So that's what you're alleging. Because they haven't done these things right, because of the separation, all these reasons, it's unenforceable.
Have you ever put all these cases and all these citations in a brief?
I'm looking at my briefs.
Is that available?
I just drafted about 3 yesterday.
Can I get that on Pacer?
Yes.
Can we
Do you
get
have
it?
a reference?
Go to the first parts of it are important only to get you into the Nevada court system. This is in the Anderson case. This is 2:10-BK, like Barbara Karen, -31903. It's the important part of it. The last part is just the judge. -L, B as in Barbara, R as in Robert. Yeah.
31903.
Excuse me?
31903.
That's it.
Nevada, you said Nevada?
Excuse me?
He's getting Nevada.
I'm sorry.
He's getting Nevada in this case?
Nevada, you said.
This is a trial, a bankruptcy court case filed right here in Nevada. 300 South Las Vegas Boulevard, right down the road. So, okay. Again, In re Wells, that was a case that they held without holding any evidentiary hearing. That when these things were present I'm talking about, or not present I'm talking about, they held without any adversarial hearing, any hearing at all, just at the argument on the objection, that you're done. It's unenforceable. It's disallowed. The court issued an order disallowing the claim, quote, in its entirety. So that it's possible. I think a judge, though, would be way out on a limb, and personally I wouldn't want to have that ruling after my client, because if no hearing was given, or he only tried to claim that the hearing was the oral argument at the hearing that you have to note for the objection, they'd probably reverse you. You'd probably be back doing the whole thing again. So the answer is the evidentiary hearing. Then you want to argue why they'll always argue their proof of claim is entitled to prima facie validity. A real iffy question right now gets to be this. Okay, they filed the original proof of claim. It always lacked the endorsement. And you wised them up, right? Show them the roadmap, what they got to do. Now they'll file an amended proof of claim with an endorsement on it. Now, do they get the prima facie validity benefit? I don't know. Do they get the benefit of that time frame? That, well, we're filing with attached to the amended proof of claim an endorsement. Clearly, that endorsement was endorsed by the time the proof of claim was filed, albeit an amended one. So we're arguing those issues in court. I'm just bringing your attention to the fact that they are issues. Here's another way in which these people lack standing, is if they don't properly assign the deed of trust. That, if you read Leyva and you read Pacius, yes. Yeah, I do. Leyva is 255, P as in Powell, 3rd, at least 1279 will get you there. Let me give you the exact one. 1275, it's Nevada 2011. Pacius is
Spell the suit as well, so I can't spell my own name.
Passillas.
Gonzalez.
Gonzalez. Wrong with everything. At least I can cite the right number. 255 P as in Paul, 3rd, 1281. That's Nevada, 2011. And then very, very interesting, to me anyway, is a case that the Supreme Court rules tell you you're not supposed to cite because it's not precedential. I'll cite it anyway, and I'll just preface it and say, well, not claiming that it's precedential or anything like that, the Faust case applied these two cases in a really good manner for debtors. And that is F-O-U-S-T. And since it's not published, it's going to be a Westlaw site. It's 2011 WL Westlaw 3298915.
That's in right?
That's Faust F. No, it's not. These cases are Nevada Supreme Court. These are not in re bankruptcy cases. But, as you learned in law school, under Erie versus Tonkin Railroad Company, the federal court applies the substantive law of the state in which it sits, and it applies the procedural law of the federal rules. So the procedural law, the substantive law of the state of Nevada is always very important because that's what they'll apply. Just quickly, and then I'll be done here, but I just wanted to see if there's any more good. Again, I'll bring up that matter about that. Here's a citation that in loan securitizations, the real party in interest is the trustee of the securitization trust, not the servicing agent. That's in Ray Rosenberg, R-O-S-E-N-B-E-R-G, 414, Bankruptcy Reporter, 826, bankruptcy case in Florida, 2009. So then you point out, you link that up with your securitization audit and found that the trustee is so-and-so. That's how they are also helpful. Moreover, again, this is important. Gonzalez points out that this is a case brought by a trustee, but here that defense lawyer shows up in a mediation for that trustee of that trust and says, no, arbitrator, mediator, we can't modify this loan because investor approval, the investors in this trust, their approval would be necessary. But when you got all that going on, no one can enforce this note because you can't pragmatically round up 250 guys. Furthermore, they probably like the tax advantages they're getting and they don't want to be bothered. No one likes litigation. A good day is one that you don't get called by a lawyer.
Question, isn't it true that there's all pooling and servicing agreements are all in violation of the REMIC laws and the IRS laws, and so they don't want to be exposed to the penalties?
That's exactly true. Yes.
Say that out loud.
These trusts, these securitized trusts, as Quentin and everybody can really tell you, they're set up that way for really good tax advantages. I mean, when we hear that the tax code itself is what, 72 pounds of paper or something, and all these thousands of pages, there's just all these loopholes created by lawyers are the problems in this world. Lawyers are in Congress, lawyers are in the White House, lawyers draft the tax laws, and these people don't want to be shown to have violated the terms of the pooling and servicing agreement and prospectuses that control these trusts, which they're doing right and left, because then they would lose their highly advantageous tax status.
Just a comment on that. There is a whistleblower statute. So if you have a little spare time on your hands, you go find a pooling and servicing agreement that has violated a REMIC status on a $1 billion trust. You blow the whistle to the IRS. I think the number is 20% is what you get. Whoa. Yeah. So if you got a little extra time on your hands, I mean, Lynn Smoniak got 18 million, but you know, that's peanuts compared to 20% of $1 billion, so that's if you got time on your hands.
Just one last point and then I'll be done. I'll take questions too, but also you should be aware that lately courts have been ruling that if you can prove any violation of the pooling and servicing agreement or the prospectus, say for example, a creditor walks into court and produces what really appears to be an original note. Maybe it's blue ink, maybe it's wet, maybe it smears when you touch your finger to it, whatever. Well then how did the trust get going? Must have had a copy, right? That'd be a violation of the terms of it right there. You're supposed to take the original. All the PSAs I've read always say you take the original note, you sign it in blank, don't endorse or don't pay it over to anybody else, turn it into bearer paper and put it in this trust. What if they did that? That'd be a violation of the trust rule. Courts are ruling though that you can't, as a third party, come in, because you're not a party to that contract, you can't come in and allege a violation of that or prove anything in your case regarding that. So,
just one other thing, the pooling and servicing agreement also requires that all the documents go to the custodian. So if the opposing counsel shows up with a document, ask him, well, where did you get that? Oh, do you have an authorization from the custodian to have that? Is there a delivery receipt? Do you have the FedEx number, the tracking number? Where did you get the copy of that note, sir? Because those notes are supposed to be with the custodian.
You mean the original, not the copy?
Yeah, the original, yeah. I mean, if they're coming in purporting this is original, well, you ask them where they got it. More often than not, they got it from LPS and a good version of Photoshop. I'm serious, yeah. I've got a whole other PowerPoint on that from Emily Will. But we're going to take just a minute here. Tiare has some additional evaluation forms. Yeah, she's going to pass those out now? Do you want to talk about it or just pass them out?
Just real quick, here's feedback forms for certified forensic loan auditors, and then also this DVD will be available for sale, and because you attended the class, you can pre-order it, but you have to purchase it today. You just have to fill this out and then pay cash, because unless you want to buy a book or something like that, because it's just a nominal fee, we're only charging you $40, which is just the cost to reproduce it. So we're going to sell them.
That's a steal.
We're going to sell them for $3.95, but you get them because you attended for $40, but you have to buy it today. So please fill out the feedback form, because like I said, it really helps us moving forward in our...
So a feedback form and an order form that she's passing out. And then, yes, sir, Ronald.
Do you have a CLE, is this CLE certified for California or just Nevada?
I researched this pretty heavily, and according to the California regulations, it says if a course is approved by Nevada and it is not given in California, then it counts for California credit. But you have to send in the paperwork, obviously. You can take the paperwork here for Nevada, send it into California, and according to their own rules, they approve Nevada-approved classes as long as they're not, if it's given in California, then California wants to approve it directly. But if it's given outside of California and it's approved, they have a list of states and Nevada is one of those approved states, then it counts. It'd be 6 hours credit.
Forms up front or where the forms? This is a CLE form?
Yeah, the CLE forms I'll pass out at the end of the... Okay. Right. Okay, I think we're going to move along a little bit here. I want to move to something that's... maybe I'll use this other microphone.
This is really kind of, we're moving now to the future a little bit. We've kind of covered the past, we've covered the current, and it's not, so now we want to look a little bit at the future. And some people might say I'm bright, but there's other articles in the tool shop that shine brighter than I do. And so I look to people like that. I'm talking about a lot of law professors and other practicing attorneys, Max Gardner, Adam Leviton, and others. And the real cutting edge of a lot of this really turns with whether the mortgage notes are meant to be negotiable instruments or whether they're meant to be non-negotiable instruments. And so this is an area of law that has an opportunity, and so you may want to use it, you may not want to use it, but I want to go ahead and share it with you, and I'll just try to go through it as we go. Now, UCC 3 controls the transfer of negotiable instruments. UCC Article 9 controls the transfer of non-negotiable instruments. And most courts, in my opinion, have wrongly assumed that all mortgages are negotiable instruments. So we don't want to swim upstream on this. You don't want to go into court and say, Your Honor, all mortgages are actually non-negotiable. You don't want to take that position because the courts have already ruled. In fact, even in two of the cases that Charles cited, the Levia case and the Bazales case, they kind of mentioned, oh, by the way, mortgages are negotiable. They don't say this is a finding of fact and we're pronouncing it. They just said, they said something like, since mortgages are negotiable instruments, and they went on to say something like that. So it's as recent as in the Nevada Supreme Court as last year. Question?
I think what you mean is that the notes are negotiable instruments, not the mortgage.
I'm sorry, when I say mortgage, I mean the note. Thank you very much. Yeah, that's the critical distinction there. And, but while you don't want to take the position that all notes are negotiable, you may, in your given case, say, well, Your Honor, while it's true that many mortgages are negotiable instruments, in my case, my client's note is not a negotiable instrument. And this may be an argument, it could be a great argument in the future, or it may be your argument of last resort if you don't have anything else that works, but I want to share it with you. And the point here is this is beginning to grow in acceptance among the leading legal scholars and minds in the country, which will, and it'll probably eventually start to happen in the courts as well. Now, Article 3104, the article that governs negotiable instruments, talks about to qualify as a negotiable instrument, it must be for a fixed amount of money. In other words, a $5 bill is a negotiable instrument. It's $5. You write a check paid to the order of cash for $10, it's $10. It's a fixed amount of money. And when you read your mortgage, well, before I go to the note, let me finish with this. So it says, except as provided in subsection C and D, negotiable instrument means an unconditional promise to pay, a fixed amount of money. And see, a $5 bill, it doesn't say on it you can only spend this on Thursdays and Saturdays. A $5 bill you can spend every day. Now, if somebody wrote a check to you and your name was George, it says pay to the order of George on Tuesdays if he's wearing a brown suit and is his wife with him dressed in pink. That would be a non-negotiable instrument because it has conditions on it, that check does. So George couldn't endorse that check over to Joe and have Joe cash it because it has the conditions that could not be met by Joe. So a negotiable instrument has to be a fixed amount of money that's an unconditional payment. Payable to the bearer at the time it's issued or first comes into possession of a holder, payable on demand at a definite time, does not state any other undertaking or instruction by the person promising. See, that's George in the brown suit with his girlfriend or wife wearing pink. Yes, sir. It may not be. This is pretty recent. I have to stop. I have to go back and look at the book to see. It may not be in the book, but anyway, it'll certainly be in the supplement, and it'll certainly be in the DVD that we're talking about right now. So those are the main parts of this 3104. It has to be a fixed amount of money, and it has to be an unconditional promise to pay. You can't have any conditions attached to it. Now, Article 3106 talks about this unconditional promise, except as provided. Unconditional states express condition to payment that the promise is subject or governed by another record. In other words, you cannot have another document that controls how the note is to be paid. And you probably know where I'm headed with this. So the note itself, the $5 bill doesn't say, go around the corner and find a contract written in your favor. No, the $5 bill or a check written to you is self-contained. So, let me go back. It says, a reference to another record does not of itself make the promise or order conditional. Now, see, it's okay to refer to another document. That's okay if it mentions another document, but if you have to go to that document outside the four corners of the note, if you have to go to it to understand it, and that's the distinction. A reference to it is fine, but when you have to go to it and read it, and when there are provisions in the second document that control the first document, that's when you've gone too far. It's not just a reference. Now, there are conditions in most mortgages. Number one, you can't prepay that unless you give written notice. And David Epstein, real estate professor, law professor, he says that alone is enough of a condition to make the note conditional. Just the fact that you have to give written notice before you can prepay it. The mortgage note requires you to go to a second document, that being the deed of trust, to find out what other conditions control. And the deed of trust is full of conditions. Many of those conditions actually change the amount of money that's owed, so it's no longer a fixed sum. Attorney's fees, broker's opinions, forced place insurance, etc., etc., etc. There are many things in a deed of trust that change the note, so it's no longer a fixed amount of money. And there are many conditions in the deed of trust that have to be met. So an actual mortgage note many times is not a fixed amount of money, and it's not unconditional. Now, if you choose to argue this, don't go, I already said it, but I'll say it again, don't go before the judge and say, well, Your Honor, all these mortgages are non-negotiable. You'll never get that. But if you say to him, Your Honor, while it's true that many mortgages are negotiable instruments, however, in the case of my client, I believe that his note is a non-negotiable instrument. And I'd like to point out the reasons why. So you just narrow it down to your client's mortgage, and you talk about the things that, but I'm going to give you standard note and standard deed of trust language, so 99% of the time it's going to apply to your client's situation. So one can argue that the note is not a negotiable instrument as defined in the UCC. The UCC is your authority. So right here is the borrower's, I have the right to make payments of principal at any time, a payment of principal only, known as a prepayment. When I make prepayment, I will tell the note holder in writing I am doing so. That's a condition. That's right out of a standard note. I have to give notice of writing. This talks about the deed of trust, refers to it. Uniform instrument, limited variations. In addition to the protections given to the note holder under this note, a mortgage or deed of trust or security deed dated the same date protects the note holder from possible losses if I do not keep these promises. The security instrument describes how and under what conditions I may be required to make immediate payment in full, not just of the note, but of all amounts I owe. And then there's a list of some of these conditions here.
Where does this come from?
This is a standard Fannie Mae Freddie Mac note.
Okay.
So 90% of your notes are going to be in this format. But I just think it's why you don't want to argue that all notes are non-negotiable, but you can take your client's note and if you start with the UCC and the conditions of the UCC, which are accepted in all 50 states, and then you just highlight how your client's note does not fulfill the requirements of a negotiable instrument, you may be able to use this. Some of the deed of trust conditions are prepayment charges, late charges that are due, plus interest, community association dues, fees, assessments, all dues, fees, assessments, and other charges that are imposed on the borrower of the property by a condominium association. And then the escrow requirements, any compensation, settlement, award of damages, proceeds, third party, damage to the property, condemnation, taking, conveyance, mortgage insurance, or whatever. There's so many things in the deed of trust that can change the amount that's owed. That's the point. Prepayment charges, late charges, application of proceeds. Maybe I don't need to I think you've got my point. And you can take any standard Fannie Mae or Freddie Mac note, and then the deed of trust after about the year, I think 1997 or whatever, or 2000, there were some revisions in there, but they're all standard. You'll see it in all of them. Lender may require borrower to pay a one-time charge for a real estate tax verification. Here you see, this is a Texas single-family Fannie Mae Freddie Mac uniform instrument. That's the one we're quoting from right here. Negotiable instruments are transferred by endorsement, as Charles Powell told us, just like a check, you endorse it over. Non-negotiable instruments are transferred by assignment and by a purchase and sale contract. So a non-negotiable instrument, it's not only an assignment, you're supposed to have a contract, a purchase and sale contract. And in fact, 99% of all your pooling and servicing agreements require that they be purchase and sale agreements, signed and delivered. From A to B, B to C, C to D, D to E. So there should be a whole stack of these purchase and sale agreements, and none of them are there. And so in the mortgage securitization business, they set that business up to deal with everything as a non-negotiable instrument. The only reason they had an endorsement of the note in there was because of they wanted to have additional security, number one, and number two, if because the notes were endorsed in blank, and then they were supposed to be delivered to New York, and if the borrower missed his first payment, sometimes people buy a house and they just don't make the first payment. So if that note goes into default, that mortgage-backed securities trust cannot accept a default that would lose their REMIC status. So they had it endorsed in blank so they could turn and endorse it back to the originator that sent it to them. You understand? So rather than accept it, they could immediately send it right back.
So what do you mean endorsed in blank? Not endorsed?
It says pay to the order other than it's in blank. And it's almost like pay to the order cash, and it becomes bearer paper. But they also have the requirements in the pooling and servicing agreement that the purchase and sale agreements and assignments are supposed to be from A to B to C to D. And then you have to understand the reason that they had so many parties, A to B to C to D to E, was because these mortgage-backed securities trust pools wanted to take qualified funds, retirement funds. And so to have qualified funds come into it, this pool has to be bankruptcy remote. So if the originator went bankrupt, they couldn't come and claim and seize the notes out of the trust. And so if you had it from A to B to C to D, it made it bankruptcy remote, so they could take qualified funds, even though these were really junk bonds, but they could be rated AAA because, you know, if the C paper defaults, well, we're going to pay the A paper first, and we're going to over-collateralize it, and we're going to insure all these notes, and we're going to sell derivatives and credit default swaps and credit enhancement, so we get the, so yes sir, it's AAA paper. That's when you put all that in the blender, you come out with AAA paper, and meanwhile you got some guy, you know, who's got a 500 credit score who just moves into a $500,000 house, and he's, you know, he's landscaping or who knows what, I don't know, you know. So that was the whole, that was the way that's why they had so much money. They pushed the money to the originators who pushed it to the borrowers, because if they could just get the borrower to sign the paper, they could take that paper and sell it for 3 times what the paper's face value was. So much money was being made. If you haven't read Michael Lewis's book, Big Short, you need to read it. Howie Hubler was in charge of derivatives for Merrill Lynch.
Big Short?
Big Short.
Who's the other?
Michael Lewis. Came out about a year and a half, 2 years ago. Howie Hubler was in charge of selling the derivatives for Merrill Lynch. In one day, Howie Hubler lost $9 billion. But he personally was compensated for that performance, $25 million. So that explains to you exactly how upside down this whole business was. And the bottom line of Michael Short's book is, he says, if you incentivize, because in writing his book, he was, you know, when, you know, 500 credit score people were being given loans, you know, at a teaser rate of 1%. So for the first 2 years, your mortgage payment is $1,500, and 2 years later, it's going to double to $3,000 from $1,500 a month to $3,000 a month. And you would, and so Michael Lewis raises the point. Couldn't somebody just kind of see that this wasn't going to work? Did somebody want to blow the whistle or say something? And he says the people in New York were making so much money that their focus was on not on why Mr. and Mrs. Smith were going to have a difficulty, but it was, why is the guy in the workstation next to me getting a $500,000 larger bonus than I am? So it just they incentivized the wrong behavior. Michael Lewis himself used to work at Solomon Brothers in the 1980s. One year he got a $200,000 bonus, and to this day he doesn't know why he got the bonus. So he talks about that in the book. So most pooling and servicing agreements call for the notes to be transferred by purchase and sale agreements, and that's when you read the PSA, you know, they may have an endorsed note, whether it's fake or forged or whatever. Go back to the PSA, and Charles will argue that we're not third-party beneficiaries to the PSA, but if that's who funded your loan and that's how you bought your house, yeah, there's different. I mean, I know Adam Levitin has a different opinion on that, and I'm not here to decide it one way or the other. But the point of it is, it all comes back to evidence. If they're supposed to have pooling and purchase and sale agreements and they don't, then there's a gap in the chain of title. So it's not just about endorsement of the note, it's about an assignment and a purchase and sale agreement in every transfer, and that assignment is supposed to be recorded in the county where the property is located. Endorsement in blank was set up as a means to return the note. Some of this I've covered. Most pooling and service agreements were never executed and are not available. That's not pooling and service, that's purchase and sale agreements. If the note is a non-negotiable instrument, there was no recorded assignment and no purchase and sale agreement, then none of the transfers actually occurred. You probably know about Linda DiMartini, who was in charge of documents for Countrywide for 11 years, and she was deposed in the case of N. Ray Kemp that Charles made reference to. N. Ray Kemp is a bankruptcy case. She was deposed there, and Countrywide endorsed all of these notes in blank. Well, the UCC says that if a note is endorsed in blank, it has to be physically delivered for the transfer to take place. And if it's not physically delivered, it's a fraudulent transfer. Well, Linda DiMartini testified under oath that Countrywide never sent any paperwork to New York. Angelo, who was the CEO of Countrywide, anything that he serviced, he kept in a warehouse in Simi Valley, California. He didn't send any paperwork up there. So 90% of Countrywide loans are fraudulent because they were endorsed in blank but never delivered. They're in Costa Mesa or Simi Valley, one or the other. Now, a lot of this is from Kathleen Cully and Max Gardner. Loans of trust via contract law. That's the pooling and servicing agreement. Level 2, note to trust via both UCC 9 and contract law and endorsement and delivery. So they wanted to make these mortgage-backed securities trust airtight. So they had the requirements of Article 9 and the requirements of Article 3. And parties can agree. The UCC says that by separate agreement of the parties, they can agree to add extra things to their business model. Level 3 is the security of the trust, Article 9 and the note, assignment, delivery. This just talks about security interest and sales of notes under Article 9, negotiable instruments, Article 3. A lot of this this is kind of just repeating some of the things that we've already covered here. I'm going to go through this pretty quickly. It's 10 to 5. That's the whole point. When these notes are transferred, there's supposed to be a full payment in every transfer. A to B, B pays A, B gets it from A, B sells it to C, C pays B. And so it's supposed to be full purchase price paid to each entity in the chain. Well, Wall Street was mainly working off Excel spreadsheets. You know, as I mentioned this morning, Kathleen Porter did a study and 40% of the mortgage notes were actually shredded. And I think she did a study of 2,000 mortgage notes, and 40% of them were, she was at, I think, the University of Iowa, now she's at Harvard as a law professor. And so, again, securitization, if it's done properly, is okay, but these guys set up their own rules, and then they didn't follow their rules. They were just making so much money so quick. You know, it's same old story, greed. And talks about the role of the servicer, talks about the role of the trustee. And one thing to remember that, you know, as Quentin showed in one of the Bloomberg screenshots, there was a mortgage in default, but it was still listed in one of the tranches as an active asset. And so many times the investors have never missed receiving a payment. Somebody may not have paid their mortgage in 2 years, but the investors who put that money into the mortgage pool, who gave it to the originator, who gave it to the borrower, these investors have been paid every month, right on clockwork. So there may not have been a default from the investor standpoint. Yes, sir?
We've had a case where we did a Bloomberg report on, and one guy refinanced like 2-3 years ago, in 2009, and it's still being traded. You can still see his loan, his old loan that was supposed to be refinanced and paid for.
Yeah.
It's still there. Being traded, Wall Street, you can buy it.
Interesting, yeah. It's a little bit like a masquerade party. We've got a clothes rack over here. And we have a trustee's costume, we have a beneficiary's costume, we have a borrower's costume, we have a lender's costume, we have a mortgage-backed securities trust costume, we have a custodian costume. So you just pick out any costume you want. We're going to have a masquerade party, and you may look like a beneficiary, but we don't know really who you are. You may look like a lender, but we don't know if you're a lender or not. You didn't loan any money, and so it's really like a masquerade ball. Delivery requirements are very important, although they're not required to transfer title, except in a mortgage note. If it's endorsed in blank, then delivery is required.
Wait.
Will you go back?
Please, I mean, are we supposed to read this and take notes or what?
No, I'm just picking out highlights here because we're almost done.
Are we going to get these notes then? I mean, there's no way I can read and take notes on.
Well, no, I'm choosing not to present everything that's on the screen, if that's okay. I'm trying to pick out the high. I mean, we'll be here till 7 o'clock if I go through all of this.
Well, I guess my point is that, like, this is the specific things I think we need to know for our briefs and for dealing with these as attorneys. And, I mean, the whole morning was spent on introductory, general. And now we're getting, 5 seconds on all of the UCC information in the cases that we really need, which is the meat of the stuff. So either we get the, I don't know, maybe it's
all
just
on the videotape.
Yeah, it'll all be on the video, that's true. I may go back and look at this, we may come back to do more of this. Most of this we've already covered. This is just being a restatement. We talked about Article 9, supersedes this is the level of authority of the UCC. It supersedes the law of states where the mortgage doesn't follow the note. That's a minority opinion. Agrees with the law of the states where the mortgage follows the note. The need for the assignment and the transfer on the Article 9. Mayor's attempts to implement the mortgage following the note in all states. It depends on the state law and the good procedures. A little bit more about MERS. Being a nominee, they're not a real party in interest. They lack standing to foreclose in its own name. MERS can only foreclose as a nominee for a named owner, but this is a little bit dated because there have just been cases that have shown that they really don't have a beneficial interest, so they don't have the authority to do anything. Now, all of the mortgage-backed securities, most of those pools, those trusts, are under New York law, New York trust law. And New York trust law says because you're managing assets for the benefit of somebody else, you have to obey the laws very strictly. And so, again, there's a remaining question of whether or not anybody as a third-party beneficiary has any right, but it's worth knowing in many cases that they did not follow their own rules and regulations according to New York trust law. The one case was in Alabama. Nick Wooten is an attorney in Alabama. I'm not remembering the name of that case. Do you remember the name of that case, Charles, the Wooten case? And he argued that they didn't follow New York trust law, and he actually won. I will see if I can get that citation for you. Just because you hold a note is not enough. You also have to have the right to hold the note, which you may not be aware of that, but just holding the note is not sufficient. You also, according to you have to have the documents that say you also have the right to hold the note along with actually holding it.
There would be a chain of title or?
Yeah. I mean, like an A to D transfer, for example. You know, even though you hold it, if you got it from A and you didn't, it was supposed to go from A to B to C, and then you're D, so you wouldn't have the right to hold that.
Question: has anybody used these challenges about like where did they come in with the note, and it was supposed to be with the custodian? Has anybody argued that?
Possibly. I think the Wooten case did. The biggest thing that you're probably going to run into is that they really do create documents with Photoshop. I've seen it done.
Yeah.
And they have auto signers and things like that. So if they do come with a perfected set of documents, don't accept it at face value, even if it's blue ink, but you need to bring in a forensic expert and look at the age of the paper and the age of the ink. Because what they'll do is they'll bring in something that's supposedly signed in 2006, and the right kind of forensic expert can show that the ink is 2 weeks old and the paper's 1 month old.
Right, but the other question is like about if it's supposed to, the note was supposed to be with the custodian.
Right.
So forcing them to prove how they were able to bring it in court.
Exactly, and that's what Max Gardner talks about. He says you need to see. A lot of people, they say, well, here's the note. A lot of people, without thinking about it, say, okay, they got the note. No, you need to ask them, where did you get the note? And they have to tell you where they got the note. And the only person that's supposed to have the note is the custodian. And if they didn't get it from the custodian, then it's prima facie fraud, frankly. Of course, the pooling and servicing agreement says all mortgage documents are to go to the custodian. And if he says, well, I got it from the custodian. And it's like Charles said, you don't take $1 million piece of paper and not have a date on it. Well, a custodian doesn't give an original note. Oh, here, take this note for $500,000 and, you know, I'll just send it to you in regular U.S. mail. No, it's going to be secured mail, FedEx or UPS or something, and it's going to have a tracking number. So these are things to ask for in discovery. Where did you get this note? Got it from the custodian. Okay, do you have a receipt? Do you have something to show that you got it from the custodian? And I'm sorry, but these people will lie through their teeth. They'll say anything. You know, I mean, I was in one seminar. It was actually put on by CFLA down in San Diego, and we had a local Las Vegas lawyer who has 13 offices here in the Southwest. and they get about $800 per foreclosure. And then the longer it takes them to get it done, the less they get. So they're not being paid a lot of money to do these foreclosures, the law firms. And LPS has what's called stopwatch justice. And when they send a file out to one of these law firms, and you have to understand these law firms gear up the foreclosure mills. You know, they'll have a lot of office space leased, they'll have a lot of employees, so they have to keep that pipeline flowing, but LPS will grade them. They have to have the foreclosure filed within 3 days. I forget exactly the numbers. I think it was 3 and then 30 and then 60 or something. But they have to have the case filed, they have to have it heard, and they have to kind of have the property within 60 days. And they have a red, yellow, and green. And so if they're performing well, they stay in the green zone. If they start having problems, they move into the yellow. And then if they're really having problems, they move into the red, and then they're cut off the LPS system, lender process servicing. And lender process servicing actually hires most of the law firms, and there's a big question about splitting law fees, because these lawyers actually get the cases and they split their fees with LPS. And so, but the point of it being, if a law firm loses its status with LPS, all of a sudden they no longer, the pipeline's not flowing. He's got 100 employees and he's got 10,000 square feet of office space leased for 5 years. So that's the little quick version of what they call stopwatch justice. This again just talks about endorsements and assignment, what we're looking for. If it's not available from the docket custodian, loan owner can obtain a judgment under the note as unsecured. And that's what you can do. If they can't show that the custodian has the note, then it's unsecured.
How do you do that?
You just have to compel discovery.
Obtain a judgment under a note alone.
Well, if they cannot show the custodian has the note, then you could ask the court to issue an order that it's unsecured, because the people that said they own the note don't have it.
Could you also file a corollary motion to quiet title?
That's where you want to end up. I mean, quiet title is kind of home plate. Once you've made the other, once you cross home plate, score 1 for the borrower and the homeowner.
So is it the obtaining a judgment under note? Is this in bankruptcy or is this in a money?
This is talking civil court right here.
So you're suing for money damages for what?
What was the question about money damages?
What would be your cause of action to be able to get a money judgment for them not having the note? I'm just trying to think, how do you get to, what cause of action would you use to get to getting a judgment?
You could use a declaratory judgment, file a complaint asking the court to make a declaratory judgment that these entities have no economic interest in this property.
Upon your notice of default, so you have an actual case of controversy, and then you file a declaratory judgment before they start the foreclosure.
Then you can.
I've seen a lot of motions to dismiss where they say that, first of all, they file the non-monetary status, the servicers hire the trustees, and the trustees put in a non-monetary status affidavit saying, we don't care, we're just, non-monetary involved.
The trustee of the mortgage pool or the foreclosing trustee?
Foreclosing trustee. So they do a non-monetary status affidavit, so you can't sue them personally for damages.
Yeah.
And then they do motions to dismiss on declaratory relief, saying that's not a cause of action.
Oh yeah, that's their standard template, and it's going to vary a lot from jurisdiction to jurisdiction. But frankly, that's why we moved to the bankruptcy court, because there was just such a bias. There was kind of an unwillingness. The judges never studied this in law school. They didn't understand it. They were, it's my opinion, they were being kind of influenced on behalf of the lenders, and so it was just, it was like trying to break through a stone wall. But it's been a much more refreshing experience in the bankruptcy courts. I really recommend the materials on quiet title, the book and the DVD out here, because covers a lot of this, and that's where we eventually want to go. And it's important to network with other attorneys, maybe who have done some of this work. So just a quick review here today. We've looked at the current state of the mortgage mess, several states including Nevada. We've examined some of the causes of action. We discussed some of the challenges to civil court. Talked about why bankruptcy is the best forum. We discussed the practical requirements for 7, 13, 11. We taught how to defeat a motion to lift stay. Charles Powell covered that in a great manner. We spoke about where to find and use this evidence through the securitization, audit, and affidavits of experts. We discussed the evidentiary hearings, the adversarial proceedings. We looked at Article 3 and Article 9. Just mentioned quiet title. This course doesn't really cover quiet title, but the other courses and books do. And so we're going to have a drawing for 2 more free books and 1 free DVD. And I'll autograph any books if you want me to. The DVDs will be mailed out. When will the DVDs of this class be available, Tiara?
It takes about 2 weeks.
2 weeks? Okay, so maybe within, say, 3 weeks you should have it, something like that.
If you pre-order it today.
Right. And to me, that's for $40. That's 10% of what it would be otherwise. And if you want me to come and speak, or any of us here, either to attorneys or to put on an educational seminar for you that is open to the public, as a way of, we're not going to sign up clients there, but we can come and do an educational seminar, and then, we'll say, if you, the public, have further interest in what we talked about, see this, you need to find a law firm, and here's the law firm that's sponsoring this event. Make an appointment and go talk to them. So that's a possibility also. Plus, coaching relationships are available. You guys have been a great class, paid attention, had great questions. That's my contact information there. The CLE certificates, I guess I'll just come around with those. I mentioned how the California approval works. So that's pretty much it. And we want to thank Andrew Lehman, the president of CFLA, and we want to thank Quentin and Tiara Lewis and their staff for providing this opportunity. And I encourage you to take advantage of their other events, products, educational services. And we need to really move together as a united army to restore justice to our nation, one family home at a time. So there's a great opportunity. There's at least 11 million homes underwater. There's probably 2 million foreclosures per year. So if your plate's not completely full and you're willing to serve people with a passion, you can have as much business here as you want. If you have any clients or contacts in Las Vegas that may need help, you can contact Aaron Gupta or myself or Charles Powell. We'll be happy to talk with them, and vice versa with all the networking. We can send people. And I know Sophia Monterosa, hold your hand up, Sophia, again. She spoke this morning. Sophia is looking for a bankruptcy attorney in the San Diego area. It does not have to be someone who's experienced in all the adversarial hearings. She just needs a basic bankruptcy attorney at this point. She was working with somebody who had a personal challenge. It had nothing to do with her. He had to withdraw from the case right as she was filing, and so she's in as a pro se. But the trustee, he's a good gentleman. He worked with her. He says you really need to get an attorney. So step number 1 is she needs a bankruptcy attorney, and then step number 2, she'll need somebody to help her. She's got a great case with Wells Fargo, by the way. And so anyway, if you are in that area, or if you know anybody in the San Diego area that you might refer to Sophia, well, that would be fantastic. So that's pretty much it. I'll come around with the CLE, and then I know, Tiara, are you going to collect the evaluations and those things?
I'm going to be right outside.
Okay.
We have other DVDs
Right. Is there anything else we need to cover from your standpoint?
No, I'll be right outside.
Okay, did you guys have a good day today?
Yeah.
Did you learn some things?
Yeah.
Okay, thanks very much.
You having the drawing? Drawing?
Oh, I'm sorry, the drawing. Thank you, absolutely.
The digital age has closed the gap between information and its accessibility. And it turns out that filing for bankruptcy doesn't have to be as difficult and expensive as it used to be. Introducing Fraud Stoppers, Private Members Association. As a private members association, Fraud Stoppers has helped countless American homeowners achieve financial freedom and the legal remedy they deserve. Fraud Stoppers specializes in cutting-edge foreclosure defense. We offer homeowners state-of-the-art countermeasures to foreclosure with turnkey lawsuit and evidence packages designed to help you get clear and marketable title to your real estate. Fraud Stoppers Private Members Association provides you access to a collection of legal documents and resources that can help you stop a foreclosure sale or eviction, sue your lender for mortgage or foreclosure fraud, get a loan modification, file for bankruptcy, and even fix your credit. By completing the form on our website, you'll get instant access to free bankruptcy documents and other legal documents and information that can help you save time and money filing for bankruptcy without an attorney. So take action right now and get the help you need to save your piece of the American dream. Go to fraudstoppers.org/free bankruptcy documents right now. You'll be glad you did. Cheers.